I declare open this hearing of the Parliamentary Joint Committee on Corporations and Financial Services into the Oversight of ASIC, the Takeovers Panel and Corporations legislation. I begin today by acknowledging the Ngunnawal and Ngambri people, the traditional custodians of the land on which we meet, and I pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video conference. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via video conference to mute their microphones when they are not speaking. I now welcome representatives from Chartered Accountants Australia and New Zealand. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. Just before we go to the statement of your names, can I invite my colleagues to introduce themselves? I will give technical apologies because of flight delays for Mr Moncrief and Mr Sharma, who will join us in person as soon as possible. And can I throw to those who are joining us online first? We'll start with Senator Scarr, if we can.
Senator Paul Scarr, Senator from Queensland.
Ms Jarrett.
Jarrett, member for Brisbane.
And Senator Pocock.
Senator Barbara Pocock, Senator Green, Senator for South Australia.
Thank you. For the Hansard record, would you please state your full...
Sorry, Chair.
Oh, sorry, Miss Lawrence, of course.
No worries. Thank you. Antonia Lawrence from Western Australia, member for Hasler.
Thank you. For the Hansard record, now to you, Cans, will you please state your full names and the capacities in which you appear today?
So, Ainsley Van Altelen, CEO of Chartered Accountants Australia and New Zealand.
Vanessa Chapman, the Group Executive General Counsel and Corporate Assurance for Chartered Accountants Australia and New Zealand.
Damien Ogden, Group Executive Advocacy, Public and Government Affairs.
Geraldine McGarry, Group Executive Policy and International.
Thank you. And can I thank you for your cooperation with the Secretariat in providing documents in the form requested by the committee for us to undertake our work, which arises out of the recommendation of the F&PA committee and our statutory obligations and the breadth of that mandate with regard to corporations. Over to you, I'm assuming Ms Van Altelen.
Yes, thank you, Chair.
Mrs Van Altelen, sorry.
Thank you, and thank you for the committee for the opportunity to appear today. As I said, my name is Ainsley Van Altelen. I'm the CEO of Chartered Accountants ANZ. I'm also the Chair of Chartered Accountants Worldwide, a board member of the Global Accounting Alliance, a technical advisor to the International Federation of Accountants as CANZ's representative, a Commissioner of the Legal Aid Commission of New South Wales, and I'm a member of the Chartered Institute for Securities and Investment. I'm joined by Vanessa Chapman, our General Counsel and Group Executive for Corporate Assurance, who is responsible for professional standards with oversight of our disciplinary function, and also CANZ's Professional Standards Scheme. Damien Ogden, our Group Executive for Advocacy, Public and Government Affairs, and Geraldine McGarry, our Group Executive of Policy and International, who's also a Fellow of Chartered Accountants ANZ. I would like to cover the following items, particularly for the newer members of the committee. First, a brief background into who CANZ is and what we do. Second, our observations on the benefits and parameters of professional standards schemes. Third, the role of affiliates in our membership base. Fourth, an overview of our conduct and disciplinary system. And finally, the steps CANZ has taken to strengthen the profession in recent years. Chartered Accountants ANZ is a private, not-for-profit membership body created by Royal Charter, representing over 140,000 finance professionals across Australia, New Zealand and globally. Our reason for being is straightforward but significant: to safeguard the technical competence and ethical standards of the profession in the public interest. We are an educator, a standard setter, a member services organisation, a co-regulator within a broader regulatory framework. While we do not have statutory powers, we operate under our bylaws and have a substantial conduct and disciplinary framework. Today we've been invited to discuss the oversight of the professional standards regime which CANZ belongs to. The fundamental aim of professional standards legislation is consumer protection. Those are not just my words, they come directly from an independent academic report entitled Benefits of Professional Standards Schemes, authored by Drs Cooper and Breakey and Professor Charles Samford of Griffith University. Professional standard laws were introduced following the insurance crises of the 1990s and early 2000s, when professional indemnity insurance became unaffordable and in some cases unavailable. These laws assure consumers that professionals who belong to associations like ours meet high standards and are subject to strong protections. Chartered Accountant ANZ's Professional Standards Scheme commenced in 1997. It is one of 18 approved schemes across professions such as law, valuation and building surveying. Our scheme applies to around 30,000 of our 140,000 members who work in public practice in Australia. It includes two liability caps, 75 million and 20 million, depending on the services provided. These caps are set through careful analysis of claims data and independent actuarial advice to ensure consumers remain appropriately protected. Our current scheme runs until 2030, subject to annual reporting to the Professional Standards Councils. This reporting is captured in our annual Professional Standards Report. The 2024 report has been provided to this committee. The 2025 report for calendar year 25 is due to the PSC on 31 March 2026, once it is approved and signed off by our board. We can provide a copy to the committee once submitted. In the meantime, we have provided a draft copy of the 2025 highlights and continuous improvement initiatives. Importantly, our professional standards framework also aligns with the requirements of the International Federation of Accountants, which has assessed our approach as meeting its highest level of compliance. Which leads me to my third point. Some members of the committee have expressed interest in our affiliate members. These are non-CA principals or partners in chartered accounting firms with signing authority. To be eligible to be an affiliate, they must meet defined education and experience requirements, such as holding a degree. They must have completed both our affiliates and public practice programs and comply and adhere to the CANZ Code of Ethics. Less than 2% of our 140,000 members are affiliates. But including them in our scheme means more professionals can be held to higher standards, extending protection to more consumers. I'd now like to briefly turn to my fourth point, which is an overview of our conduct and disciplinary system. Complaints are handled by an independent professional conduct committee and, where required, referred to a disciplinary tribunal and/or an appeals tribunal. These bodies are made of senior professionals, including accountants, lawyers and ethicists. The tribunal has the power to impose fines of up to $50,000 for individuals and $250,000 for practice entities, in addition to suspension or expulsion from membership. Between December 2024, being the time since we last provided data to the committee, and December 2025, the Professional Conduct Committee received 707 complaints and resolved 710 matters. More than 2/3 of those matters rose from self-reporting and proactive monitoring by CANZ, including in large firms, reflecting our active and interventionist approach to regulation. Over 2024 and 2025, we implemented a major reform program under our Going Further roadmap to modernise our regulatory framework and strengthen accountability even more. Our members voted to change our bylaws, expanding our disciplinary powers, increasing fines, and the ability to investigate former members. We refocused our disciplinary system to prioritise serious misconduct and resolve high-risk matters, and streamlined our complaint handling to be more proportionate and effective. Ethical standards were lifted across the membership by embedding the Chartered Accountants' commitment into annual renewal and increasing mandatory ethics CPD. We strengthened quality assurance by expanding risk-based quality reviews, particularly for large firms, with a focus on emerging areas such as AI, and we moved from self-attestation to active verification using data and automation to identify risk and drive enforcement action where it matters most. Our strengthened framework is having an impact, but like every profession, there will always be those who fall short. When that happens, we have a robust system in place to respond firmly and fairly in the interests of the public and the profession. In closing, I want to acknowledge the large majority of our members who work diligently, ethically and professionally every day. They expect strong standards, credible enforcement and public confidence in their profession, and so do we. My colleagues and I welcome the committee's questions. Thank you.
Thank you very much, Mrs Van Olsen. And can I also provide the opportunity for my colleague in the room to just put on the record?
Scotty Buchholz from Queensland.
Thank you very much. So I propose to ask a series of questions at the beginning and then to rotate the call. Initially in 15-minute blocks. There's quite a degree of interest in evidence from you this morning. I acknowledge members from ASIC, including Commissioner O'Rourke in the room, who is listening to this. One of the committee's concern was regulatory gaps and knowledge gaps across the sector. So part of fleshing out in our second hearing with you is the landscape there. So we appreciate ASIC being here to hear the evidence this morning. Given that level of interest, I just might indicate we may need you a little longer than is indicated. I hope that you'll be able to accommodate that. And they're nodding very, very nicely. Thank you very much. I think that means yes. We appreciate that as well. So thank you for your opening statement. If it's possible for someone to provide that to the Secretariat, I'm sure some of the colleagues would appreciate being able to visibly interrogate it. Yep.
I believe
so,
you emailed it.
Wonderful, thank you. So we might get copies here in the room and distributed to members of the committee. Thank you. I'm going to go to a particular matter just to flesh out the shape of some of the challenges that I think that remain. Could you please just clarify your rules for investigating members or former members, given you changed your bylaws after the Peter John Collins fiasco?
So I am having a little bit of difficulty hearing you.
Yep, we might get the volume up then in the room if we can. Let's try now. Is that better?
Yes, it is. Thank you.
Great. So could you please clarify your rules for investigating members or former members, given that you changed your bylaws after the Peter John Collins fiasco? Perhaps this might be a Ms Chapman question, is it?
I'm very happy to take that question. Thank you, Senator. Yes, you're right. The bylaws were amended as a result of our professional conduct framework review to establish a former member jurisdiction. Those rules are operative now, and we currently have 13 concluded former member matters and 5 which are currently on foot, so a total of 18 former member matters which have been taken in Australia since those rules were introduced.
Okay, thank you. That's quite helpful. Now, what circumstances must exist for a person to be investigated?
As a former member?
Yes.
So the circumstances are the same regardless of whether a member is a current member or a former member. The intention with the former member jurisdiction is to consider misconduct or conduct that is of such egregiousness that the member might have faced suspension or termination had they remained in membership. The processes for assessing those matters are the same regardless of whether the member is a former or current member.
So this is to prevent what I might call the old-fashioned gentleman's agreement. If you retire, resign and walk away, there'll be no black mark against you as you leave the profession, which I understand was the long-standing practice.
Precise. Well, whether that was practice, but certainly a possibility.
Yeah. In New Zealand, Chair, we've always had the ability to investigate former members, and the benefit of the Professional Conduct Framework Review we did in 2021-2022, which had the independent oversight of Dennis Cowdery KC, was it identified that opportunity for us to ensure consistency between the jurisdictions, and so therefore we asked our members to vote for and had an overwhelmingly supportive vote in favour of not only that change but also increasing fines and other process improvements to our conduct and disciplinary frameworks.
Thank you. So it's correct that they could cease being a member, but any transgression that took place while they were a member could still be pursued by you.
Correct.
And that continues to be your practice now.
Correct.
Are you aware of the case of Mr Ryan O'Shea?
Yes, we are.
In the ASIC media release 24 October 2025, we find out Mr Ryan O'Shea had his registration as a company auditor cancelled for failing to carry out his duties properly by the CADB. CADB also found him not to be a fit or proper person to remain a company auditor. Would you agree this seems to be a serious adverse finding against him in the auditing profession?
Yes, and indeed the CADB decisions over the last 5 years would indicate the cancellation of registrations of a number of registered company auditors, and where those auditors are members of chartered accountants, there have been disciplinary decisions made. It generally is the case that there's a time lag between the CADB finding and the decision being made through the chartered accountants disciplinary process because it's not an automatic or ipso facto outcome. There has to be an investigation and an assessment.
Right. So do you know whether Mr O'Shea was a member of CANS at the time this action was taken against him?
I'm not aware. I believe he was or is. That decision, October 2025, I would just note that normally our observation is that where the decision, for example, in the case of other registered company auditors, there's generally about 6 months between the CADB decision and the disciplinary tribunal decisions at the chartered accountants level.
Okay, so
Chair, one of the benefits of the Professional Conduct Framework Review was and our Going Further roadmap is improved information sharing within our co-regulatory space. So obviously there's other regulators, TPB, ASIC, as well as us as a private membership body. And so that has improved over the last few years, which is pleasing to see.
thank you. Could I just clarify, that's all helpful information. For my understanding, Mr O'Shea was a member of CANS or is currently a member of CANS. What is his status?
I would have to take that on notice just to check. He was certainly a member of chartered accountants at the time of the CADB decision, October 2025.
Right, so he's definitely been one of yours?
Correct.
Correct. Okay, well, we want to just clarify that. That's good. Now, I'm tabling a document here which Mr O'Shea appears to have signed, and he used the CANS logo as part of that process. I've got copies for you if you wish to see them.
Is there a date stamp on when he used the logo?
It's for the year ended 30 June 2023.
30 June 23.
Thank you. Yep. So I'll need one of those. It's dated March 28, 2024, which does suggest that he was potentially still a CANS member at that point. So when you receive it, if I can get you to flick to the final page, that logo down in the bottom right-hand corner I'm reading is your insignia, and that's only to be used by people who are members of your association.
Correct.
Okay. So he was still potentially a member of CANS at that point. Is it disappointing to you to discover that a CANS member has been subject to regulator action by CADB?
It's always disappointing to hear of members who are subject of disciplinary action by another regulator.
Thank you. Now, referencing our discussion earlier about your capacity to undertake further action, what is the action that CANS is currently undertaken with regard to Mr O'Shea?
Given the focus of this committee's inquiry on the large firms, I don't have that information to hand right now. I am aware of the matter. I have the understanding that Mr O'Shea is a member and that decision of the CADB was of interest or is of interest to our Professional Conduct Committee, but I'm not entirely aware of the progress of that matter. I can take that on notice and provide that advice to this committee.
So if somebody could find out, I mean, it's like, was he a member? When was he a member? When did he cease to be a member? That would actually be very helpful for some questions that I want to have today, because even the fact that you've indicated that there could be a time lag in between CADB, which is a very robust disciplinary body, and then potentially your response is of some concern, because in that 6 months period of time, a person who has been found not suitable for the profession continuing to operate under your CA logo can do a lot of damage. That's a fair statement.
So the CADB decision was to cancel Mr O'Shea's registration as a registered company auditor, so his ability to continue to do audits ceased at that time. Our disciplinary process cannot impact registration or statutory registrations. Those are matters that the statutory regulators oversee. So the ability for a member who has been stripped of their statutory registration to continue to do audits is heavily confined.
Could I just indicate, thank you for your response there, Ms Chapman. Can I indicate that Mr O'Shea's case clearly has attracted some considerable attention, including an Accounts Daily, which I'm sure that you would be reading and keep across. So I'm presuming that you do attend to matters like this. When you see something like this, when you hear of it, somebody being struck off, what is your automatic response? How do you ensure that you're picking this information up? And do you look at the professional associations and try to work out, if the person's had a history as a chartered accountant, as you do in this case?
Certainly. So our conduct team monitor regulated decisions and are aware of CADB referrals and decisions as they are made. Typically, and I say this because there is a separation of powers, our disciplinary bodies are independent, so they take action on the basis of their own inquiries and investigations. However, typically where a member has been suspended or had an adverse finding made about their business conduct by another regulator or by a court, if it's a matter of civil proceedings, then that will raise a presumption in favour of an investigation and in favour of a similar type of outcome. So, for example, if a member has been suspended or terminated, had their registration terminated by a statutory regulator, then that would be grounds for suspension of membership of chartered accountants.
Senator, we take an active and interventionist approach in our conduct and disciplinary frameworks. So we monitor things like adverse findings in court judgments, adverse findings made by other regulators, and in that case, the CADB would have or should have informed us that he was a member. As I understand, in this particular case, the decision was made by the CADB, which I just would point out have made 25 decisions in 15 years. He was not a member at the time of the decision, so he resigned in March 2024, so post the date of the 28 March 24 advice that you have provided with us or financial report.
So I'm just tabling two documents. One is the article from Accounts Daily by Emma Pardis, dated the 28th of October 2025. And the statement there, to give shape to what was found, the board determined that O'Shea had continuously failed to investigate the companies related to party investments, including GCPF's investments in 15 property developments, which totalled $93 million in the 2023 financial year, 5 of which were related to GCPF's directors. So we're not talking about something of small scale. He may not be one of the big six, and we'll get to that, but it just goes to show that there is significant financial impact by people who are travelling around the country doing their business with a CA sticker attached to what they purport to be able to do and entitled to do. The second document I want to table is the current registration, with the TPB for Mr O'Shea, which my office printed off yesterday, and I note that even as of yesterday, he is still registered as a tax agent and is in fact listed as being a member of the IPA, who will be joining us a little later today. When did Mr O'Shea, colourful figure that he is, cease being a member of CANS?
He ceased being a member of CANZ in March 2024, Senator. But
before the CAB finding, because we're just trying to, I'm just trying to flush out a timeline here.
That's right. But post our former member bylaw changes, so as a former member, we are able to, and I'm just confirming whether we are investigating him. I assume we are, but yeah. It depends on the timing of the bylaw changes which came into effect.
Okay, so March of 24 is technically when you cease to have a formal relationship with Mr O'Shea.
Correct.
Okay. I'm going to table another document. All of these available just in the public place.
Chair, if I may, his registration as a tax agent is a matter between the CADB and the information sharing powers with the Tax Practitioners Board. So his registration in that capacity sits with the TPB.
Yes. Yeah. And thank you for the clarification. And I think this goes to my initial comments about where the gaps lie and the risk to public good and proper governance in the sector with somebody who's operating clearly in a profoundly unethical way. And to just stress that point, I'm going to table another document, which is the Golgol Preschool Association Incorporated report. Now, I've got a couple of copies here, another one for you, Mr Buchholz. Now, Mr O'Shea, on the 25th of February 2025, appears to sign off on an audit as a chartered accountant. So, but where his membership of the IPA is shown now in the bottom right-hand corner of the back page, could Mr O'Shea be a member of both organisations at the same time?
Yes, he can, Senator. It would be inappropriate for him to use his CA designation in this capacity that I'm seeing in relation to a financial report dated 25 February 2025 when he had ceased membership.
As of March. So he ceased membership with you. CADB has already had some determinations around him, yet he is now able to use the IPA insignia as a verification of his qualifications. Is that a concern to you, Ms Van Onselen?
Yes, it is. And in the event that he's also using his CA designation, we do have a process and procedures in place when that happens. From time to time, former members erroneously use their designation, and we normally will provide either a cease or desist letter and some other process.
Do you want to speak to that? Because I think we did cover this off a little in the last hearing about, communication between the different entities. But I find this demonstration of continuing practice, given he's moved from you, known to the CADB and still able to operate, and this is a smaller entity than the last one that we were talking about, but still.
Well, presumably the IPA should have done or did do a fit and proper person assessment, so I'll leave that. The IPA is being heard later today, so I'll leave that for them to answer.
And I guess the question that I ask on behalf of ordinary Australians who, when looking around, many wouldn't know that accountant is not a protected term, so that's the first risk. The second risk is then they hear chartered accountant. Might not have too much to do with it, but somehow it's got, credibility. Like the big four in lights across the country, chartered accountant, they're the good ones. IPA, CPA, these are special accountants. They are ethical people.
Very much is a trusted designation, yes.
So I guess how can the Senate and the people of Australia trust the self-regulation that currently operates within the sector when we have these examples of such profoundly egregious behaviour?
Whenever we find or become aware of former members who are not entitled to use the Chartered Accountant designation using it, we do write to them and ask them to cease and desist. It is, I would suggest, misleading and deceptive for an individual to use a designation that they're not entitled to use. I would also suggest that clients who are affected or who have relied upon a designation when choosing a professional would also be entitled to take action. It's not appropriate. We do occasionally come across individuals, former members, who continue to use their designation, and we take that very seriously. The term chartered is a protected term under our corporations legislation. It's not a term that can be used without authorisation or by just anyone. So we are very conscious of protecting that.
Can I say that it seems to be extraordinarily poorly policed, that there are gaps, wider than the span of the Harbour Bridge between different entities that should be overseeing this, and that this is not a safe operating system as it exists. It may have served its purposes in another time, but I think this case in particular just shows the glaring gaps that continue to exist. And for fullness, I'm just going to table an additional document, which is the statement, the media release from CADB about exactly what happened with Mr O'Shea. And for clarity for committee members before I move on the call, Mr O'Shea admitted that he had failed to perform adequately and properly the duties of an auditor, that he was not a fit and proper person to remain registered, and that his registration as an auditor ought to be cancelled. With that knowledge, with that document in the public, the man continued to practice as an accountant and undertake audit. Very big problem that needs more resolution to serve our national interest. Can I rotate the call now? I understand, Senator Scarr, that you have some questions, and then I'll come to you, Senator Pocock. 15-minute blocks, beginning with Senator Scarr. You have the call.
Thank you very much, Chair. And just in relation to this case of Mr O'Shea, is there any communication between Cairns and IPA in relation to these sorts of matters?
Certainly, Senator Scarr, thank you for the question. In terms of the communication between the Cairns disciplinary bodies and third parties, when matters are considered and adverse findings are made or decisions are made by the Cairns disciplinary bodies, a decision is taken around communicating or notifying third parties of the outcomes where the member holds a dual registration with another professional body such as CPA or IPA, or holds a statutory registration, whether that's with the TPB or ASIC or any other body, then there is capacity and those bodies are notified as interested persons of outcomes. It's also possible, and we have seen recently our PCC taking a much earlier notification approach, so notifying third parties on receipt of complaints so that those who are interested, whether it's other professional bodies or regulators, have early information available to them about the investigations underway.
Would you agree with the general proposition that if someone's found not to be a fit and proper person to be an auditor, a registered auditor, and recognised as such, then they're likely not to be a fit and proper person to be a tax agent or hold any other professional designation relating to the accounting and finance industry?
That's certainly a rebuttable presumption. I think in the case of professional disciplinary proceedings, it's always important to provide procedural fairness and give individuals an opportunity to address or provide additional information which might be relevant to that particular question. But certainly my observation where CADB or the TPB or another regulator has formed a view about fitness and propriety, then it's reasonably appropriate for that to be a common finding or to be a shared finding. And the TPB would certainly be interested in this.
Yeah, which comes back to the point I think which the Chair was making about this affluction of time between different processes commencing, different concluding, and the time it takes for all the relevant players, if I can put it that way, or stakeholders in the ecosystem to complete their deliberations. Where you've got a pretty strong finding in relation to someone's status as an auditor and they're found not to be a fit and proper person, what's the nature of the investigation that CANT undertakes? Do you go back and consider all the evidence de novo from the start, or is there a presumption that in terms of the technical finding, if I can put it that way, that's been substantiated and now it's a question as to, well, how do you respond to that disciplinary finding that's already been made?
That's a good question. Thank you, Senator Scarr. We don't do a de novo. The bylaws provide that it is an offence for a member to have had an adverse finding made against them by another regulator. As I said, there is a principle of professional disciplinary jurisprudence, which is that the member is required to be given an opportunity to adduce additional evidence or an explanation that may be relevant to a sanction that is applied. However, it's a prima facie offence. As part of our PCFR in 22-23, we introduced expedition provisions into our bylaws to enable those matters to be dealt with in a sort of far more efficient and expeditious way, and we have seen those proceedings used a number of times to expedite findings in relation to members who've had findings similar to Mr O'Shea's.
Okay, so you say expedite, so how quickly can you actually deal with the matter? Do you have any statistics or insight you can give us in terms of expedited cases with respect to how quickly those processes are completed?
So on average, most matters under our ordinary processes are concluded within sort of 4 to 9 months, with some taking slightly longer if they're a little more complex or if they require some sort of adjournment. Because of the expedited proceedings, the process is quite curtailed. My understanding, and I'll need to check this with my head of conduct, but those matters can be dealt with within sort of the 4 to 6 months mark.
Right, it's still quite a bit of time, isn't it? Given that. Yeah. Sorry, I'll just finish the question. Given someone's already gone through what would have been an extensive disciplinary process, they've had the benefit of natural justice, there's been deliberation with respect to the evidence and a finding made, can you understand the perception that perhaps matters need to be dealt with even more quickly, or there needs to be some sort of interim suspension process or something to try and protect the public from further conduct by the individuals, protect the public from them holding themselves out and using cans, if I can say it that way, as sort of a fig leaf to cover their egregious misconduct?
Certainly, Senator Scarr, and you're absolutely right. We do have an interim suspension procedure which is available, which can be used to suspend a member within a sort of 21, 28-day time frame. We need to provide notice to the member and an opportunity to respond, but it is a shorter time frame for enabling an interim suspension of a member.
Okay, so was that used in the case of Mr O'Shea? Or had he ceased to be a member by that time?
Because I understand he'd ceased to be a member in March 2024, so at the time of the decision of the CADB in October 2025, he had already ceased to be a member. As I said, I will need to take some advice from the Independent Professional Conduct Committee about the information that they have available to them about Mr O'Shea's conduct. It's not entirely clear to me from this media release when the conduct giving rise to the CADB referral took place.
Okay, and you made a...
if I may,
Sorry,
one of the...
Mrs Van Olsen and Senator Scarr.
Yes, thank you.
Yeah.
In the APSR, so the Australian Professional Standards Report for 2024, and also in the highlights for 2025, which we've provided the committee, we reference the continuous improvements that we've made in the conduct and disciplinary framework. So notably, for example, the disciplinary system was sharpened by introducing a formal prioritisation framework that elevates senior conduct and expedited pathways that materially reduce time to outcome for high-risk cases. And complaint handling was modernised by embedding alternative dispute resolution as well to resolve lower-level matters quickly and fairly, while preserving investigative capacity for complex and serious misconduct.
Okay. And do you have any examples of the expedited process actually being used in practice, so you can demonstrate to the committee how there have been cases where the improvements you've referred to, which makes sense to me, have actually been used in practice to protect the public from people who perhaps shouldn't be providing the services we're discussing?
Yes, we have, and we've provided details in our 2024 APSR about the number of expedited, or the impact of the expedited procedures on the throughput of the program, and I will provide that.
Our attention to what page that's on, please.
A long document.
If we look at page 32, Senator, we give them some complaint resolution timeframes. So, for example...
Right.
Yes.
No, you do.
Yeah.
Yep. Okay.
And to that point, look to, as expeditiously and as efficiently as possible, resolve matters, and particularly higher order or more serious matters. So in terms of time taken, 5 in 2024 were less than a month, 85 were within 1 to 6 months, and within 6 to 12 months was 67. Some more complex matters involving volumes of evidentiary material may take longer, or depending on the approach taken by the member in terms of how they defend those proceedings, which is entirely up to them.
Okay, that makes sense. Just 2 further questions, Chair. The first one is, you made mention of the fact that in terms of the power of Cairns to look at the conduct of former members, it depends whether or not, as I understood it, whether or not they became a former member before the new bylaws came into effect. Is that correct?
Yes.
Or is it when did the conduct occur?
So what is relevant is the timing of the conduct. When did the conduct occur? Was the person a member at the time of that conduct? And then it's not really relevant when the actual finding is made by an external body. It's relevant. The referable point is whether they were a member at the time of the conduct.
Okay. Okay, so if someone was a member at the time the conduct was made, but that was before the bylaws were changed, they still fall within the purview of the amended bylaws in terms of their previous conduct?
As long as they were a member at the time of the misconduct,
right.
then they're covered.
Okay, got it. And then the last question, the recalibration of the fines that can be issued, can you just confirm that for me again? As I understood it, it's 50,000 for an individual and 250,000 for a firm. Is that correct?
Yes. Yes, Senator.
Hello.
Oh, so I'm not sure if you heard my reply, but it was an affirmative. Yes, that's correct.
Yeah. So how did you come up with those amounts? And I'm saying this as someone when previous or documented cases this committee's considered that fine to be totally inadequate. Given the revenue or the income, net income that is earned by partners in major accounting firms, how did you calibrate the fine to the income that's actually earned by especially senior partners in some of the major accounting firms?
Yes, thank you for the question, Senator. Ainsley Van Onselen speaking. In the context of our professional conduct framework review that we initiated in 2021, the findings of which came down in July 2022, the recommendations of which were independently verified by the former ACT Integrity Officer Dennis Cowdery KC. We looked at the fines of other associations within both Australia and New Zealand. So, for example, the Engineers Australia, Law Society of New Zealand, Law Society of New South Wales, the Australian Medical Association. We also looked at our peer bodies around the world, so Institute of Chartered Accountants England and Wales, AICPA. What that found was that our fines were within a very similar level, in fact, even at that original level, higher than, for example, Engineers Australia. And other bodies. But we felt that some improvements could be made. We felt that there were societal expectations in that respect as well. But something we were very cognizant and took legal advice on was that as a private membership body that operates under common law, our fines cannot be penalties, they cannot be punitive. We are not a government regulator, we are not a frontline regulator. So in the context of ensuring that our judgments and our fines, when they are made, are upheld, if ever challenged in a latter court of law, we therefore made them as proportionate and as high as we could. We then took it to a member vote, and our members overwhelmingly voted in favour of those amounts.
Okay, so there's a legal issue, given the nature of the organisation, given the nature of the membership, that if the fines were too high, they may be found by court to constitute penalties or be punitive in nature and thereby be struck out. Is that correct?
Correct. And we have in the past, Senator, said to this committee and other committees that if the government decided that they wanted to increase fines, it's certainly within their remit and purview under legislation to increase our fines in that capacity, but we would need legislative authority to do so. In the event that you have other authorities around the world, for example, the PCAOB, they have huge, significant revenue and funding to make their investigations, and as a result, you'll see that their fines, which they have legislation to do, are significantly higher than any that an Australian either government regulator or professional body can remit.
And we might just note for the record, it was the PCAOB who provided the public knowledge of the KPMG cheating scandal. It was an entity outside of Australia that identified that in the public place and instituted a fine of some size.
A sweep of large firms in that capacity, yes, that's right. And they have significantly more resources than ASIC do, which is something that in our Going Further roadmap we have referenced. One, that ASIC needs further clarification in respect to its purview of particularly audit firms of public interest entities, and also further resources.
So I'm just going to table for fullness, because I will put this before ASIC this afternoon, but in the light of the questions that have just been asked and where we are, I'm going to table an ASIC public statement media release with regard to the Auditor of United Global Capital and related entities cancelled by the company's auditor disciplinary boards. And I do so because the background really gives shape and form to the scale at which Mr O'Shea was operating at then, and just to put on the record, appears to continue to be operating at with some impunity. There's one clarifying question in the room, and then I'll come to you, Senator Pocock. Mr Buchholz.
Thank you, Ms Van Olsen. Just to your comments then around the fine imposed. You mentioned that you're not a regulatory body. So in the event that you impose a fine from your organisation onto a member who ceases to be a member, what is the impulsion on the non-member then to service the fine? If they walk away and say, no, thanks for the fine, but I'm not interested.
That can be a risk, but we find that our recovery rates are high. We recover, and this goes to the question that Senator Scarr raised earlier, on page 17 of our own annual professional standards regulation and conduct report, we note that we recover about 85% of our costs, our external legal costs. There is always a risk, particularly with insolvency matters, that the member is impecunious and unable to pay. However, we do recover a high proportion of our costs, and we do take recovery action where necessary.
So the cost could be, you could pick it up on 85%. Is that in the case where members are wanting to continue the membership in the event such as this, where the member has indicated they're no longer, the membership has ceased? Does that fall into the 15% category of non-recoverables? Not
necessarily, Mr. Buchholz. We do have examples of members who have ceased to be members but who have continued to pay, who have paid their costs orders.
Are they required to, though? That's the question.
They are required to.
And what do you do if they resist?
We pursue civil recovery.
And can you provide on notice circumstances where that's occurred and the amounts that we're talking about?
We can provide that on notice.
Thanks, Deb. Thank you very much. You have the call now, Senator Pocock, for 15 minutes.
Thanks, Chair, and thanks everyone for being here. KPMG has been mentioned. Can I just ask what's the status of the investigation into KPMG registered auditor the auditor who used AI to cheat on internal AI training?
Thank you.
Thank you, Senator. So those related matters in relation to use of artificial intelligence for internal tests at KPMG were disclosed to us by the firm through a quality practice review that was ordered post the 2021 exam-related matter. In that instance, it was disclosed that there were 28 employees of KPMG that were involved in that academic integrity matter, 10 of which are our members and 10 of which have self-disclosed to us, including the RCA that you refer to, and are currently going through our independent investigative process.
May I add one thing to that, just to complete that? Thank you. Just to complete that, the ASIC has been notified of the details of the registered company auditor who has self-disclosed to us.
Can you give us any further information about what whereabouts in the process you are going through, you are up to?
The Independent Professional Conduct Committee is progressing these matters. It would be inappropriate to comment any further. They're on foot. They are in progress now.
Can you, going to another matter, you informed this committee that you've been investigating the conduct of KPMG in relation to the New South Wales Transport Asset Holding Tahi matter, and that's been underway now since 2021, so more than 5 years. What is the precise status of your investigation into that conduct, including any inquiry into Mr Andrew Yates or any other executive partners of KPMG?
Thank you for the question, Senator. Yes, I note that in earlier proceedings before this committee, we noted that the Professional Conduct Committee had commenced an investigation. I can confirm that the disciplinary bodies have concluded their investigations in relation to a member who was involved in an engagement, and those investigations concluded and determined that the member did not breach the Code of Ethics or the CANS bylaws.
And is that a published finding?
In terms of the CANS bylaws, where there is no adverse finding against a member, there is no capacity to publish a finding. The publication provisions of the bylaws provide that a disciplinary tribunal or an appeals council decision is published if there is an adverse finding against the member. There is no publication if there is no adverse finding against the member. The bylaws also provide that in terms of the Professional Conduct Committee investigation outcomes, which is the lower order outcomes, Those decisions, if they are published, do not contain identifying details but may be published in the public interest as a deterrent. So to your question, there is no published decision in relation to this matter. However, I'm authorised to make that statement.
Thank you. Mrs Van Onselen, in your opening statement, you spoke about our interest as a committee in the affiliate members of CANS. I'm interested in the scope of the coverage of professional standards and accounting those standards. So I understand that a public interest case has been brought in the New South Wales Supreme Court seeking to remove affiliate members and Category 3 services from the accounting scheme. If that occurred, the accounting scheme would, I understand, continue to apply only to qualified accountants but cease coverage of unqualified consultants and consulting services, principally affecting those in the Big Four. Will CANS be defending that proceeding?
Yes, Senator Pocock. As I said in my opening statement, we are defending that matter alongside the Professional Standards Council. And I referenced the report, which I do have a copy and can table. It's an independent report conducted by Professor Charles Samford, who is a very senior academic at Griffith University, is involved in matters relating to integrity issues in the Queensland government, where it says that the fundamental aim of professional standards legislation is consumer protection. Now, affiliates work across firms of all sizes, and including them in our scheme achieves two things. First, it holds more professionals to a higher standard, and secondly, it protects more consumers who may need access to compensation through mandatory professional indemnity insurance.
Thank you, and it also caps, of course, any liability. In contesting that case and defending that case, do you fund that out of general CANS revenue, or do you impose a levy? How do you fund those? How will you fund that case?
Like all litigation matters or conduct-related matters involving lawyers, we fund those out of our operating expenses.
And what communication have you had with your members about that case?
I believe that we issued a membership-wide either email or reference statement on our public website, probably both, in relation to that matter, and that we were defending the matter.
Thank you. Could you provide to the committee those pieces of communication, those two or any other that have dealt with that case? Is CANS a respondent to any other litigation from its members or former members at present?
Yes, we are, Senator. There is one matter that remains on foot in the Queensland Federal Court, and there is one matter that was concluded this week with the handing down of a judgment by Justice Brereton in the New South Wales Supreme Court, which concludes that matter at this stage.
So, in the matter of...
Sorry, Senator, if I may. In that last matter that my friend referred to, Justice Brereton made the following comment. In the circumstances where this court has concluded that the claims that Mr Jaworski wishes to bring have no prima facie evidentiary basis, he is making vexatious use of processes of this court in seeking to adjudicate the same claims when he has failed to meet outstanding cost orders of this court and the Court of the Appeal.
And is there a matter still afoot in the Federal Court of Reeve versus CANS?
Yes, Senator, that's the matter that I mentioned. It's the Federal Court in Queensland. That matter
is part of Mr Reeve's allegation that CANS failed to investigate his repeated reports of professional global audit firm?
Mr Reeve has advanced a number of claims. He's a self-represented litigant, and those claims are being defended by chartered accountants on the basis that they are without foundation and they're not substantiated by evidence. The next hearing in this matter is on the 9th of, is in April, I believe. But to hear Mr Reeves' application calling for the recusal of the judge in our case, Mr Reeves has also advanced cases against the Fair Work Commission and the Australian Human Rights Commission, which are separate matters. We are defending the proceedings as we are required to do, having been made a party to them. However, as I said, we believe, and our defence is on the basis that the claims are unsubstantiated and without foundation.
Thank you. You've given us data this morning for the year through to December 2025 on complaints and the resolution of complaints. When you last appeared, you were questioned specifically about the apparent lack of enforcement against the Big Four. As I recall, you testified that just 17 Big Four members had been disciplined for breaches of ethics. And in your answers on notice in 2024, you reported there are 170 active monitoring, inquiry and investigation files concerning members in Big Four firms. How many of those have resulted in disciplinary sanctions?
So, Senator, thank you for the question. As you can see from the data we've provided to the committee for the purposes of this proceeding, there has been a fairly extensive and comprehensive set of investigations undertaken by the Professional Conduct Committee over financial year 25 and into the calendar year 25 in relation to academic integrity in particular. The details of those investigations taken on the PCC's own initiation are detailed at page 15 of our annual Professional Standards Regulation and Conduct Report. That has resulted
Sorry, I'm interested. My question is not about the general numbers. It's about those cases concerning members in Big Four firms.
And those cases concerning members in Big Four firms have significantly increased as a result of that PCC program of work. The number of complaints resolved by the PCC in the 13 months from December 24 to 31 December 25 amounted to 334, which is a significant jump. Of those, you can see from
Sorry, just explain what 334 is. It's the number of...
So that's the number of complaints involving members in the 6 large firms that the committee has asked for information about. Of those 334 complaints, there were 203 cautions issued, 4 consent orders entered into, 87 professional reminders issued. No further action was ordered in 16 cases, and we've provided as a footnote to page 15 of our submission the reasons for no further action, and then a number of complaints that were not investigated because of deficiencies in the complaint itself, and then 6 matters that went through to the DT or Appeals Council, resulting in the termination of a member, the suspension of 3 members, and the censure of another member, with fines as well in relation to 2 members, or 2 complaints or 2 matters.
Can you just give me the reference? Is that in your submission or another report?
So this is in it's in our submission on pages 14, 15 and 16, and I've included links to the decisions in the footnotes should the committee be minded to read those decisions. They are quite comprehensive in terms of providing insight into the tribunal's reasoning.
So on notice, could you tell us or provide to us the type of service involved, including whether it related to audit and accounting or non-accounting services, and the level of fine, where it went through to fine, I think you said in 3 cases? So
the fines applied in 2 cases. They applied in the cases of Mr Seymour and PwC, the firm.
Okay, yes. If you could give us...
Before you jump off there, could I just get for the record the amount of the fine that Mr Seymour was sanctioned with?
So the tribunal ordered a fine of $15,000 and a costs order of almost $10,000.
9,000. It was, up in the high nines. Right. So
his membership was suspended for 4 years. He was stripped of his fellowship status as well, which is in line with the TPB deregistration as a tax agent, and also given a 4-year ban. And
that was the first occasion, I believe, that you had sanctioned a company and a head of a company in a way that related to his behaviours other than just as an individual. Is that correct?
Close, not quite.
Good.
So the first time PwC, so November 2023, PwC, the firm, was censured and fined in relation to the TPB finding against the firm, and at that time the highest fine that was available to be applied, $50,000, was applied. A second fine was imposed in relation to PwC, the firm, in relation to its reporting failures to the PCAOB, and on that occasion a fine of $25,000 was imposed by the disciplinary tribunal.
May I just add, Senator or Chair, there was also a cost order of $45,000 or just over for that first matter. PwC was also ordered to do a quality review, undertake to provide further information to PCC on a regular basis, and there was a publication order and notification to other parties. On the second matter, there was a cost order of almost just over $7,000.
Sorry, 7 or 70?
Yeah, $7,232. It was an undertaking to provide any further documents provided to the PCAOB regarding the matter, and again there was another publication and notification order. If I may just go back to your question, Senator Pocock, before in relation to the schemes matter, I do have an update for you. So we provided on the 3rd of March 2025 on our website an announcement of the approval of the new professional standards scheme to commence on the 13th of July 2025 for over a 5-year period, where we were complimented by the Professional Standards Council on the quality of our report and application. And then on the 16th of July, we provided an update in relation to Mr Lyons' litigation and noted that we would be defending it. And in the meantime, the scheme is fully in force and operative.
Senator Pocock.
Can I go to your views about the adequacy of that fine for Mr Seymour? I understand $15,000 fine and a $10,000 costs award. What's your view about the adequacy of that in view of the nature of the breach by PwC?
Well, as a private membership body, Senator, CANZ's powers, as I've mentioned before, are defined by our Royal Charter and our bylaws. It's important to note that we're part of a broader regulatory landscape, but we do not have the same powers as statutory regulators like ASIC or TPB. The disciplinary decision against Mr Seymour, which we have provided to the committee, considered the TPB determination, and the decision outlines clearly the tribunal's view of his conduct. The tribunal, as I mentioned before, determined to suspend his membership for a period of 4 years, which corresponds to the TPB decision to terminate his tax agent registration and restrict reapplication for 4 years. In addition to that, they stripped his membership status as a fellow, had a public naming of the decision, and then there was the costs order and also the fine. Fines are determined by the tribunal, but to be enforceable, they cannot be punitive, and management cannot challenge or amend the tribunal's sanctions or fines made by the independent disciplinary committee. It's a little bit like church and state or government and the judiciary. There is an independence that needs to be honoured in this instance.
In your experience, is this the only instance, published or unpublished, in which a member of the Big Four, an affiliate member or otherwise from a big firm, has been disciplined by CANZ?
I think you'll see on page 14 of our submission to the committee, we've provided the total complaints resolved by the PCC in relation to large firms, as identified in the invitation by the committee for our appearance. I would just note, though, for the committee's benefit, the 6 firms identified are not necessarily the 6 largest firms by revenue. There are 2 others that, in most recent reports, are larger. And in that period between calendar year 19 and November 24, there's 133 complaints resolved by the Professional Conduct Committee against large firm. In relation to disciplinary tribunal, it's on page 15, and I don't have that figure to hand, but we can certainly provide it. There were two calendar year 19 and November 24.
Just before we move on, what were the other two large firms that you did not name in your answer then to Senator Pocock, please?
So that's so there's an annual publication of firms' revenue, so biannual revenue.
Yep, so just if you can name them.
Yeah, so Findex and RSM.
RSM, thank you very much.
I just have a last clarifying question. I wanted to know how many affiliate members have been investigated or disciplined by CANS.
So in the last 5 years, Senator, we are instructed that there have been 24 affiliate members who've been had complaints made about them by chartered accountants, disciplinary bodies. I believe of those, 10 of those were complaints lodged by third parties, so clients or other members. 8 were self-reports, and 6 were complaints that were initiated by the PCC on information that they had about the affiliate from external scans. There were 14 investigations undertaken in relation to those 24 complaints that resulted in 9 cautions being issued, 2 consent agreements and 1 referral to the disciplinary tribunal, which is on foot at the moment.
So any sanctions or disciplinary outcomes specifically?
So 9 cautions.
Today, 9 cautions, yeah.
And 2 consent agreements, which would include censures or similar types of reprimands, and then 1 referral to the disciplinary tribunal, which is predicated on the basis that suspension or termination of membership is being sought.
Okay.
And
Thank you.
Just to clarify, Senator, we have 2,261 affiliates within our 140,000 membership base, so just less than 2% of our membership.
Thank you. I have more questions, but I think my 15 minutes is up, Chair. Thanks for your answers.
Thank you very much. I hope we'll be able to go around again. Can I just indicate that it's a matter of public knowledge that Mr Seymour's last salary in the year 22-23, before he was displaced from his role as the CEO of PwC by intervention of the global element of PwC, his income that year was $4.6 million. We're not talking about career outcome. We're talking about a single
1 year,
$4.6 million. You very clearly indicated the fines that he received. In what way do the fines that you've explained you're capable of implementing and that you have increased in recent years with the consent of your compliant members, in what way do you think a fine of $10,000 in recovery cost under $15,000 as the personal penalty acts as any form of dissuasion for members in the profession who are bringing in $4.6 million in a single year?
So, Senator, that would be a question, I think.
I'm asking you, and I'm not asking you to move it to anybody else. What is your view about the dissuasion factor of that level of fine, noting the limitations you've put on the record already?
Yes. And noting that the TPB did not issue a fine, which is a government regulator, and noting that we exist within a co-regulatory space, and that we have received legal advice on this issue, that our fines cannot be punitive or of penalties. We would need
We've already got that on the record. Now, the question is, do you see that level of fine having any dissuasion effect at all?
I look at it in the context of what's legally enforceable, Senator, and what would be upheld if it was challenged in a court of law. And our advice is that it would be challenged if it was
Of course it would.
Yeah.
Of course it would. But the reality we have to deal with is cowboys who are moving around in our economy who are being profoundly incentivised by profit that is a counterweight to any ethical training, even if you police that training quite quickly, quite well. The reality is if you're an unethical person and you're incentivised by profit at any price, especially if it's to the tune of $4.6 million, that is a risk ratio that is of extraordinary level in our economy. That's how I see it, representing Australian citizens. And you're sitting in your position expressing your limitations. But the gap has to be attended to, Ms Van Olsen.
The limitations of the government's legislation. If you want PCAOB type fines, then you need to provide sufficient resources to ASIC and legislation authority, either to ourselves. We certainly have the disciplinary and conduct frameworks to go through that process, but we would need legislative intervention.
Can I ask if, in response to the Financial Services Council recommendation in 2023 that the PABs might be combined to perform a single independent body to oversee the entire sector, which at least would mitigate some of the gaps that have been exposed already in the evidence this morning. Have you given any further consideration to that? Have you advocated for the fusion of your disciplinary board with the other representatives of the sector, the CPA and the IPA?
So in that so you're not talking about the merger of the standards, just to clarify, the standard setting bodies, the new ERA body that the FRC will merge
I'm talking
to?
about a disciplinary body. Has that been given any consideration?
So in that instance, as a private membership body, we would always need to retain the ability to discipline our members and to have oversight of our membership base.
Can I put it to you, Ms Van Olsen, that while that is a desirable thing from your point of view and from CANS as a business model, it is not serving the public good? I'll go to questions from Ms Jarrett.
Would you like me to respond to that?
I think I'll just leave it as a statement because I don't think we're going to agree. Ms Jarrett.
Sorry, I've just got to turn my light on. It on cue went off. Hang on.
Conserving energy. Well done.
Yes. Good morning. Good morning, everybody. I just want to pick up on a couple of things. You said at the start, Ms Van Olsen, that there were 707 complaints and you've resolved 710. Did I hear that correctly?
Correct, yes.
Okay, and so does that mean that the difference is because you're resolving older cases?
Yes, that's right.
Okay, so how many open cases would there be at the moment that you're dealing with?
I might defer to my friend, Ms Chapman.
I would need to take that on notice. It's in the order of a couple of hundred, plus we have about 1,143 monitoring files active at the moment, and at any given time, dependent on inquiries that are being made, those could convert to investigations.
Okay, yeah, if you could take that on notice, because I am keen to understand like how many cases are open at the moment, given the discussions that we've had around timing and interactions with others. Is there you talked about self-reporting and 2/3 are self-reporting at the moment. Is that an improvement on previous years?
Yes,
or is that sort of standard run-of-the-mill, this is what we normally get?
It's certainly an increase from prior years and is reflective of the enhanced work that we have done in both our Going Further roadmap and professional conduct framework review to look upstream and educate our members in relation to their self-disclosure obligations, noting though that self-disclosure is only one part of our ability to open an investigation and look at a matter. So we can receive complaints from members of the public, from clients of our member services, from the government, for example. We also do active monitoring of adverse court findings, where we receive information sharing from other regulators, etc. However, our members do have an ethical obligation to self-disclose in a number of forums. So the first would be when they have their annual renewal, of their subscription. They're required to attest that they're a fit and proper person. They're required to inform us of any adverse findings that have been made against them. They're also required to inform the conduct team, I think within 14 days, of an adverse finding made against them, be that in a court of law or by another regulator and beyond. What we've done upstream is we've, for example, and you'll see this in our highlights pages of our APSR 2024 that the committee has, and the highlights pages of our 2025 APSR. We have, for example, amended our membership handbook to make it very clear the circumstances and guidelines behind self-disclosure. We've included a frequently asked questions component in that respect. And then we've used our quite large platforms like our Acuity magazine, our website, our social media platforms, LinkedIn, for example, to, again, remind members of their self-disclosure requirements. And we also proactively work with the firms as well. It's very important here that the firms encourage the members of their employees that are members of ours to self-disclose, for example, if there's been a firm adverse finding, and we've worked with them successfully, and you can see that in the report at page, the annual transparency report that we published in December of this year, page 15. You'll see outcomes for 2025 in terms of the type of complaints, and you'll see the large increase there of some historical academic-related integrity matters dating back to 2016, 2019, of which there was about 189.
Okay. Are you able to just take this on notice and just let us know what percentage increase there has been in self-reporting over the last, from year to year over the last few years? And you mentioned that you're working with, first of all, you mentioned adverse findings. Now, that I assume means adverse findings, whether it be through one of the other professional bodies, through ASIC or whatever, correct? Like a more formal process. Is that correct?
Correct. Or in a court of law, if there's been a judgment.
Or in a court of law, yeah, correct, yeah, okay. And then you said you are working with the firms to better understand maybe their internal disciplinary activities. Is there a requirement for those firms to notify you if they're watching someone carefully, if they've made their own internal cautions or taken action against individuals? Is there a requirement for them to tell you that under their membership rules?
The requirement under the membership rules sits with the individual member to notify the PCC within 7 days of a notification event, which includes internal findings by an employer that go to integrity or another aspect of ethical conduct and behaviour. So that's where we have seen an increase over the last few years with self-reports, a significant increase, and we will take it on notice, Ms Jarrett, to give you that number. But if I can add to Ms Van Onselen's notes about the work we've been doing to raise awareness of self-disclosure through the PCFR, we observed that members had low levels of awareness of their self-disclosure obligations and have worked consistently over the last few years to remind members of their obligations. And in October 2025, we issued our first quarterly ethics digest, or QED for the mathematically inclined, which is being sent to all members, all individual members, on a quarterly basis. The first issue was sent to coincide with Global Ethics Day last year, which was an incredible event in terms of attracting 16,000 registrations of our members to hear about integrity in practice. But the QED goes out quarterly and includes links to those fundamental membership obligations around self-disclosure. It is the individual member's obligation to disclose. That's not to say that we don't have firms from time to time bringing matters to our attention. However, the obligation sits with the individual member, and we have seen, as I said, an increase.
Yeah, and if the firms don't bring them to your attention, does that then kick off some sort of internal process for you to start looking at, whether it be through the tribunal or the disciplinary board, etc. Is that a trigger?
The trigger, so through our practice quality review program, we send a reviewer into practices and they will ask questions about these sorts of matters, and that will often surface issues and will form the basis for further inquiries to be made.
Okay. Have you seen...
Sorry, if I may add, in terms of the enhanced ethics training that we give our members since we introduced mandatory ethics training post our professional conduct framework review and going further roadmap. So the Global Ethics Day, for example, when we held that it's on Global Ethics Day, that was when we hold it, it's complimentary CPD for our membership base. When we first held that a few years ago, we probably get 2,000 or 3,000, which was a record at that time of our membership base. As the years have progressed, you can see the emerging awareness of that particular day in particular. It's getting quite a brand. So to get over 10% of our membership base registered and over 9,000 live on that time, when we had global ethicists, we had a former Premier, Mr Mark McGowan, was also on the panel, I was on the panel, reminding members of their obligations under the APES 1110. In addition to our other material and acuity articles and things of that nature. So we have done a huge amount of work upstream to ensure that our members are aware of their obligations as a member of CANZ.
Okay. Have you seen, I'm just interested in any trends you're seeing in terms of the type of cases that you're reviewing at this point in time? Are you seeing any changes? What's going on? What I'm trying to understand is, are things changing out there in the ether that we don't know about that we should be aware of?
In our annual Professional Standards Regulation and Conduct annual report, we provide a breakdown of the sort of causes for complaints. We also provide it in our 2024 APSR. Sadly, year on year, the issues tend to be the same. Non-criminal adverse findings, unprofessional behaviour.
Just before you jump off that, could you explain for those of us who are not doing your job every day what exactly that means?
So adverse findings in civil litigation, so where the court has made a finding about a member in a non-criminal, so it doesn't relate to a crime per se, but there are civil proceedings where the member has been observed by the court to have engaged in misconduct that impacts their integrity or their business practices.
Okay, so example of such cases, please. What does that look like in the public place? Because we're talking in this lovely sanitised level of language, and we can do that with a report. But our job is to help Australians understand what the risks are that they are being exposed to by people that you are sanctioning in if I can put it, in the dark, in a quiet place where people aren't named and behaviours are not explicit. So this is the chance for us to get on the record. What exactly are you talking about there? What sort of behaviours have represented?
So they would be adverse findings, for example, by the TPB or CADB that a member has failed to satisfy requirements for registration as an agent or as a registered company auditor. Those are not criminal findings, they're non-criminal, but they're adverse findings that go to the members' integrity or business practices.
So for the record there, you're talking about backwards and forwards between CADB and the TPB and yourself. So it's inexplicable to me that there are such gaps if this is going backwards and forwards with you. How many occasions would you be interacting with CADB and the TPB in a year?
So CADB referrals are public. We take notice of those as they're made public.
Do they interact with you directly?
I believe we interact directly with ASIC. So CADB processes are subject to its own legislation, and so the referrals are made public. We become aware of those, and then the findings are made public. There is an issue where settlements occur or where matters are historically, we've seen that matters would settle and there would be no public outcome. However, we, as taking notice of the referral, our PCC could, if it could take action and could follow those inquiries.
Good.
But the settlement
doesn't necessarily do so.
Yeah.
Okay, so we've got the TPB, CADB, we've got some gaps in knowledge transfer between those entities and yourself. a little uncertainty about how proactively CANS or your disciplinary body chases this down, given there's a cost to do so. And you seek to recover costs in some cases, and they seem quite low by comparison to what I might have thought. What else are people in the profession doing that are bringing themselves to your attention in a non-criminal way that we should be aware of as the Australian community?
Yeah. So I'm thinking too, if I could add to that, Chair, not just disciplinary cases, but your complaints, the trends in the complaints that are coming through.
Yeah, thank you.
To be clear.
Yeah, the trends in the complaints, as I said, have remained fairly standard. So, due care and diligence, we get complaints regularly about books and records, so members not handing those over to a new accountant or a new practitioner. There are criminal convictions and charges.
So basically, let's just flesh that out. Somebody says, I don't want you to be my accountant anymore. I want you to transfer all my documents to another accountant. And accountant number one in that example says, no way, I'm keeping the information myself. I am not going to assist you with the transfer. That's going on.
There are complaints about those liens being... so accountants historically would use liens over records in order to secure the payment of outstanding fees, but it's not an appropriate practice. So that's an issue that we still see sometimes.
Okay, so despite a request for transfer, there is a practice amongst accountants to not transfer information until they get paid for their services. They use that moment of transaction.
So we had 14 matters in FY financial year 2025 that related to that. So the full list is on page 15 of our
Can you just
report.
Talk me through them though? Because there will be people who will be listening. There'll be people who will not be able to read that document and understand. So Ms Jarrett and I both have asked for examples and trends of disciplinary and emerging behaviours, please.
So for the FY25 year, non-criminal adverse findings, as I've mentioned before, so registrations being subject of an adverse finding, unprofessional behaviour, failures of due care and diligence, conflicts of interest and objectivity.
So what does a failure of, what was your second point? Failure of...
Due care and diligence. So the complaint would be that a member has made a significant or material error in a client engagement or in a piece of client work.
Okay, and materiality in terms of accounting means what, Ms Chapman?
It depends on the engagement. Trivial or minor errors in work wouldn't necessarily be a grounds for a complaint, but where the client has suffered a detriment as a result of a significant error, then that could be raised and could be pursued as a complaint.
So this is perhaps where there might be the purchase of a business and there is an unrealistic assessment by accountant number one of the business to be sold that values it at more than it is actually worth, and the person who purchased it on the back of that public information provided and ticked off by one of your members finds that it was inaccurate. Is that what that descriptor means?
It would go more to the failure to exercise the due care in order to establish a reasonable valuation. So
it could be accountant two who hasn't checked the homework of accountant one.
It could be that accountant one simply hasn't done enough work to determine an appropriate valuation. The circumstances vary and each complaint is assessed on the basis of the particular facts.
But there are two failure points there, potentially, at least.
Potentially. Ultimately, the client engagement partner is responsible for the work, and whether the person who's signing off the work relies on tools or whether they rely on other people to assist them with the delivery of the client work, it's the client engagement partner who bears the responsibility for the accuracy and the quality of the engagement.
Okay, so that was item 2. Item 3 on your list?
Conflict of interest? What are the conflicts of interest you're seeing?
So we do see a number of conflict of interest cases coming through. Typically these involve practitioners who are acting for business clients, small business clients, where the directors are partners in matrimonial partners as well as business partners. The sad reality is that often accountants trying to do the right thing will continue to act for the business and one of the individuals and not necessarily appreciate that the conflict arises when there's a marriage dissolution or some other factor which impacts that relationship. We have a conflicts of interest guide which outlines a number of scenarios where that can be a factor, and we use scenarios to provide very practical guidance, particularly to those members who work in that small to medium business support space, to recognise the issues. But it could be a range of things. You could have a member who's acting for in a range of capacities and not necessarily appreciating that they have a conflict and therefore need to disengage.
Can I just put on the record at this point of time work by this committee in the previous Parliament, and the recommendations, 61 unanimous recommendations for the financial abuse report.
Correct.
Australians know a lot about scams. That costs the economy $3 billion per year. That inquiry received evidence that indicated the cost of financial abuse, which is enabled significantly by sort of the example you've just provided, is costing Australia $5.7 billion. It is a form of very gendered abuse, predominantly perpetrated by men on women, and we took evidence that described the sorts of behaviours that we're discussing here, where in a partnership the accountant most frequently took the part of the man in the breakdown of the relationship, and economic abuse ensued, enabled and directed by members of your profession. So can I point that report out to you and express continuing concern about the behaviour, and thank you for putting on the record that this is something that is in your sights, because it is a very significant cultural problem that needs redress. Ms Van Olsen, you want to comment? I'll come back to you, Ms Jarrett, for a question, and then I'll go to Senator Sharma.
Thank you, Chair. Yes, I'd just like to refer the committee of our 2025 APSR highlights extract, page 11 and 12, outlines the activities we have done just in 2025 alone to address financial abuse. So in April 2025, CANZ voiced its support to the pre-election promise made by the Labor government in this area. In May 2025, we accepted an invitation to contribute to an ongoing multidisciplinary consultative forum established by the Australian Human Rights Commission, and that project is now able to be reviewed on their website. We published an update to our members on financial abuse in the October edition of Acuity magazine, which explored the hidden signs of financial abuse that you alluded to and the role accountants can play as first responders to victims and how accountants can respond with care. During the year, we also commenced discussions with Legal Aid New South Wales to gain a better understanding and to build a network of experienced professionals in this area. On 24 November 95, we hosted a free webinar for our members that explored the vital role that accountants play in preventing and mitigating financial abuse by strengthening client practices. And this webinar featured Adjunct Professor Susan Rick, AMFCA, Chair of CAA's Advisory Group, and others.
Thank you very much. Back to you, Ms Jarrett, for a final couple of questions.
Yeah, I just wanted to ask, are there any other trends? So you've mentioned conflict of interest, you've mentioned due diligence, material errors, etc. Is there anything else we should be aware of?
Some of the areas that we're looking at the moment. So academic integrity, for example, and internal training has been a priority for us since 2021, with firms required to show how their policies and controls address this risk. And you'll see that as highlighted in both the annual the Professional Standards Regulation and Conduct Annual Report that was published for 1st July 2024 to 31st of June 2025. And as part of its investigations, our Independent Professional Conduct Committee required several firms to conduct internal inquiries, which resulted in this large number of self-disclosures that you see at page 15 of that report. I also wrote to all of the large firms as well. Could
I just interrupt you there quickly just to clarify? With those, you said several firms, the academic integrity, is that seen more in the larger firms versus the smaller firms?
I think it's across...
Or is it more widespread?
It was in relation to historical matters that the PCAOB initially looked at, so from 2016 to 2019.
Yes.
They're
the big firms,
predominantly. Yeah. But in terms of emerging areas, we're particularly, and you'll see this at page... Sorry, just bear with me, of our submission... Sorry, no, our 2025 highlights page. We're looking at artificial intelligence in academic learning, particularly our own CA program. So we're working with TEXA. We are the only professional accounting organisation that is accredited with TEXA. We've provided them with our Generative AI Action Plan. And we have, over the last 4 to 5 years, ensured that our candidates sit first and foremost an academic integrity module, and they have to pass an academic integrity test with a minimum of 80% before they can attempt their first assessment. We also removed multiple choice questions from the CA program assessments in order to ensure that there's genuine engagement through open book exams. We use plagiarism detection software for online written work, and we have personalised and unique tasks, reflections and candidate authentication and proctoring for high-stakes online exams. And our academic integrity framework aligns with TEXA requirements and also the higher education standards frameworks. So that is an area, particularly the use of AI is an emerging area of focus for us, but also the finance profession will be heavily involved in the Tranche 2 AML legislation, and so we are at this stage, again at that upstream end, really working and equipping our members to ensure that their clients are compliant with the AML Tranche 2 legislation requirements, but also climate disclosure legislation as well that is also active now for Group 1 entities. So there is a huge learning with this kind of regulatory change that's occurring that we need to equip our members so they in turn can give accurate, satisfactory advice to their clients.
Thank you. Thank you, Chair. I have other questions, but next time.
Thank you very much. We'll go now to Senator Sharma.
Thanks so much, Chair. Thanks and good morning, everyone. I just wanted to understand a little better the basis of your organisation being able to impose disciplinary action on its members. So as I understand it, and please correct me if I'm wrong, it's your relationship with your members is contractual in nature.
Yes, correct.
And so when they become members, they sign up to your disciplinary processes and agree to honour and observe them. Yes. So if they, to go to, I think someone was asking this earlier, if they refuse to pay a fine, for instance, they are in breach of contract, but nothing more than that.
Not necessarily, Senator. So there have been instances, and I think we'll take those on notice to provide the committee further information, but there have been instances where we will, in lower courts, depending on the amount actually that's owed, will pursue our costs orders that have been made in our favour.
Okay, but you're doing on the basis that there's the party's in breach of their contract, right? Like that's the basis for your legal. And then to go to this question about the quantum of fines you can impose, so it's the sort of the non-penalty principle of equity law, effectively, that limits what you can impose here. So you cannot have a punitive fine in a contract, just as you couldn't. If I was a consumer with a credit card and I missed a payment, the bank can't say you're going to have to pay me $5,000 for being 1 day late in your payment. Is it similar for... That's what limits your ability to impose fines?
Correct. The common law makes those sorts of provisions void as penalties.
Yeah.
And because our disciplinary bodies are required to... We're upholding the rule of law in the public interest, so seeking remedies that are not legally enforceable or that may not be legally enforceable is not really consistent with that principle. So CAN's Regulation 8 provides a set of guiding principles to sanctions and to the determination of sanctions and the relevant principles, and that regulation is generally appended to every public decision and explains, there's an explanation in each decision as to how the tribunal or committee has has come to its view on the quantum of, or the determination of a sanction.
Okay. And there is obviously, I mean, if you were to, you said, I think you can now impose penalties of up to $250,000 for
public, for the firm event,
for the firm,
firms,
and for an individual.
50,000.
50,000. Okay, but you would need advice, or the disciplinary tribunal would need advice that would be able to withstand a legal challenge before they could seek that it wasn't going to be punitive in nature. It still has to be in a way of linked somehow to the damage suffered or the costs incurred.
Correct. So the tribunal does look at, the tribunal is legally advised. They have external legal advisors to support their decision making as they consider a matter, and so they would take advice at that time. The fact that there is a ceiling of $250,000, there are circumstances where it could form that view that would be the appropriate level. However, it's entirely within its discretion because of the independence of that process.
Okay, I understand. And then if I could just return to the PwC, Mr. Tom Seymour matter. So, as I understand it, so you suspended his ability to be a member for 4 years, is that right?
For 4 years, that's correct.
And then you imposed a costs order on him and then also a fine.
Also a fine.
Okay. And then if I compare that to what the Tax Practitioners Board did, the Tax Practitioners Board terminated his registration and prohibited him from applying for registration for a period of 4 years, but issued no fine.
No, they didn't issue a fine.
So is it true to say that your association took stronger action against him than the TPB?
Yes, correct.
That's interesting. Because the TPB, I mean, you're obviously not operating under a statutory framework, right? You don't have the powers of a regulator or legislation behind you.
No, and we do regard them as the higher order regulator. We have very good relationships with the TPB. We meet with the TPB regularly. We have information sharing arrangements in place with the TPB. However, you're correct, Senator. The TPB did not impose a fine or seek a civil penalty order under the legislation.
They could have sought to impose a fine if they went to the federal court. That's correct, isn't it?
That is my understanding. Yes.
But they didn't seek to do that. Okay. All right. Thank you. And then just on page 15 of your submission, where this is the table where you provide complaints resolved by your body. So you've got the PwC item there, and I can see it's footnoted, and I've looked at those press releases. Then you've also got the KPMG item, which is no published decision. So just explain to me why in the PwC case are all the details publicly available and you confirm the case has been closed and the person is named, and in the KPMG instance that's not the case?
I think that matter, Senator, may have been covered prior to you joining this morning. The KPMG decision that's referenced there relates to the Tahi matter.
I think I caught it at the end of it when I think Senator Pocock asked you about it.
Correct.
Early on, yeah.
So where there's no decision, where there's no adverse finding, the bylaws preclude the publication of a decision, and on that basis, there is a limit to what can be said publicly. I am authorised, though, to...
But you are authorised to say the matter has been resolved?
Correct.
Okay. And that rule is in place, I presume, just to, protect the reputation of the innocent or make sure that people's do not suffer adverse consequences as a result of an accusation that's made against them that ultimately is not substantiated?
Correct.
Okay.
And while there's no adverse finding against a member, Senator, it's not appropriate to publicly name that member.
No, I respect that.
We encourage members to self-disclose, and it would be counterproductive to then publicly name those individuals that did nothing wrong. And again, there's a separation of powers between CANZ, similar to the government and the judiciary, between the independent conduct and disciplinary processes.
Yeah, understood. And just so I'm clear, because I caught the end of this, but with that KPMG case, you concluded that the member did not breach the Code of Ethics or the CANZ bylaws?
So the CANZ disciplinary bodies formed that view, yes.
Okay. And that is consistent, as I understand it, with the New South Wales ICAC's finding that there was no corrupt conduct in that investigation?
Senator, during its 2021 inquiry, the New South Wales Public Accountability Committee resolved to refer aspects of Tahi to the Independent Commission Against Corruption, and ICAC did not identify any evidence of corruption and discontinued its investigation.
Okay. So that's, I mean, obviously your involvement with this issue has terminated. There's no other ongoing or active investigations into this that you're aware of?
That's right.
Okay, all right.
While you're at KPMG, can I just...
No, I'm finished my block,
okay,
so you're free to chair.
I'll just jump on the KPMG discussion. My understanding is that the partner who was a registered auditor has been fined more than $10,000 by KPMG for using their technology in a training course about AI. More than two dozen KPMG personnel have used artificial intelligence to cheat on internal exams since July 2025, and a handful of first-year staff used AI to collude on internet training. What's the status of the investigation into the registered auditor for cheating with the use of AI?
So, as I mentioned earlier, Senator, that investigation is underway, along with 9 other self-disclosures that have been provided by 10 Chartered Accountants members that were identified by the firm as having improperly used
so
the
there was
AI
self-report and the status is ongoing?
There's 10 self-reports, 10 members involved or identified as being involved by the firm. 10 of those have self-reported, including 1 member who is a registered company auditor, and the PCC has, I'm instructed, the PCC has notified ASIC of the details of that registered company auditor, notwithstanding that the investigation is on foot, not yet concluded.
Okay, so what triggered that notification when there seems to be some uncertainty about who lets whom know what's going on and when? So our bylaws were, as part of the PCFR, amended and introduced new, clearer provisions around the notification to third parties. So bylaw 40.37, for those who are inclined to go and have a look at it, does allow the PCC now and other disciplinary bodies to notify any third party at any stage of a complaint where it's in the public interest to do so or where there's a legal permission to do so. So the TPB, for example, ASIC, an employer, any other person who the PCC considers ought to know. Over the last 12 months, our PCC and disciplinary bodies have notified external parties in relation to 27 matters. 22 of those matters members were referred to the Tax Practitioners Board, 8 were to ASIC. We had referrals to the Victorian Police, we had referrals to the Office of the Registrar of Indigenous Corporations, we had 1 referral to the PCAOB. So there is an active referral Could you provide
process.
on notice a breakdown of those matters with some descriptions for the committee to understand where they are? And can I ask if you have any indication of intersection between Chartered Accountants Australia New Zealand and the matters about Westpac, ANZ and National Australia Bank with regard to lawyers and accountants enabling fraudulent acquisition of loans? Are they before you? Are they connected to you?
So I can say, I can take that on notice. I would like to comment though on the fraudulent loan applications point, because that obviously is a current matter, with the Commonwealth Bank having raised the alarm, if you like, with AUSTRAC and others. We are closely monitoring the reports and what's happening in that space. At this stage, none of the accountants and none of the information that's available to us suggests that any chartered accountants are involved. However, we'll keep an eye on that. We have written to the Commonwealth Bank and we've made the Commonwealth Bank aware of our jurisdiction in relation to chartered accountants. However, given that it is a police matter, I expect that that process will be respected and allowed to be concluded. We have obviously taken this as an opportunity to remind all of our members of their obligations to comply with the law at all times. Any member who is charged with a serious criminal offence, which includes fraud, is required to self-disclose to chartered accountants, to the PCC, in accordance with our bylaws.
I love the etiquette of that, but I put it to you, if the police are investigating you and you're part of a criminal gang that is sophisticated enough with knowledge from accountants and lawyers to go in and rip off 3 of the 4 big banks in Australia to the tune of hundreds of millions of dollars, you're hardly likely to have the character to self-report to Cairns for fear of a massive fine of $15,000.
We see this as an opportunity to remind all of our members of their obligations, not only to act lawfully and ethically, but also to be very aware of the risks of identity theft, the risks of AI misuse in their own practices, or the risks of their own credentials being misappropriated by any third parties to fraudulently obtain loans with financial institutions.
So many more questions, but if I can go to Senator Pocock for another round of 15 minutes, if you're able to.
Thanks,
stay
Chair.
with us. Thank you.
Yes. Great, thank you. And I feel that we've heard this morning about some really important things for this committee to consider. We've certainly heard about holes in the regulatory framework which allow for scoundrels to forum shop, essentially, to maintain some kind of professional status despite serious misdemeanours. And I feel like we've also heard very clearly that the fines available to you under current arrangements are very small in size, and that there is a role for lawmakers to enable a larger pursuit of significant financial penalty. A $17,000 fine if you're receiving $4 million income just doesn't cut it. But I want to go to a third thing, and then I have some other questions as well. Is it the case that any consultant or Australian consulting company can cap their liability through the accounting scheme, or is it access effectively restricted to those in the very large Big Four and a small number of very large multidisciplinary firms? Given the way the system operates, is that effectively what is granted here in relation to the cap?
So the scheme, Senator, applies to about 30,000 of our 140,000 members, and they are those that are in chartered accounting firms, and apply if they are a partner or have signing authority. Then they'll also be encompassed through our affiliate program and be required to adhere to our code of ethics and be accountable to that code of ethics, as you've heard earlier from Ms Chapman in relation to some of the actions we've taken in the past in relation to affiliates. The caps that you mentioned, 75 million and 25 million, depending on the services rendered, are subject to actuarial advice and reference to historical claims data as well. The primary aim of the scheme in this case is to ensure that those members of the public who are receiving advice from a chartered accountant who is a member of the scheme, that they will know, or they may not know, but they will have the benefit of mandatory professional indemnity insurance, so that in the event that anything goes wrong, they can claim against that insurance. Now, when you look at the wider consulting sector that are not members of chartered accountants and are not CA firms, the protection to that consumer of their services is entirely within the contracting negotiations of that party, i.e. it's subject to the terms of engagement between that consultant at large versus the client. And there may or may not be anything in that engagement contract that says there must be mandatory professional indemnity insurance. However, with our members, they are required to provide a certificate of currency. It's one of the improvements that we've made in the last year, that we now do active verification of that certificate of currency to ensure that they have sufficient protections.
For every member? We do it for or as a sample?
The insurance certificates are provided at the firm level. So the firm takes out insurance for the firm as a whole. And so we obtain certificates of currency from every practice.
But how is it, I want to continue my questioning here, how is it in the public interest to have only consultants in very large firms covered by these caps, and not the very large and significant group of consultants, the number, outside the Big Four firms? Isn't it a very unfair circumstance? You're telling me there are particular criteria they need to meet to be inside that coverage. I take that, I'm not arguing about that. But what we have here is a very selective access to that important caps for being sued, which are very significant for big consulting firms and their individual consultants.
And increases consumer protection for the users of those services, which is the primary aim of the schemes.
So if I might...
I know that's your argument, but I'm raising the question of how is the public interest served by such partial access to the caps, which privileges consultants in very large firms?
So, Senator, I'd like to answer that if I may. In 2004, the Professional Standards Act in New South Wales and subsequently in other states was amended to amend the definition of occupational association so that it covered, for each occupational association, the primary and also the ancillary professional services offered by principals and partners within that practice or within that, within the occupational group. We take the position that professional standards legislation, and we've outlined this in our submission to the committee, professional standards legislation extends a very well-established common law principle, which is that contracting parties negotiate to limit their liabilities to each other. Most contracts between consulting firms who operate outside of schemes will limit liability to their clients by reference to a calculated formula or to fees paid or to some other amount. Invariably, they exclude consequential loss. The idea that contracting parties are exposed to each other for consequential losses is in practical terms, unlikely. What professional standards legislation does, it says you can do what you would do contractually, i.e. cap your losses to a higher amount, to an amount that we calculate to be actuarially responsible and appropriate. However, you must be a member of a professional association that holds you to account if a complaint is made about you, and that you will have mandatory professional indemnity insurance to meet those claims. In 2004, when these legislative amendments were made, or late 90s, insurance companies were folding and going under, and consumers were left without recourse to insurance proceeds. This is a stabilising instrument. It stabilises the insurance market, it stabilises the professional services market, and it ensures that consumers do have access to appropriate protections. And as Ms Van Onselen has said, it's not large firms, it is all of our members in public practice, all 33,000 of them.
I'll leave aside the argument there, but I want to go to page 5 of your submission today, which we've already spoken about, the 13 months of data about complaints. And I would like to ask you, on notice, if you could supply by firm, a large firm, the total complaints received, total complaints resolved, the court, and then the nature of the outcome from the PCC, the Professional Conduct Committee, by firm, and also by whether the matter has been relating to an accounting or audit function or a consulting or affiliate action. So I'd like to seek that on notice, please. I notice on page 15, you do break it down by 4 large firms in terms of complaints resolved by the Disciplinary Tribunal or Appeals Council. I would like it by the 6 firms, please, on notice. And can you remind us of who is in your group of 6 large firms? EY, KPMG, Deloitte, PwC, and you said 2 others.
Grant Thornton and BDO. However, there are
2 other large ones that were mentioned earlier. Findex
and RSM are 2 firms which now, by revenue, are probably larger than some of the others.
So there are 8 firms in your bucket of large firms, is that correct?
Our definition of large firms for the purposes of this information request is limited to the 6 firms that you've asked about.
Okay.
We're very happy to provide data
in due course.
If you could give it the breakdowns I have sought by those firms, that would be appreciated. I wanted to go to the question of exams and students in the recent audit and risk exam experience. I understand there was a real problem in this exam, and it's been spoken of and public discussion has unfolded. Affected students in that recent exam said that the problems, that they had repeated difficulties completing the exam, that I understand CANS informed them problems would be fixed. Many people sat online for hours and later learned it was unresolvable. And so students were also directed to call Janison, I understand, who might have been, correct me if I'm wrong, the source of the platform. Will CANS, what was behind the mixed messaging from CANS to students who were sitting that audit and risk exam?
Thank you, Senator, for the question. And first and foremost, I apologise to the candidates affected for the frustration and disappointment that was caused, especially after their significant preparation. On 10 March, approximately 2,000 candidates were scheduled to sit the audit and risk exam. 600 were able to complete the exam, but 1,416 could not get in via the identification platform. Shortly after commencement, many candidates experienced technical issues caused by a failure in a third-party exam platform. Based on the advice that we received by our third-party providers that the issue would be resolved quickly, candidates were advised that the vendor was working to fix the problem with the aim of allowing the exam to proceed, even if delayed. When it was clear that the issue could not be resolved fairly for all, CANZ made the difficult decision to stop the exam. Around one-third of the candidates, as I mentioned, were able to complete it. Candidates were updated every 15 to 20 minutes via SMS and our website. Within 24 hours, CANZ confirmed remediation options that balanced empathy for disruption with regulatory, academic and integrity requirements. These options included alternative exam arrangements with support or withdrawal without academic or financial penalty and special considering applying. Yesterday, 1 week later, 1,224 candidates sat the exam successfully. The balance of 192 are either going to sit the alternative exam on 22 April, opt to withdraw with no financial penalty, or are still deciding. A special out-of-timetable audit and risk offering will be available next term for candidates unable to progress this term. CANZ requires a formal audit and risk exam to meet accreditation and integrity requirements, and for that reason and to maintain fairness, an ungraded pass or take-home exam was not appropriate. CANZ has engaged with employers seeking their support for affected candidates. In more than 5 years and almost 120,000 online exams with this provider, we have not experienced an issue of this scale. We continue to engage with the provider, and I'll be meeting with the 2 CEOs in question in the next 2 weeks.
What's the name of the company you're dealing with?
So Janison is the third-party provider, but the platform that failed was a provider that they engage, which is ProctorTrack. It's commonly used throughout the university system and also for across the world.
Will you seek compensation from Janison?
At this stage, due to the commercial sensitivities, we couldn't comment further on that, but we are having active discussions with the providers.
Will you keep using them?
That is yet to be determined. We're in the midst of a full root cause analysis and post-implementation review.
Last question, Senator Pocock.
I've got a few more.
I think we both have. We're renowned for that, Senator Pocock.
So will you compensate affected students who've had to take time off? And have you formally reported these systemic failures to TEXA, and has TEXA reviewed whether your current solutions remain fit for purpose? So compensation and TEXA.
Yeah, so TEXA regularly reviews our framework. We've received unconditional approval to 2031. We provide annual reporting and attestation as well, and they are satisfied with the CA program overall and the platforms that we use. But we will be working actively with those providers to ensure that hopefully this does not happen again.
And compensation for students who have been disadvantaged now have to study at length before a subsequent taking leave to sit the exam? Any consideration of that?
Well, we've provided them with an alternate exam within 7 days of the previous matter. and that is something that we are not contemplating at this stage. It's not appropriate.
Last question. I've heard complaints from students that the quality of their experience and the teaching they're receiving from your courses are suboptimal. Very short videos, textbooks years out of date. How is CANS justifying this kind of delivery model, and what are you going to do about the quality of your teaching? Do you see it as an issue, and what remediation are you doing?
Thanks for the question, Senator. The CA program takes a best practice approach to professionally aligned learning that avoids long and passive lectures. In our most recent annual student survey, 80% of respondents reported being either extremely or somewhat satisfied with their overall learning experience. All learning materials are reviewed annually and updated to reflect current professional standards and legislation, including requirements set by the Australian Tertiary Education Quality and Standards Agency, TEQSA, and also the International Federation of Accountants, IFAC, the global peak body for the accounting profession. Learning is delivered through guided weekly activities, applied case studies, assessment-aligned practice material, and supported with discussion forums and access to experienced facilitators and experts, including practising members. The program is also designed to be flexible, to allow candidates the ability to juggle the demands of the course with work or other commitments.
So no problem? You think there are no problems here?
It's regularly reviewed and assessed.
Thank you. Thanks, Senator Pocock. We have a couple of 5-minute blocks and then one final set of 5 minutes from myself to finish, and we'll then be able to release you. Thank you for your perseverance. I'll go now to Senator Sharma.
Thank you, Chair. Just brief, I just wanted to clarify something. Your relationship with CA New Zealand, if I'm describing that right, so they are part of CAA NZ?
Correct. We had a merger in approximately 2014 that was in effect in 2015.
Okay. But as I understand it, CA New Zealand has statutory regulatory powers that you do not enjoy in Australia. Is that right?
Correct, including over auditors.
Okay. So when people are saying, well, why aren't you doing what CA New Zealand's doing, it's because you sit in with respect to Australia, you have quite a different set of powers available.
Correct, that's right, yeah.
You don't have any legislative powers, right?
That's right. So we report to the FMA in New Zealand and provide oversight not only of auditors but also insolvency practitioners. Be more than happy to do so for the Australian government if it was so inclined.
Okay. And then just a few of my colleagues have been mentioning the public interest. I don't expect you to ignore the public interest, but you're actually not mandated to enforce or look after the public interest. I mean, you're a membership body, is that right? You're there to serve the interests of your members and not act contrary to the public interest, but there's no statutory or other legislative instrument that says you must be enforcing the public interest, for want of a better term.
No, Senator, but our bylaws do talk about our advocacy being in the public interest, and we don't see those as necessarily mutually exclusive.
No, I can understand that. I don't think it's fair for us to expect you to do things that you don't actually have the powers or the legislative footing to do, though. That was all for me.
Thank you very much. And Ms Lawrence, five minutes if you wish now. You have the call.
Sorry about that. Thank you. I just had you on mute there. I just wanted to go at just a very high level in the interest of time, just whether you had any comments in response to ASIC's findings that many auditors are failing to demonstrate compliance with auditor independence obligations, and also just around the extent to which auditors are identifying red flags and reporting them to ASIC, to the extent to which you have data around where they're carrying out those obligations?
If I may, the ASIC released audit findings in October of last year. It's important to put those reports into context. They're designed to probe and challenge, to reveal insights and focus areas to improve audit and reporting, and that's what the 2025 reports have done. Both external and internal assessments of investor confidence in audit remains very, very strong. Edelman Trust Survey, a global study that has been undertaken since 2017, shows that chartered accountants in particular are the third most trusted profession in the world, just behind doctors and engineers, and that is well above the term accountant, which is about 7th or 8th on that list. We've also seen trust in chartered accountants increase year on year. In 2025, ASIC expanded its work from corporate reporting and audit to encompass registered superannuation entities and did a deep dive on independence. The reports are risk-based, honing on issues rather than providing a generalised assessment or conclusion on audit quality in Australia. Our annual, or at least regular, audit investor confidence survey that we do shows very strong confidence in audit in Australia by investors. Our approach to the ASIC findings each year is to engage with ASIC, who I believe will be on this afternoon, so that we fully understand and can also properly incorporate their findings into our work. We're making sure that ASIC's focus and messaging cuts through to our auditor members on the ground, and that they are also taken seriously by our members. We do this via an annual audit and accounting conference, webinars focused on current reporting and assurance issues, and regulator findings, guidance and CPD requirements. And we use those findings from ASIC to inform our advocacy on reporting and audit standard setting and regulation, as well as our research and thought leadership activities. We value the insights that ASIC provides to the profession each year, and we should be concerned if they don't identify findings and areas which require areas of focus for improvement.
Ms Lawrence.
Thank you. Unfortunately, the very tail end there did cut out. And I did ask for a broad, feedback, so thank you for that. I guess I would have been interested more to run you agreed with their findings, that, their disappointment about the underreporting, the concerns around independence, self-breaching, just sense that actually, appreciate the trust factor, but what are you seeing amongst your membership around the extent? Do you have some data to point to? Is there any kind of loop that you are then privy to understanding the extent to which red flags are reported to ASIC, the independence issues managed? What data or what are you looking at to back in the overarching statements around trust and assurance?
Perhaps I can answer that, Ms Lawrence. It's Vanessa Chapman. So we take all of the findings from the ASIC reports and incorporate them into our practice quality review program. The findings against the number of, the relatively small number of auditors that ASIC looked at are salutary, and they provide really important reminders and risk scenarios for members more broadly. So we incorporate those into our quality review program. Our quality review program results are reported in our annual professional standards regulation and conduct report. Satisfactory findings remain reasonably high at 85%. Where we do find issues, we ensure there's remediation by practices within a reasonable time period. So they're complementary activities in that regard, and we certainly take the ASIC reports on the basis in which they're provided, which is well established and well outlined in the reports themselves.
Thanks, Chair.
Thanks, Ms Lawrence. Just a couple of quick ones to finish off. Could I go to page 14 of your report? If I can go down to the final point there, consent order with a footnote number 14 on page 14. PCC, outcomes, large firms. What does PCC stand for in that context? PCC, outcomes, large firms.
So that's Professional Conduct Committee.
Thank you very much. So the consent order number for that is 3 in the years, calendar years 19 to November 2024. There's only one published decision and 2 ASIC referrals. I see you've got note 15 over. Could you just break that out for me and give me a sense of, what can you do about the 2 that are not disclosed?
So the consent orders were made in relation to 4 complaints. Often there might be 3 members and 4 complaints, so one member may have 2 complaints against them. In this particular case, consent orders are not generally published. Occasionally the PCC will publish a decision where a consent order has been entered into in order to ensure that that the membership's aware of an issue more broadly. But in this particular case, as the numbers show, as the table shows, there were 2 of those consent orders resulted in referrals to ASIC and 1 published decision, which at footnote 15 is the published decision in relation to a provisional member at BDO who engaged in academic misconduct, and that decision is published and it's on the ASIC on our website.
Excellent. Okay, so can I deduce from what you just said that the consent order of 3, 2 of them may be connected to is it the first one? Sorry, was that BDO? No. Who's the one that's public?
The BDO provisional member. So
are there 2 matters for BDO?
No, there's 1 matter for BDO.
Okay,
the others
so
do not relate to published decisions. They relate to unpublished decisions. I can take that on notice and give the committee more information.
And I guess the question is, when the PCC makes a decision about whether to make these things public or not, what is the schedule of considerations that are given to making that decision? I mean, given you have so few powers and such limited amounts of money to be able to provide incentives for people to stay within the lines, it seems extraordinary to me that when there are findings that they are not made public. So, what's the consideration? On notice if you can, because the time's lagging and I'm sure you have to get on and we've got other witnesses. Could I quickly just go to matters with regard to Deloitte and corporate travel management that went undetected during PwC's 14-year tenure as auditor? Have you any views as CANS with the systemic weakness of audit quality, professional scepticism amongst large firms, and particularly with regard to prolonged engagement such as that matter of 14 years, even with rotation by large entities such as PwC, KPMG, EY and Deloitte?
So we'll take I will reiterate the point I made in relation to ASIC's report 816, 81 and 819. Long tenured and rotation and independence are critical. They're fundamental features.
Yep.
So
there's a sweet point
there is no argument about that, and the independence rules are reasonably prescriptive. They're prescriptive and they should be well understood. In terms of corporate travel in particular, I will observe that there are a number of matters on foot and that there may well be public findings in relation to those matters. Where there are matters on foot, we obviously have notice of those. I mentioned earlier that the Professional Conduct Committee maintains an active monitoring oversight of external matters and currently has about 1,100 monitoring files. To the extent that matters like this are in the public domain, the Professional Conduct Committee is monitoring and actively considering and inquiring into whether there's a disciplinary action required to be taken.
So perhaps on notice then, what action should or could be taken by your professional body when a successor auditor identifies apparent deficiencies in a predecessor's audit work. So if you could clearly outline that for the committee on notice, that would be helpful.
Just one final... could add some additional flavour.
If you would do it on notice, Ms Van Olsen, I'm about to let you go, but I just want to ask one final set of questions given the growing influence of private equity and foreign ownership in Australia. This goes in particular to issues in the public place around Grant Thornton. Who takes precedence when ethical obligations conflict with investor expectation? Professional standards or financial performance?
So there is a rise of private equity investment in accounting firms across the world. It's something that we're actively monitoring. My colleague Geraldine McGarry is actually on the IFAC private equity subcommittee monitoring this. There's been a rapid increase in the US and in Europe and UK, and we're now seeing it on our shores.
Yes.
It's something that we're actively monitoring. AICPA in America, for example, currently have out for public consultation that, almost exactly to your question, that input in terms of ethics versus private equity and financial interests. What we have informed our members, and will continue to do so, is that their primary obligation as members as ours is to adhere to APES 1110, which is the Code of Ethics. And so issues such as confidentiality, integrity, competency, honesty, etc., all still remain with that member whilst they are a member of CA. And if it's a CA firm, then it certainly attends to that as well.
I guess we're seeing really the level of tension now mounting. I think this is a sector where this committee certainly has found standards to be wanting. Today we've confirmed regulatory gaps, community expectations about management, excuse me, and supervision and policing and fines and dissuasion in the sector. I don't think meet community standards at this point. And now we have the added burden of, will I keep my CANS membership and the access that gives me to the profession, or will I keep my job and deliver profit, which we have seen has driven terribly aberrant behaviours to the level that I would consider, treasonous to our nation, in the case of Mr Peter John Collins.
One of the reasons, which is probably a pro factor for private equity investment in accounting firms, is what they deliver is much needed capital to invest in technology.
Yes.
So be that AI,
but will that tail wag the
automation.
dog, Ms Van Olsen, is the question I think that needs a considered response, and I'm pleased to hear that you are in conversation with your international partners. Has any regulator concluded that private equity ownership is compatible with the profession's duties to act in the public interest, or has that simply been assumed as the market is emerging?
There has been no regulator pronouncement of that type. As Ms Van Onselen said, the the standard-setting boards, the APES board, for example, has considered private equity, and we can take it on notice to provide copies of the pronouncements that it has put out around private equity.
Have you made any public comments or even private representations about the levels of transparency that's required in the public place, so that both clients and regulators can know who truly controls these firms?
We've been fairly consistent in terms of advocating in favour of transparency, and particularly having ASIC potentially using the transparency reporting provisions of the Corporations Act to set a standard or to set a set of requirements around reporting. I might defer to my colleague Ms McGarry in terms of the particular question.
Thank you. So you've travelled all the way, Mrs McGarry. It's great to actually get you on the record.
Thank you, Senator. I would add that the International Organisation of Securities Regulators, which ASIC is part of, is conducting a review into private equity and the profession.
If you want to go through the break, I can just get you up.
That's all right. Thank you very much. If I can conclude with these two, and perhaps they might need to be on notice. Should accounting firms with private equity ownership be subject to stronger disclosure, more determined and clear oversight, or other ethical requirements than traditional partnerships, which we've already seen as a structure is not particularly edifying once you get inside and see the failure of the notion of joint and several liability? Do you have a view about that?
So generally, as a professional membership body, we're agnostic in terms of firm structure, so whether that's by corporation, partnership or sole trader. So I don't really have much to add there, other than to say what I mentioned before is that what private equity is doing is enabling particularly small, medium businesses and practices to be able to have the technology that they can invest in order to keep up with changing times and evolving technology needs. So there is
which is
benefit there
a
as
range
well.
of things, including AI, which has been the subject of some discussion and considerable acceptance that there's risk involved in it. It's part of the world that we've got to come to terms with, but there's another risk. And finally, if you could give consideration to this on notice, at what point does consolidation and investor ownership become a threat to competition and independent professional judgment? Any insights that you have, anything that the board's considering with regard to that would be helpful.
Well, I think we can take that on notice, but certainly we would observe that that is a question of the same type as the previous question around independence. Our members have professional obligations under the Code of Ethics, under the firm, under pronouncements issued by the standard setters that they must comply with, regardless of whether they are practising within a traditional accounting firm, partnership, or whether they're an employee effectively within a corporation or whether they're a sole trader. Those obligations are non-negotiable, and particularly in relation to the regulated services such as audit, tax, insolvency.
And can I just point out that we come full circle. The word should and expectations about compliance with those ethical standards were clearly not met by Mr O'Shea, and yet he continues to be registered with the Tax Practitioner Board, and not only with the Tax Practitioner Board, but also with some legal entities, which I'll have more to say about a little later on. Can I thank our colleagues for your engagement? I think it's been a very interesting session this morning. We'll take a break now for 15 minutes and return with the CPA at 1:45, and we will try to get back on schedule as promptly as possible. Thank you.
Do you want that back?
No, for you.
I'm going to be.
Okay. The committee will resume with representatives from CPA Australia. I'll just check to see who we have online. If we have any colleagues
I think Paul Scar's online.
Coming in. So Senator Scar is still with us. And with that noted, I'll proceed. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. I understand Ms Lawrence is with us, Senator Scar online and here in the room for those who are distant. We have Mr Moncrieff, myself, Deborah O'Neill, the Honourable Scott Buchholz and Senator Dave Sharma. For the Hansard record, will you please state your full names and the capacity in which you appear today? We might start with you, Mr Pinto.
Yeah, thank you. Dale Pinto. I'm the President and Chair of the Board of CPA Australia.
Eleanor Cassipedes, Chief of Policy, Standards and External Affairs.
Chris Freeland, the CEO of CPA Australia.
Warren Slade, General Counsel, Company Secretary, Head of Risk Compliance and Professional Conduct.
Melissa Reid, Head of Professional Standards for CPA Australia.
Thank you very much. I now invite you to make a short opening statement and the conclusion of remarks. I will ask members of the committee to proceed with questions. Over to you, Mr Freeland.
Yes, thank you. Thank you, Senators and members, for the opportunity to appear before the committee today. As I said, I'm Chris Freeland. I'm the CEO of CPA Australia. I've been in this role just on 2 years, having previously practiced as a corporate lawyer, a strategy consultant, and in leadership positions in professional service firms in Australia and Asia. As you've heard, here with me today is our Chair and President Dale Pinto, who's a Fellow of CPA and has more than 30 years' experience in professional accounting and taxation law. Eleanor Cassipedes, who's the Chief of our Policy, Standards and External Affairs. To my right, Warren Slade, our Company Secretary, General Counsel and Head of Risk and Compliance. Warren oversees our Professional Conduct Unit. And Melissa Reid, who's also a Fellow CPA, FCPA, and our Head of Professional Standards, whose responsibilities include the Best Practice Program and Continuing Professional Development Review Program. I want to start by acknowledging that the trust that communities, corporations and governments place in CPA Australia members and, by extension, our organisation every day. We welcome the opportunity to share CPA Australia's 2024 Annual Professional Standards Report and discuss how we support professional standards through our Best Practice Program, the mandatory quality assurance program required to obtain a public practice certificate, our CPD reviews and regulatory compliance activities. This year we successfully piloted firm-only assessments focused on professional and ethical obligations, improved targeting of assessments to focus on members engaged in higher risk activities, made substantive updates to the public practice program content in areas including AI and cybersecurity, and introduced stronger measures to ensure new PPC holders fully understand risk and quality management systems before they start their own practices. As you'll see from our report, CPA Australia has 176,000 members working across 100 jurisdictions. The vast majority of our public practice certificate holders own or work in small and medium-sized practices, with just 27 working in the 6 largest firms. We welcome the opportunity to discuss our report and questions on any related aspect of interest to the committee, but first I'll invite Professor Pinto to say a few words as well.
Great. Thanks, Mr Freeland. Senators and members, I'd just like to add briefly 2 points to the CEO's opening statement. First, together with the most senior CPA executives present today, I appear before you as Chair and President of the Board to really emphasise how seriously our Board views this matter. Upholding ethics and professional standards is essential not only for CPA Australia and our members, but also for the integrity of our profession and more broadly the trust the public places in us. Second, that commitment is captured in a single word at the heart of our crest, which is integrity. And this is not just symbolic, it is the standard we expect, the standard we enforce, and the standard the community rightfully should expect of us. Thank you. We are prepared to answer any questions you have for us.
Thank you very much. Senator Scarr, if you're ready, I'll go directly to you.
Thank you, Chair. I just have a few questions. We heard from previous witnesses in relation to fines which can be imposed by Chartered Accountants Australia and New Zealand. What's the practice in relation to the CPAs?
Thanks for the question. So CPA has a very rigorous ecosystem of clear standards, education in relation to what the requirements of those standards are, and monitoring of compliance with those standards, and taking action where there's been a failure to comply with those standards. Where there has been a failure, it's referred to our professional conduct unit. If necessary, it then goes to our disciplinary tribunal, which is an independent body to make a determination regarding the matter to which it's been referred. That disciplinary tribunal is overseen by a further independent body, the Professional Conduct Oversight Panel, PCOP. The disciplinary tribunal, as I say, is independent. It can levy fines of up to $100,000, but they have other actions that they can take, and the most significant of which is forfeiture of their membership. And I say that is, in our case, perhaps the most significant thing. The value to our members is our designation. The vast majority of our public practice certificate holders work in small enterprises. They have 1 or 2 partners. To lose their designation as a CPA is a disaster for their career. That is a very significant impact on them. So that, for us, that's the ultimate sanction, but we can levy monetary fines of up to $100,000.
Okay. In relation to flow of information between CPA and regulators and other professional standards bodies, what's the policy principles which the CPAs have in place with respect to alerting other stakeholders with respect to especially egregious conduct once it comes to the attention of the CPAs?
Yeah, we're in open dialogue with other relevant regulatory bodies, in particular ASIC, and I note, for example, just recently that I had a meeting with Kate O'Rourke, the Deputy Commissioner of ASIC, with my colleague Eleanor next to me, and that included a discussion about how can we do even more in this space. So it's something that we're proactively involved in, but also with other regulatory bodies, and we do communicate with the other professional bodies in relation to disciplinary matters through the statement of fit and proper purpose, but I might pass to my colleague Warren to answer more.
Yeah, thank you, Chris. I can confirm we had 11 referrals from the Tax Practitioners Board. We received information about members from investigations they were undertaking. We opened 13 complaints following ASIC media releases. We have an active media watch. for any of our members that are published in media articles or in statements of disciplinary action by any of the regulators as well. We also share information of outcomes with the regulators once the disciplinary tribunal has handed down a decision. In addition to that, where we know there's a dual member, we also notify the other professional body that we've disciplined one of our members so that they're aware of it as well.
So are you actually waiting for media releases by ASIC to be alerted with respect to investigations, outcomes of investigations undertaken by ASIC? Does ASIC have a practice of giving you information separate from you obtaining publicly available information available on media releases?
Yeah, that's correct. That's generally the practice. What I would add, though, is since the hearing of this forum last year, there have been more regular interactions. There was a meeting between CPA Australia and ASIC a couple of weeks ago, just looking at ways to further explore how we share information about members who come before both bodies and how the flow of that information can be more expedient and where we can share intelligence and trends and those sorts of things as well. So at this stage, generally speaking, it is from media releases and the like, but we are exploring ways to try and improve that.
To add to that as well, the recent amendments to the Tax Administration Act and the Tax Agent Services Act, which enable the prescription of prescribed disciplinary bodies under that legislation for information sharing bilaterally. We are currently in discussions with Treasury about progressing the proposed legislative instrument that would enable us to do that in that space.
Okay, excellent. There was some questions asked of the previous witnesses in relation to the introduction of private equity into accounting practices. The explanation was given that this assists to provide capital with respect to accessing technology. Different bodies around the world are looking at this phenomenon. I'm interested to see what our witnesses have to say in relation to this issue of private equity, access to private equity.
Mr. Freeland. Sorry, I'll name you because it's easier for me.
Sorry.
Mr. Freeland.
Okay, thank you. Just to add, we're a member of IFAC, the International Federation of Accountants, which my counterpart from CANZ mentioned earlier. So we've been privy to and involved in some of the discussions going on at a global level regarding private equity, which certainly throws up a number of tricky issues for the accounting profession. But Eleanor, please go on.
Yes, certainly. Thank you. So Eleanor Cassapetes here. We are regularly engaging with IFAC, the Small to Medium Practices Group, which is looking at the evolution of capital funding structures across the profession, and the International Ethics Standards Board has also been conducting desktop research, and we're involved in those projects. We don't prescribe how a firm might be structured. Our membership is focused on the individual CPA designation and the public practice certificate holders. We note that private credit more generally, as well as private equity, is a challenge. So to the extent that we are making submissions on consultations being initiated by Treasury and looking at how firms might be structured from a capital point of view. What we would emphasise, though, is that the Code of Ethics, the requirements to have things like systems of quality management, to manage conflicts of interest, and all of those fundamental principles remain at the core of how we approach our members and their firms.
And if I can add, those obligations around ethics, particularly compliance with APEs, do not change, irrespective of the ownership structure for our members.
Yeah, no, understood. At the same time, though, you mentioned it raised some tricky issues, and I think that was the phrase you used. From your perspective, what are the issues that need to be considered?
Well, I think that was the issue that was flagged, and having been a lawyer previously, I know the same issue was raised in the context of the legal profession about where does your duty lie, and it's a tricky issue, but there's a clear-cut answer, certainly in our opinion, which is the primary, ethics do not change. The ethics obligations remain constant. So it may appear tricky, but that's the position.
No, good answer. I'm satisfied with that answer and happy to share the call, Chair.
Thank you very much. I'll give the call now to Mr Moncrief.
Thank you, Chair. So last time the CPAA was before this committee, it was acknowledged that there were gaps in the self-regulatory scheme. I think that was in response to a Treasury paper in relation to the consulting industry. And I think you said that you were supportive of conversations to address those gaps. I just wonder whether those conversations have occurred. I know you spoke earlier about your engagements with ASIC. Were those conversations had with ASIC or with other regulatory bodies, or have those been ongoing?
Thanks for the question. I'll pass to Eleanor.
Thank you. So the construction of the statutory framework for the regulation of professional services really is a policy framing decision. While we do talk with the Tax Office, Tax Practitioners Board, ASIC, about how the implementation of existing law and how we can resolve those issues is ongoing, we do feed into the Treasury consultation cycle. What I would say is that we reiterate our position, which is what is the problem you're trying to solve? Mm-hmm. Who is it that you're trying to regulate? We noted at the time, and we continue to note, that the term accountant is not a regulated term. Consultants come from a far broader range of backgrounds than just qualified accountants. So the discussion and the conversation needs to be led by government, and we are open to consultations about where are those specific gaps. What I would say is that the Treasury paper from several years ago really highlighted that professional services in tax, insolvency, audit, financial advice already have those regulatory frameworks. So it's a broader conversation around who is it that is participating, what is the risk of harm to the public, and how would we define the participants in that environment, and then what would be the appropriate level of licensing and regulation.
So do you have a view on what should be the appropriate level of licensing and registration?
Our membership, so the accounting professional goes beyond just public practitioners. So we have many members in corporate, in the public service, in not-for-profit. Our view is that currently the framework has identified the right kinds of targeted professional services that are at the highest need of regulation. The question really is, can the existing frameworks adapt to the new risks, for example, around private credit or I guess you can say insolvency or consulting, or is there a demonstrated higher level of scrutiny that is required? Again, though, when you introduce a new regulatory regime, it does need to be targeted, it needs to be appropriate, and it needs to recognise the diversity of skill sets and professions that might be participating in that part of the sector.
Great, excellent. Just wanted to go to the CPD, Continuing Professional Development. Just in relation to this assessment for compliance, what sort of data do you gather about whether people are completing this? And you spoke, as this in the last time you spoke for this committee, around saying that AI was one of the major challenges as well. So in a world with AI, how are you going about making sure that these assessments are done appropriately?
I'll pass to my colleague Melissa in the first instance.
So with respect to our members' obligations for CPD, they have very clear obligations which we've previously shared with the committee and are within our bylaws. Mm-hmm. So within our membership, our members need to tell us on renewal each year that they are continuing to meet those obligations. That's first and foremost their membership obligation with us on annual renewal. Second to that, we conduct an annual CPD review of a sample of our members. Now that sample is skewed to members that we are monitoring across our data to be a higher risk of non-compliance. So we are intentionally analysing our membership to make sure that we are targeting members where we can see from our information that they haven't been recording within our ecosystem, CPD. It doesn't mean they're not, and in most cases they are, but they're using alternative record methods. So we target that population each year and we request that they provide us information.
So you're saying, the measurement that you're using for the higher risk are the people that aren't reporting the CPD to you?
Yeah, so we have a CPD diary that our members are able to use and help them track their obligations. That diary is linked to the products or the services that we provide our membership. We have an extensive PD offer, and when they engage with our services, it automatically populates to their diary. So it's a member benefit and it helps them to be tracking their compliance. Obviously, not all of the CPD they undertake will be with us as a membership body, and so it's up to them to either keep our CPD diary up to date or maintain other records. So when requested, they are required to provide us with sufficient and appropriate information that demonstrates that they have met their obligation to us as a member.
So if you've got someone that is not behaving up to the standards that you would expect of someone that is a member of this professional body.
Yes.
I would think that those people are more likely to be not honestly reporting their CPD requirements than those that are meeting those high standards. Correct?
That would be a risk factor. Yes.
So, is there any consideration given to whether?
Yes.
Whether how to address the ones that aren't meeting those high standards that you rightly expect of your members?
Yes, so the answer to that is twofold. Obviously, as I said, we are looking where we can see already within our members' diaries that they are undertaking extensive PD. We see that as a lower risk of their compliance, and we're not going to spend our compliance effort focusing on those members. But that's not the only driver. When we know that there are members that have had complaints through conduct, where we know that we've had concerns about their quality when we've done best practice reviews, which do also include a review of their CPD, we will flag those members. Where they have previously been non-compliant with their CPD, they will remain higher risk and are more likely to be audited again within quick succession to make sure that they are meeting their obligations. So the other risk factors are brought into that risk model.
Right, okay, great.
And on the AI...
On AI, I can give you a little bit of information on that quickly, if you like. So our approach, firstly, is, as Senator O'Neill indicated earlier, this is the world we're in now. So our approach is firmly on responsible usage of AI. Technology will continue to evolve, but ethics will endure. So that underlies our approach. And we view it in the same way Excel is a tool, AI is a tool, and we therefore still emphasise that you need human oversight, professional judgment, professional scepticism, and ultimately accountants are responsible, people are responsible, so you can use whatever tool you want, but it's a person who has to sign off on it. In a practical sense, how we've operationalised that, we've currently got some 17 AI products to help our members, including for public practitioners in the public practice program, AI governance and cyber security. So we're not just concerned about teaching people how to use AI, but teaching them how to govern properly and use it responsibly. We've obviously got core courses in AI and accounting, AI tools for accountants, regulatory compliance and so on. We've got a separate micro-credential on ethics and AI for our members, and I'll share that all board members have done this course as well. And we've got broader offerings in partnership with institutions including the University of Sydney on AI fluency and governance. And again, the whole board's been through this because we're sitting around the board table, so we have to be confident that we understand what the needs are and what the risk factors are. But we're on a journey with this, but we've made, I think, a good start, not just to teach people the technical aspects of AI, but more importantly, the ethical and governance arrangements that should mandate it.
Great. Thank you, Chair.
Thank you very much. I'll go now to Ms Lawrence, who is online.
Thank you, and my apologies I'm not there in person. I just had some questions around professional indemnity insurance. And just briefly, if you could just explain to me what mandate is or what requirements are set for members to hold indemnity insurance.
I'll pass to Melissa.
Yes, so our members in public practice are required to hold professional indemnity insurance, and that obligation is established within our bylaws. So, and within our bylaws, it stipulates the the requirements of what that cover is to be. That is something that we monitor when they first apply to have a public practice certificate. We ask them to provide their full policy and confirm that they're holding compliant insurance, and then on an ongoing basis, when they're selected for best practice program assessment, we also confirm that they've continued to keep that current, that it continues to meet those requirements. It is also a factor of renewal confirmation, that they need to tell us on renewal of their public practice certificate each year that they hold that. And they also need to tell us if they've had any claims made against them in that policy.
And are you able to provide the committee with information about the number of complaints to give a sense of where there may be some concerns or some data that sort of indicates, issues generally that are perhaps percolating up that become evident through claims against insurance?
Yeah, so the insights data that comes from professional indemnity insurance claims is something that is very important to us. We are a membership body that is there to hold our members to account, but also in doing that across the board is to support them and make sure that they are best equipped to remain compliant and to learn where other people have had a claim against them, what they could do to avoid that and ensure that they're providing the highest possible standard of public accounting services. So we require our members, again within our bylaws, to inform us when they have a claim made against them. We also then have a partnership arrangement with a preferred professional indemnity insurer, although our members are free to be insured with whichever insurer they choose. They don't need to use our member partner. And through that relationship, though, we also gather intelligence of the underlying root cause of claims being made against our members or being made more broadly across the profession or professions generally, so that we can be ahead of that curve and be providing information and content to our members to keep them informed. In terms of the claims, we report them to the Professional Standards Authority in our annual Professional Standards report. That is one of the elements of their monitoring and is critical to their oversight of schemes. And as mentioned, I think earlier by Cairns in their evidence this morning, that speaks to the relevancy of the caps that are applied to members as well. So what are some of the common causes? What are some of the common claims, that we have seen? We would see within our membership, and we have reported in our annual professional standards report and the copy that you have.
Page reference?
Yeah, so unfortunately in the 2024 year within this report, we did not have many claims. Let me just find the right page for you. It begins on page 15, responding to professional indemnity claims. So within there, we outline our relationship with our partner, as I mentioned. We also reference our bylaw requirement to disclose. Just for clarity, it's page 15 of the Professional Standards report, which might not be the exact page number of the report you're looking at, because we had some additional pages at the start. So it starts at section 6, responding to professional indemnity claims. So in there, we advised of one claim in the 2024 year. However, that claim did not proceed with that member, so we don't have details beyond that it was initially related to general tax advice. In the prior year, we did have more claims data, and in 2025, in the report that we will table with the Professional Standards Authority in the coming weeks, we have 15 claims notifications for that year. And again, a general theme would be around general tax advice within our membership.
Before we jump to your next question, Ms Lawrence, could I ask you, in the way that I asked the previous witnesses, to outline the sorts of behaviours that Australians need to be aware of, that people who are acting unethically, who hang out a shingle with the CPA logo on it, what are you observing in these 15 instances that you just referred to?
Yes, so I don't think we would say that we are observing unethical behaviour necessarily in those claims. They are claims where the accountant has made an error in the provision of general tax advice, not an intentional circumstance. And so our claims tend to be on the lower side against our members. We have not reported significant claims.
Okay,
and if there was an unethical claim...
Talk about what that means. So I'm running a small business.
Yes.
I come to you as a CPA seeking advice around tax management. I want to pay my fair share and no more. That's pretty much the Australian way.
Yes.
And it's within the law.
Yes.
And I receive tax advice from one of your accountants.
Yes.
It turns out that that tax advice is later subject to some scrutiny perhaps by the ATO, and it's proven to me as a client that the interpretation of the CPA registered accountant was incorrect. What sort of monies are we talking about here?
I would need to take on notice specific details of monies, but from what I can recall of those cases that we do know about, they are low.
Yeah, but low is a relative term. I need some numbers on the record here, Ms Reid. Perhaps Ms Cassiopoulos.
If I could say, Australian taxation law is very, very complex, and 97% of small businesses use a registered tax agent to do their compliance and get their advice. We will give you the details of the insurance claims, but you're right, there's a lot of ATO scrutiny. There are particular risk areas each year that the ATO will signal. And what we've got now with the new amendments to the Tax Agent Services Act, with the breach reporting, the framework around what is recklessness versus taking reasonable care, those are all aspects that we work together with the Tax Practitioners Board to really understand the landscape. There are a lot of areas of uncertainty. Quite often, audits will result in an agreed settlement. So the space is very, very dynamic, and the ATO does thousands and thousands of audits a year. So where we have claims of, let's say, 15, below, let's say, $1 million, these are very specific issues that are based on the level of advice and the details of the advice between the client and the agent.
So settlements with the ATO is something that I would say many micro and small businesses are unfamiliar with as a concept, and we've taken evidence in previous cases that it's only very large companies with very large providers of advice who tend to avail themselves of the opportunity for a negotiation, which is very different from some of the practices from the taxation department with, freezing assets that have been reported by different businesses. So can you give me some shape and form of what's going on in terms of what you're observing at the moment, Ms Cassiopoulos?
So if I could correct the record, settlements is a very specific term, so I did misspeak. What I mean by that is where there is some uncertainty, quite often what we are hearing from our members and their clients is that they will understand what their correct obligations are under the law, and there may be negotiations on things like interest and penalties. And we're doing a lot of work with the tax office to make sure that those outcomes are fair and reasonable. So really it is around how do they identify the correct amount of tax that is due and payable, and how is the law applied and interpreted. And then following that adjustment or the amendment to that tax return, there may be a civil insurance claim undertaken between the client and the agent.
Okay, if you could take on notice, even if it needs to be de-identified, but preferably so that we can make it public, the sorts of amounts people are being recompensed for advice that was flawed in some way and found to be so. Back to you, Ms Lawrence. Thank you.
Thank you for that. I just was going through, so on page 21, it does refer there to your professional indemnity insurance compliance report, and it does have some explanation there as to why there has been an increase in the number from 1.1% in non-compliance to 6%. It does provide a little bit of an explanation there as to why that's the case. Is there anything you wanted to add to what you're observing there and what remedies you're taking with members to address that non-compliance?
I'll ask Melissa to comment again, please.
Yes, thank you for the question. As outlined on that page, we note that it had increased to a 6% non-compliance across the sample of members that were included in best practice program assessments that year. That included 2 members that were not holding any professional indemnity insurance, but were holding our public practice certificate. The basis upon which they were doing that was because they weren't actively providing professional accounting services. So they had made a decision that they didn't need cover anymore. However, that's not the requirements of our membership, and so we have called that out as non-compliance for not holding professional indemnity insurance. The remaining number of members in that percentage are then members that have professional indemnity insurance but may be missing one element of the requirements of the bylaw, and we have listed there a couple of the examples. So they might have left off or dropped off defence costs, for example. And we are holding them to account for the full obligations within our bylaws because we believe that that level of cover is what is appropriate for our members, providing accounting services to the membership and to their clients. So in response to what we're doing to make sure that they all are aware of these obligations, we have and continue to inform them of their obligation. It is also a requirement, as I've already mentioned this morning, on membership renewal to confirm that you are holding current and compliant professional indemnity insurance. We've also now created an annual compliance checklist for our members in public practice and a maturity model, and that's provided to them on an ongoing basis to prompt them, as Eleanor's already flagged, in a very regulatory changing environment, that they are not misstepping in any of their membership obligations with us, and that we can prompt them on an ongoing basis. We also provide content, and all of our members love a good story about professional indemnity insurance in our In Practice magazine, and we use that to remind them of why this is important.
Have you found that the risk profile has changed in the context of services for financial advice or for SMSF auditing? Like, are you seeing a different risk profile come through that's requiring, even with risks like around cyber incidents, AI, it's changing what type of indemnity cover is necessary?
So the relevancy of our current policy requirements is something that we do think about, and in the remake of our professional standards scheme in 2025, that was part of that application process to the Professional Standards Authority. So making sure that we still have appropriate requirements for our members, keeping in mind, as you say, what are we seeing in claims, what are the risks and the challenges within the profession. So at this stage we are satisfied with those as they are at the moment. But that
you don't think there's an underinsured element?
No, we don't see within our membership that they are underinsured based on the claims that we would see coming to our members. And we have seen where and touching on your point before about what are the common themes, we have been able to use insights to really drive change in our membership. So cybersecurity is one you flagged, and a few years ago that was one where we did see an increase in claims against our members. And we created a cybersecurity hub. We have extensive cyber resources. We've provided them all with a checklist of these are things you need to have in place to be secure, and we encourage them to share that with their professional indemnity insurer. And as a result, we have seen a significant drop-off in claims relating to cyber instances for our members.
Okay, and just with SMSF, supplementary super funds, is there any difference in risk profile there, given in the increasing number of people transferring funds to SMSF?
I guess my answer in terms of risk for claims, we haven't seen a significant change in that environment, but we take the SMSF sector very seriously. There's over $1 trillion sitting in superannuation in Australia and in self-managed super funds. It is an area where we meet with the regulators, ATO and ASIC. We information share what they are seeing when they oversee SMSF auditors, and we do the same, and we work together to build out content and approaches to make sure our members know the challenges or the risks in that space and how to best address them.
So your members would be very much part then of the ecosystem that's recommending movement of products to different platforms or into SMSF? Like, would that be a role that you see your members playing?
So separate to an SMSF auditor, obviously, for independence, but financial advisors within our membership could well be making those recommendations, and then our accountants could also assist in the establishment of superannuation funds and then the production of financial reports for those.
And are you comfortable with the level of controls or disclosures for your members, be they accountants or financial advisors? Do you feel there's a sufficient separation of any conflicts of interest around perhaps where they're recommending movement of funds onto different platforms or establishing an MSF account?
From the establishment of them and their advice there, I'll refer to Eleanor in a moment, but from the audit and the accounting separation, we are pleased with the improvements we've seen in that sector, and that has been led through the ATO and the ASIC enforcements and supported by all the professional accounting bodies in ensuring our members are aware of the independence requirements, and there is a much clearer separation between preparers of accounts for SMSF and the audit of them.
And if I could add, so Eleanor Cassidy, thank you. So financial advisors comprise a relatively small proportion of our public practice certificate holders, but once again reinforcing that if they are providers of financial advice, they are required to hold a public practice certificate. They will come under scrutiny through our best practice program reviews over time. And then, as Melissa mentioned, there are also others that will support the establishment of an SMSF entity and advise on the tax consequences. So it is a complex and dynamic environment, but we do work with ASIC on the financial advice space, and our advocacy team is also engaged in providing insights through the various consultations around the regulation of the advice that these particular professionals are giving their clients.
Thank you, Chair.
Thank you very much. Did you have any questions, Senator Sharma?
I did briefly, yeah.
Yes. Look, I'll come to you then.
Okay, thank you. Just a few. Good morning. Nice to see you here. Or good afternoon now. Just briefly, I was reading about the sample of members that you do each year with your just making sure that people are complying with the continuing professional development requirement. What's the methodology for selecting that sample of members?
I'll ask Melissa to comment again. Thanks, Melissa.
Yes, so similar to my response earlier, it is a risk-based selection across our membership. We have a CPD diary, and where members are using that diary, we can track their compliance proactively and see what the level of CPD is that's been recorded already. And where we see that they're not engaging in that diary, which means they're not entering into our ecosystem, we would flag them as someone that would be higher risk for assessment. And then obviously other intelligence sources too around concerns whether they've had conduct complaints, whether they've previously been found to have not met their CPD obligations or to have any kind of quality concern regarding them. So in the 2024 year, we selected a sample of 850 members, and we tried to do that across the spectrum of our members globally and include a portion of members within public practice within that. However, we also include public practitioners and their CPD in the best practice program, so the coverage there is higher for that particular cohort of member, and they are the members that are providing the public accounting services to the Australian community.
So how do you select is it 850 you said you did in 2024? Yes. Is it just randomly generated, or it's not, then you say you want a certain amount from each category?
Yeah, so we categorise them into risk buckets and then take a certain percentage from those, and then it is random to some extent, other than where we have specific intelligence, but we also then apply rules regarding whether they had previously been assessed and passed or had just undertaken a best practice review, because we're not going to waste our oversight effort on someone that's already just been overseen and passed.
Okay. So you're convinced it's a representative sample that you get then?
It's risk-based sample.
Yeah.
So it's not a random sample. It is risk-based, and it's skewed towards those that we believe are at a higher risk of non-compliance and who might need support. And it's also for us to go in and verify that they are maintaining the appropriate records.
We have increased it to 1,000 in 2025, and I guess would flag that is the sample of which we are requesting specific documentation from. We do keep that objective view across the entire membership of what we can see from those that are using our diary as well.
Okay.
Yep.
What's the general? Do you have a figure on the percentage of use of the diary amongst your members?
Yeah, it would be between a third to 40%, I want to say off the top of my head at the last check we looked at, that are using it. But we could take that on notice and confirm exactly.
And it's not mandatory for your members to use a diary, it just encourages it, or?
That's right, yeah.
Okay. And then just on the...
Before you jump off that, can I just put it to you now that, you know, it's very clear that that's the tool that you're using, that there'll be people who will be very aware of managing their risk by participating in a performative way in that research model.
100% agree.
Which is one of the concerns that we've raised previously with ASIC about the need for random audit as well. Can I put it to you for consideration that PCAOB has its effect because it's called peekaboo, because nobody knows when they're going to show up and have a look, right? So can I put it to you that that's worthy of consideration? Thank you. Over to you, Senator Sharma.
That's right, thank you. And then just on the complaints investigation function, so how many... I saw two different figures, but I think I'm getting confused with complaints from the Big Six versus complaints across the board. But could I just get the most recent figures you've got for the number of complaints that CPA has investigated and the breakdown of that?
Yeah, I can take that. So in 2024 year, we had 389 total complaints were received.
Right.
225 of those were investigated. And then the results of...
Can you take us to the page that you read?
Oh, sorry. Oh, no, I'm reading off my own notes.
Oh, okay.
Yeah, this is not something that's been submitted to...
Thank you.
Was it? I seem to have it footnoted as pages 9 and 10 of your submission, but I don't actually have your submission in front of me. I don't know if that's right.
2024 complaint.
Just for the benefit of the rest of the committee.
Thank you.
So it's page 20. It's 10 rather.
It is page 10? Okay, yep.
It is page, apologies.
That's 2024.
Yeah,
and
so
Warren
it's
was referring to 2025 figures,
Okay.
which is in the next report you'll get.
At the end of the month. Yeah,
Yeah.
exactly. Yeah.
So it's 389 total complaints, 225
were
investigated.
That's right. And then the outcomes of those were there was 44 matters were referred to the disciplinary tribunal, which is the independent body that determines the or has the hearing and determines the outcome of those members. And 2/3 of those that went before the tribunal were forfeited, amongst other penalties that were handed down, included fines, severe reprimands, and then requirement to do further CPD and the like.
I see. And then, so for 220, there's 389 total complaints, 225 formally investigated. What happens to the other 164?
Yeah, so the vast majority of those were non-members of CPA Australia, so we don't have any jurisdiction.
I see. Okay.
Yeah, you were referring before around the contractual arrangement that we have, and that's the basis on which we can investigate.
You can only investigate your own members.
Yeah, there's no relationship there, so we can't investigate them. And then there was others where there's approximately 90 where there was just no case to answer because the evidence didn't support the complaint that had been alleged, or it was older than 5 years, related to conduct that was more than 5 years old, or it was a fee dispute. And in our bylaws, where there's a fee dispute between the client of our service provider, we don't investigate those.
I see, okay. And so it's only if they pass the threshold of within 5 years it's a member, sufficient evidence, not a fee dispute, that it would get to the disciplinary tribunal? Correct,
but then there's other intermediate steps. For example, the member... if it's a straightforward matter, they might plead guilty, if you like, to the allegations that or the complaint that's been put before them. In those circumstances, then it's rather than it being referred to the disciplinary tribunal, the outcome is confirmed at that point, and there may be a fine issued or so forth. But that does have to be signed off by a single member of the disciplinary tribunal. We call it a one-person tribunal, but it's just a mechanism in which we can get through more of the complaints, which just helps us with efficiency and resolving complaints more.
I see, okay. And then the highest sanction you can impose is loss of membership, and is it $100,000 for your...
Correct. Individuals, it's $100,000, correct.
Okay. What's the highest fine you've ever imposed?
$100,000.
Okay, against an individual?
Correct, yep.
And how did, because we were discussing this earlier, you might not have heard this conversation, but because of the contractual basis and the principles of common law that apply, you had advice, or you were confident that a $100,000 fine would not be potentially struck down by a court as punitive?
Yeah, correct. Well, we haven't got advice on it. Internally, we've reviewed it. We've got a team of lawyers.
Okay, yeah,
myself.
you've got internal legal,
we form the view that in the context of the matters that come before the disciplinary tribunal, that it wouldn't be held to be a penalty to enforce a $100,000 fine when it's been levied against the member based on the conduct. It is at the upper end, obviously, of the threshold that we can apply, but we've never had it challenged either, and there are, whilst 100,000 is the most, there are multiple fines of 50,000 or 80,000 that have been levied as well, and none of those have been challenged. So in the circumstances, we think that threshold's appropriate for individuals.
Okay. And have all those fines been paid?
No, recovery is a different question altogether.
Yeah. So was the is it just one $100,000 fine?
On my record since 2020, there's been one.
Okay, and was that paid?
I'd have to take that on notice.
If you could, yeah, I'm interested. Could I ask if you're not going to breach any privacy restrictions here, what was the nature of the conduct that gave rise in broad terms to the $100,000 fine?
Generally, it's pretty serious misconduct, either fraud, corruption, theft is another area. So
do you remember the circumstances of this particular?
I don't. I'd have to take that on notice and bring those claims. Yeah.
Okay. Yeah, look, I would be interested in notice on what you can reveal about that particular investigation and whether that fine was paid as well.
Okay. Yeah.
That was all I had for now, Chair.
Right. And can I just ask, do you have meetings with the IPA and CANS at all?
So we engage with them on a range of issues to do with policy and non-competitive issues. So we certainly don't have meetings with them on competitive issues, but if you're asking in relation to investigations, do you want to talk about the way we communicate?
Yeah, we do. Yeah, absolutely. So our professional conduct unit will have regular engagements with Chartered Australia and New Zealand, just in relation to the process and how we're engaging with regulators, the Tax Practitioners Board and so forth. And then professional standards, Melissa can talk to how they engage as well. So we have lots of interactions with the other professional bodies.
Yeah, so from a professional standards perspective, we do meet with both IPA and Chartered Accountants Australia and New Zealand on a semi-regular basis, maybe once a quarter, to information share how we're responding to changes in technical standards, how we're planning to support members, whether there's areas we could collectively work on together, or just to learn from each other in that space.
And are they minuted? Are they formalised in any way, or is it just a casual catch-up?
Casual catch-up, yes.
Okay, very interesting that a mechanism of any kind exists, given the breakdown of communication that it seems to us happens across the sector. But that is, I think, helpful information. If I can just ask a couple of quick questions. A chartered accountant and a certified accountant, could you just put on the record any hierarchies that exist?
It's not a hierarchy, they're different. Dale, do you want to comment?
Well, I think for me, I go to the governance and chartered's established under a charter. I think if you are asking what differentiates us, we're global. That's probably the main difference. And as my colleagues have indicated already, we operate in a range of sectors, so we're not confined to the big end of town. We go everything from small sole practitioners to public practice to academia, public sector, right up to the Big Four. So we have a variety of constituents in our cohort, and we are a global organisation. But if you had asked me, that's my recollection, and I don't think I'm not here to express a view on which one's inferior or superior. I think we're part of the accounting profession, and
members and senators.
And we know who's the best on that one.
We are both outstanding organisations.
The senators called the upper house for a reason, right?
To add to that, all three of us are members of To add to that, all the three professional accountancy organisations are members of the International Federation of Accountants, and what that means is that we all abide abide by the same statement of member obligations, the same set of standards set internationally, and all three of us fund the Australian Professional and Ethics Standards Board. So we have a joint interest, a collective interest in making sure that standards in Australia and all of our members collectively are required to abide by those standards. So it is a collective response.
Sorry.
Yes, Mr. Freeland.
To illustrate the point, in our constitution we have three objects, the first of which is to promote excellence, enterprise and integrity amongst members and the accounting, financial and business advisory professions generally. So we have a societal purpose, and that purpose is fulfilled by engaging with other professional associations for the benefit of the accounting and finance profession. And that's why we do collaborate with them in relation to advocacy issues, thought leadership issues. We're all outstanding organisations, and certainly from our perspective we work actively in the interests of a better and a stronger accounting and finance profession for Australia.
So is there any reason why there couldn't be a single disciplinary body established to allow for, you know, these casual conversations, catch-ups to be more formalised, for perhaps a productivity lift and more efficiency gain, less communication gaps?
So each membership body, each outstanding membership body has a different composition of membership within its...
Ethics are ethics in the profession.
Ethics are ethics, but we, for example, are quite global. We have 176,000 members. A third of those are outside of Australia. And so how we think about the bylaws, our bylaws are different within each organisation. It would be very complicated and messy thing to try and align that.
I understand what you're saying, Mr. Freeland, and the separate nature of this is historic. The question is the current structure fit for purpose for Australians in 2025?
Well, that's, yeah, so the question is why would you do it? And if that's the purpose, so from a CPA perspective, I'd say we have a very effective system of education of our members, monitoring of our members.
Your fines seem a bit higher too, Mr. Freeland, if I can put it bluntly.
They seem too high?
No, they're a bit higher.
Comparatively.
Comparatively high,
right.
yeah.
Okay, so we...
Thank you.
And we take this very seriously. So in our view, there is no deficiency there. And if I might add, our members want to see our rules enforced. It's in their interest because the failure to comply with ethics and requirements of some reflects, unfortunately, on the profession as a whole. And so for our members, it's an important issue for us to take that seriously. So our interests are aligned there. I believe, as the CEO of CPA Australia, we are effectively managing that, and therefore there is not a need to change.
Could I just go to two other quick matters before I go to Mr. Buchholz, and we will break for lunch very shortly and release you. You, I believe, were in the room when I asked questions about the financial abuse dimensions operating within the industry. Could I ask you on notice to give us an indication of what it is that you are doing, particularly with regard to financial abuse, noting that it is a huge cost to the Australian population and that accountants are involved at a critical moment. So you could take that on notice. The other thing is First Guardian and Shield. I could just indicate to the Secretariat that I'd like this question to go to all of the witnesses today. With regard to First Guardian and Shield and the failure there that involves research houses as well as trustees, as well as financial advisors, have you investigated whether any of your members are involved at any part of that ecosystem that enabled First Guardian and Shield to be perpetuated or perpetrated on the Australian people?
Take this on notice, is that...
It will, if you have a response.
Do you want to respond on the financial abuse, Alan? or no?
So on financial abuse, just on the record, we have been really proactive in engaging with each and other statutory agencies like the ATO and TPB. So we will share with you the website material, the resources and the guidance that we have been producing, and we will be releasing a new suite later on in April to help support our members.
I'm particularly interested in trusts because some of the evidence that we took, where it was put to us in evidence that 30 million now is a small farm. But many women are trapped in a trust structure without any evidence of income. They're in a financially abusive or domestic, physically abusive situation. They can't flee. Accountants take over the management of the trust on behalf of the family, and then it's just one person against the whole family, often the woman, unable to get access to any sort of services, unable to prove a record of employment to get on with life in terms of any finance. This is very serious evidence, and trusts are being looked at, but what is the abuse element that's going on in there, and how aware of your members of that, if you can add that to your consideration?
Certainly, we can include that in our response. With respect to First Guardian and Shield, the facts as reported publicly, they're still coming to light. But on managed investment schemes more broadly, we do submit, we've recently made a submission on managed investment schemes and some of the regulatory overlay, including with auditors as well. I will refer to Warren, though, as to whether we have a self-reporting regime.
So we rely on self-reporting at this stage. So there are some matters that we have
to repeat my comments about, if you're dodgy as, you're probably unlikely to declare yourself as dodgy.
Yeah, quite possibly. I think what we do is we monitor, because they're criminal investigations as well. So for those members or the names where they're identified, we will actively then open an investigation and a complaint against the individual and follow the process as we do in managing all complaints. But we require that to be published at that point, or we rely on self-disclosure for their involvement.
Okay, thank you very much. Over to Mr Buchholz to bring us home.
Thank you, and this will be a very short question. Thank you for your appearance today. I did get a lot out of it. Can I acknowledge Mr Pinto as Chair for your longevity and 30 years of service to the sector? Well done. That is a colossal contribution.
Thank you.
Now, I've given warning to Mr Freelander of the line of comment or discussion I just want to have. And you made some comments in an article published by Accountants Daily. And I thought the article was extremely well written. The professional accounting bodies are urging the re-elected government to revitalise, reform and repair the Australian economy and business landscape. As per your charter, you're well within scope to make comment on these matters. In the article, you spoke about seizing the opportunity of its revived mandate to revisit, reform and repair the Australian economy. You specifically spoke about the revitalisation of businesses that you'd like to see. You spoke about aggressive tax reform. You spoke about budget repair. And you wanted to see an optimistic vision from this government that improves business productivity and speaks to a particular cultural shift that bolsters growth. Well-written article, I thought. Who wouldn't want to see those outcomes? Now, when I go through and do some searches against some of those key KPIs, and maybe this, to use an accounting term, would be a point in time where you would offer some interim comments, part of the way through. When I have a look at the revitalisation of business, and I had a look at what the Business Confidence Index is at the moment, and this is as of February 26. Business Confidence Index is actually down 8.8%, and it's the lowest, unfortunately, in 5 years in our country. When we talk about budget repair, our current net government spending to GDP for the 24-25 period is 27.3%, and we're closely sneaking up on $1 trillion worth of debt. When we talk about productivity reform and productivity outlook, both the Treasury and RBA are saying Australia's productivity growth is forecast to remain weak. Treasury lowering the long-term outlook to a slower recovery, taking 5 years longer than expected to get back into the long-term forecasted average. Would you like to offer an interim comment on your earlier observations as to the performance of?
What I would say is that productivity remains a very important issue for Australian business. Clearly, productivity levels have been dropping and more needs to be done. We are part of a group of alliances which was initiated by the Business Council, and collectively we've been calling for, in particular, a 25% reduction in red tape. So for example, our members, one of the things that they often cite to us as a frustration for them is just the regulation, at least the way that it's been put in place, the duplicity of the regulation, and so that's one area that certainly we've been very vocal on, is trying to declutter the regulation environment for the profession, but for business generally, particularly small business. There's other things that we have advocated for. We each year do a small business survey where we survey a very large number of small businesses across Asia Pacific, and unfortunately Australia ends up being right towards the bottom on pretty much every one of the indicia of growth measures. One of those is investment in technology, where I think we were 10th out of 11th of the 11 jurisdictions, ahead of only New Zealand, I believe, in terms of investment in technology. That's another area where incentives, programs to encourage investment in technology for small businesses, and that includes in our profession as well, is another avenue towards productivity enhancement. And I might ask Eleanor if she wants to supplement anything of what I've said.
We've also been very active, of course, in calling for comprehensive tax reform and actually taking a look at the system as a whole. Productivity is a range of factors, and so for us, looking at the tax piece, and I know there are conversations in the lead up to the budget, but it really is around taking a step back and saying, how do we encourage greater investment in business, greater confidence in business. We also have ageing business owners, particularly in the small to medium sector. How do we encourage our young people to take that leap and have the confidence to invest in technology? They've got confidence in the tax system. They know what is coming ahead. And of course, foreign investment is critical to the Australian economy. So how do we maintain settings or encourage settings that continue that pipeline of investment?
Can I just offer, and this is my last comment, not just a comment, when you guys get the opportunity to reappear again, can I just ask you to be pre-armed with insolvency data? I want to have a look at that, just on the back of how we're performing as an economy. Thank you, Chair. Thank you so much.
And getting the shape of that.
Yeah.
This committee did an insolvency inquiry, and the government's indicated that there's, work being done in the space, but often the data seems to be very lumped together and doesn't give us the proper shape and form, and also the proportion of small businesses that are now being grown as our population's grown, and genuinely authentic comparative data would be really helpful.
Yeah.
Really helpful, because these businesses and their accountants need our ear, but we need the truth of what's going on. And it's hard to get it. One
of your early indicators in insolvency will be low business confidence. So if that number's high, the insolvencies are less. You know what I mean? So they do track each other. And I only asked through that mechanism. Yeah.
Well, forewarned, forearmed.
Please, yes.
Excuse me.
I've given you a line of sight to what I'm going to say.
You have. Thank you, Senator.
Thank you. Could I thank you for giving your time to give evidence today. There will be a number of questions on notice that will follow. Some we've indicated and others that we'll write to you on review of evidence. If you could provide additional information to the Secretariat by Friday the 10th of April, that would assist the committee in preparing our report, in which we will document what's happened here today. That concludes this session, and the committee will suspend until 1:40 for a lunch break, when we will return a half an hour behind with the IPA. Apologies for the delay, but we hope that we'll be able to get back on track for ASIC at 2:45 or thereabouts, and we will certainly be finished at 4. Thank you.
Thank you. The committee will recommence with representatives from the Institute of Public Accountants. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. For the Hansard record, will you please state your full names and the capacities in which you appear today? Mr Conway.
Thank you. Yes, Andrew Conway, Chief Executive of the Institute of Public Accountants.
Vicky Stiliano, Group Executive, Advocacy and Professional Standards at the Institute of Public Accountants.
Thank you. And you're joined here in the room by my colleagues
Scotty Buchholz,
Dave Sharma,
David Moncrief.
I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Well, thank you very much, Chair and members of the committee. Again, appreciate the ability to participate electronically, so thank you to you and to the Secretariat for facilitating that. We do appreciate the opportunity to appear before you today on behalf of the Institute of Public Accountants in this very important ongoing discussion and conversation. It's both a privilege and a responsibility to contribute to this important discussion on the oversight of professional bodies and the professional standards of members. The IPA stands firmly committed to serving the public interest. That commitment is central to our purpose as a professional accounting body and underpins every aspect of our work, from enforcing professional and ethical standards to supporting our members in maintaining competence and integrity, to ensuring that the communities and businesses they serve can trust their advice and stewardship. Integrity, accountability and professionalism are not optional values in our profession, they are fundamental obligations. In recent years, the accounting profession has faced significant scrutiny following high-profile ethical breaches. These events have tested public confidence and prompted a necessary reassessment of professional oversight and corporate culture across the sector. We welcome this scrutiny because raising the bar on ethics and professional standards is not just a regulatory expectation, it's a moral imperative and a shared responsibility across all professional bodies. However, it's also important to recognise that many of the regulatory compliance obligations that have emerged from these incidents have fallen disproportionately on smaller practitioners, particularly those serving regional and small business communities. These members perform essential work that sustains the integrity of Australia's small business economy. Yet they often operate with limited resources, shouldering the same compliance and reporting burdens as large practices without equivalent means. The IPA continues to advocate for a balanced approach, one that strengthens ethical and professional frameworks while ensuring that solutions remain proportionate, practical and supportive. Our focus is on building integrity through education, guidance and collaboration, rather than compliance alone. To this end, to build on our track record of consumer protection, we've taken a number of steps, including the fact that the IPA were the first professional accounting body to mandate an annual ethics and practice management CPD conducted through a thorough professional conduct review, secured unanimous member approval of constitutional changes to raise the bar on professional conduct, provided practical guidance and support in relation to practical risk management, aligned to the APES 320 and 325, and more recently, the IPA board has required members to be accountable for their CPD on an annual cycle as opposed to a triennium. All of these steps and others have been designed to contribute to consumer protection and public trust. We acknowledge that this will always be a work in progress. We are working alongside regulators, government and our fellow professional bodies to rebuild trust and reaffirm the profession's social contract. Our objective is clear, and that is to ensure that every accountant, regardless of practice size or location, can meet the highest standards of ethical and professional conduct while continuing to serve the public interest effectively. We thank you, Chair and members, and we look forward to your questions.
Thank you very much, Mr Conway, and I'll go to Mr Moncrief for the first set of questions.
Thank you for seeing us this afternoon. I was wondering if you could go through some of your the CPD requirements that you have for your members and how you ensure that they are meeting the... So I understand it's a self-reporting system and how you go about ensuring that that self-reporting system has integrity maintained?
Thanks, Mr Moncrief, and through you, Chair. We apply a process of, there are three broad, if I could describe them as buckets of CPD we ask our members to fill up. I'll keep it fairly straightforward language, because I think our profession, like other professions, I suppose, does get caught up in its own language. And if there are acronyms we use, please, I'm sure, as we've experienced in the past, the committee is very good at asking us to refrain from acronyms and use full terms, so we'll do our best. But from the continuing professional development side, those three buckets are technical and product knowledge. So that's really around the technical knowledge of core accounting areas. The second element relates to management and professional skills. So really the nature of managing productivity, the behaviour and operations of accountants and their practices and the environment they operate in. And also the third bucket is the professional and ethical standards. That is applying those professional and ethical standards that are set, making sure public interest is foremost, and we apply those standards accordingly. We then conduct a random CPD audit. So there is a random approach. Members are required to complete their register. That is a voluntary, as you point out, Mr. Moncrief, a voluntary disclosure to us, although CPD that's undertaken with us is automatically logged on our system. And then for other CPD that we would recognise and verify, that would be up to the member to verify that to us or provide that evidence to us. That's all subject, as I said, to a CPD review and an audit that we select members in two ways. One, there's both a random selection of members, and secondly, there's a risk-adjusted approach to members who we have no record of CPD on our system, so those who are failing their obligations, or where our practice management reviews, our practice quality assurance reviews have identified a concern. So there are sort of a range of ways we triangulate that requirement on members. They are required to complete 120 hours over a 3-year period. As I mentioned in my opening statement, we've just required members going forward, that will be an annual submission to us. They must declare annually their CPD requirements, because if we wind the clock back 3 years, there'll be elements of CPD that some of us would not have imagined we'd be performing now. And 3 years is quite a long time in what we would describe as a very dynamic industry.
This is Vicky, sorry, just to add to that, this is Vicky Stiliano. The other thing that we do in terms of ensuring compliance is for our public practitioners, they must, it's mandatory, complete a professional standards declaration annually, and that has a range of CPD questions in it. So they have to complete that.
Sorry, what do you mean by CPD questions in it? Is that in relation to like industry-related knowledge, or is that related to what they've done?
In relation to what they've done. Right. So we ask them, what have you done? Who have you done it with? Have you recorded it? And we ask for proof. But as Andrew said, we also do a random check, even of people who say they've complied. So we check to see if they've actually complied. So we get them to upload evidence, and we check that as well. And then for the non-practitioners, we have them on a different cycle, because we also risk rate them, and because they're rated as lower risk, because they're not public facing, but we still put them on a regular CPD audit cycle.
So the higher risk ones are a higher rate of being subject to audit?
Yes, exactly, yes. And as Andrew mentioned, with our quality review program, we also have a special CPD section, and again, we ask them to upload documents, and that all is checked. So even though they do have to report it, but we do verify the information.
And if someone wasn't meeting those requirements, do you impose financial penalties as well?
It's not financial penalties as much. We actually take an educative approach. So anyone who is not compliant, what we do is we give them like a remediation plan. So they are required to make up the hours. Now, if they are so far behind, which is the problem with the triennium, and that's one of the reasons we're moving to an annual cycle. So if they're that far behind and it doesn't look like they're going to be able to meet the requirements, then they could face suspension or even forfeiture. So basically, with any non-compliance, if a member isn't able to remediate the non-compliance, at the end of the day, they could face suspension or forfeiture.
So suspension's more likely than a financial penalty?
Suspension is more so for members who are close to sort of the border, members who are responsive, members who really show that they want to comply, but for various reasons haven't been able to comply. So for those members, we do a lot of, let's say, hand-holding to make sure that they become compliant. It's the ones who end up being forfeited are the ones who are sort of so far sort of behind the line that they're not going to catch up, or they don't show that they want to try and comply.
Could you expand a bit on how you review what you're classing as CPD, and whether you've obviously we're dealing with quite a dynamic landscape in terms of artificial intelligence. So you comment a bit on how you keep these things up to date with international standards.
Yeah, so we're part of a various number of international bodies, including the International Federation of Accountants, which is where most of the standards are derived from IFAC, the International Federation of Accountants. And then we have people who, like staff members, who, in terms of advocacy, part of the role, and as part of it being a professional accounting body, our job really is to ensure that we're up to date with the standards, also that we contribute to influencing the outcomes of those standards, so obviously a lot of advocacy. And then once the standards are issued, then we do a lot of CPD and training on those standards, and whatever emerging issues there are, whether it's AI or cybersecurity, sustainability reporting, you know, the whole landscape of different types of topics, we offer that through our CPD. We also have micro-credentials through a much more, and Andrew, you might wish to talk to the GCPA, but we also have a global certificate for public accounting, and that also has a lot of different topics. We put a lot of research, it's competency-based, so education, our education service and offerings are always having to evolve because, you know, as we all know, everything's changing constantly.
And I might just add, if it assists, specifically to that question around how do we categorise, there's a combination of both structured or verifiable and unstructured or unverified CPD. Across that 120 hours over the 3 years, our requirements are that 90 of those hours must be verifiable. Now, verifiable will be formal learning with a defined objective. There's sometimes an assessment aspect to that. There'll be seminar attendance, workshop attendance, might be in-house training that we can verify, where there is actually a defined learning outcome. So that's how we actually look at the categorisation of CPD. So to give you a worked example of that, as we put together our National Congress, our technical team works closely with our events team to identify the knowledge areas, or structure our program and code it. So we code it against each of those three broad areas I outlined before, and identify the number of structured and verified hours that are available to practitioners. So it is self-set. So the organisation, the IPA, will set whether it's verifiable or unverified, but it gives us a degree of structure about applying those credits. And as Vicky pointed out, we then assess those against our quality assurance review. I'm happy to go to those evolutions we've made. I might, just to assist the committee, I'll keep this contribution short, but happy to expand on it. We've undertaken a very comprehensive review of our professional program requirements to give you some idea of how we compare with other bodies, and we highly respect the programs of Chartered Accountants Australia, New Zealand and CPA Australia. Our model is quite different in the sense that up till this year, we were running our professional program as a program in partnership with the university, so a postgraduate-led program. And in response to demands from employers and members and other stakeholders, we set about crafting an alternative pathway that is a micro-credential competency-based pathway that assessed over 19,000 units of competency from around the world. We assembled those into 50 micro-credentials, and they are, if I use the language, of verified learning. But the difference for us is that there are many organisations running micro-credentials and largely using those for CPD purposes. The difference for us is we use micro-credentials as a pathway to certification. So it is assessed learning. We map it to be equivalent to an AQF, or Australian Qualifications Framework Level 8. so a postgraduate level equivalent, and that's changed the way. So it's competency-led. It is show us and demonstrate you can do, not that you can pass an exam. And so it's a fundamental shift, and that shift is echoed across the global profession, where there is a move to competency-based programs to focus on what you can do rather than what you can say you can do or what you can pass an exam to demonstrate competence. So they're key differences for us.
And is that something that is trying to adjust for the role of AI in all of these exam programs, or is that a separate?
Yeah, I'm sorry. Yes. So I'll give you a very specific example. So the Global Certificate of Public Accounting, there are three broad areas of competence that we assess, and they are technical skills. We think it's still important, I'm being flippant here, but still important for an accountant in 2026 and going forward to know something about accounting. So we have technical accounting skills, we then have professional skills, and then we have transdisciplinary skills. So in the transdisciplinary skills, we'll have digital acumen, cybersecurity, those elements that could apply to any discipline. In the professional skills, problem solving, teamwork, communications, well-being. And in the problem solving, to give you a precise example, Mr. Moncrief, the problem solving we assess by way of a workshop. It's an invigilated workshop where a problem statement's provided to a group of people. They're asked to consider the problem, and their response to the problem, their management of it, is assessed and invigilated to assess the competency. So it's a very different model rather than a multiple choice exam or some sort of online assessment mechanism. So it's that, again, reinforcing that point of show us that you can do and you can demonstrate that competency to achieve the certification.
Thank you.
Thanks. Thank you very much. Senator Sharma, did you want to?
I did, yeah. I had a few questions. Thanks, Chair, and thank you, Mr. Conway and Ms. Stiliano. I just wanted to ask or understand a little bit the disciplinary tools and procedures you have available to you. So I was just looking at the numbers of disciplinary actions you took against members last year. I see that there were 5 matters that were referred to the disciplinary tribunal. That's the right figure I've got there?
Yes, that's correct.
Okay. And then, so I see that the breakdown in your submission is 1 forfeiture and censor, 4 admonishment, 5 costs, 2 fines. Would you just mind explaining each of those sanctions separately to me? So forfeiture and censor is you lose your membership?
Yes, that's correct. So forfeiture, you lose your membership.
Yep.
Suspension is where you don't lose your membership, but basically you lose your privileges. And sometimes it depends on the situation. Sometimes we go straight to forfeiture. Sometimes we go to suspension to allow the member to remediate and comply and do what must, to meet certain conditions. And if they meet those conditions, then they get to keep their membership. But it's always under usually threat of forfeiture. We have admonishment and censorship. So in some cases, we do publish the results, but in some cases, we publish names, and in some cases we don't.
Okay.
So it depends. We can have any combination.
So is publication of the finding. Okay.
Yes. So sometimes there's a combination. It might be a fine. A fine. There's also there could be a cost order as well.
Yep.
Sometimes, because there's a difference also between the disciplinary tribunal and also a more administrative approach. So the bulk of our disciplinary matters go through to a professional conduct committee.
Yep.
So we've tried to, over the last few years, streamline our processes so that the more serious ones will go, or the more complex ones, the more contentious ones will go to the tribunal. And then the more straightforward ones will go to a professional conduct committee.
I see.
And then there's various processes within that. So we've just tried to really streamline, especially if it's a situation where the member is not contesting, if it's a situation that's come from a regulator and the regulator has breached the member, then we take that as evidence on the face of it and very, very rarely does a member contest it. So in matters like that, we still investigate because we don't have jurisdiction, obviously, over the legislation, but we look at the same evidence in terms of the Code of Ethics, the professional and ethical standards, to see what's being breached. Most matters are reasonably straightforward, and so those can then proceed more quickly. There's also complaints that we investigate, and it might be a case of no further action. Sometimes complainants don't provide sufficient evidence, so there's really nothing to go on. So it's a whole range of different things.
Could I just ask with the fine, so what's the maximum fine that you're able to levy?
It's $100,000.
Okay. And what of the two fines you issued in this, this is calendar year 2024, these figures, I think. What size was each of those fines, do you remember?
I'll have to have a look and take that on notice, but I know I think the highest fine we've issued so far is $25,000, and then costs, I think the costs were $13,000, but I'll give you the exact numbers.
So $25,000 was the highest fine you've issued so far?
Yes.
And is that just going to the sort of the general causes of complaints? So you've got failure to meet professional standards, professional misconduct, ethical issues, service quality issues. What sorts of conduct or cause of complaints tend to give rise to the highest fines? Is it ethical issues or professional misconduct? What?
It's probably a mix of both. We find that the most egregious ones are ones that have involved fraud. There's some, for example, where there's multiple companies, multiple trusts, various corporate structures involved, lots of different parties involved. Usually there's court proceedings in the middle of it all. That's not uncommon for those types of matters. And sometimes we do hold a matter in abeyance until the court proceedings have concluded. And sometimes we get copies of the transcript from the court. We see what the final determination is, because a lot of the evidence that would support a claim against the professional and ethical standards would be found there. But we still give the member the opportunity to be heard if they wish to be heard. Those matters would normally involve lawyers. Members have lawyers representing them. So usually they involve at least allegations of fraud, not necessarily criminal matters. They're different, but these are civil matters.
I understand. Okay. Thank you. And then if I turn to another topic, just Mr. Conway, you said in your opening statement how some recent changes and requirements had fallen disproportionately on smaller practitioners. Would you mind just expanding a little on that comment and how you've noticed it as a professional membership organisation and I guess the ability of smaller practitioners to meet these requirements and stay viable as small units?
Sure. No, thanks, Senator, and thanks for the opportunity to address this point, because I think it gives a chance to provide a voice to our members in this space, and we regularly interact with members. Perhaps to a fault, I still to this day contact every new member and give them a mobile number and ask them to contact me, and that's their right. My view is they pay for the phone; they should be entitled to contact. So I hear a lot, and as Vicky does, we hear a lot from members, just generally around the volume and velocity of regulation that they're facing, particularly, most importantly, in the small and sole practitioner space. The challenge, I think, is if we think about the regulatory interventions following matters pertaining to PwC and the responses to TASA code determinations, the Taxation Services Act code determinations, the imposition of breach reporting obligations, there is a genuine concern with members about working through the practicalities of that. What does it mean? What sort of breaches should I be looking to identify? What happens if I'm breached or there's been a notification on me? And there's a genuine fear, it's sort of palpable within the profession. Now, some might say, well, that's just the territory you live with. But for sole practitioners who go about their business almost exclusively, day in, day out, to do the right thing by their clients, their observation is, anecdotally, is that they're having to bear the brunt of regulatory impact perhaps more acutely than larger firms. And they're the ones who are having to face and address these regulatory compliance obligations when they really don't have the means and capacity to implement them as they feel they're required to. So we take that obligation up seriously. We provide that support for them and guide them through that process. But I think it's a very real sentiment that members hold, is this sense of the overarching sense of regulation. As other colleagues from other bodies have spoken to, there are a raft of other regulations impacting. There's, of course, the anti-money laundering regulations taking hold, the tranche 2 reforms, and all of that is important. There's no question the public policy priority, but it's set against the backdrop of sort of ongoing change and concern that small practitioners are facing. So we feel an obligation to voice those concerns on their behalf. We feel as an intermediary that our job is to help manage the implementation of the reforms, to try and address the public policy parameters and do that in a sensible way. But I think it's important for the committee, as I'm sure you already do, to take note that smaller practitioners are feeling the pinch of not just the pinch, but the squeeze and that core of ongoing regulation. I think we have to call that out, because it will not serve Australia well if practitioners simply disengage. So we need to keep them engaged in the process to ensure that public interest is upheld. As I said, every practitioner, almost every practitioner, goes about their business every day trying to keep their head above water and making sure they do the right thing. And that's what we see our job is, to try and facilitate that.
Thanks, Mr Conroy. You did mention, I was curious to just hear a little bit more about this, and I won't spend too long on it because it's not quite on topic, but the AML CTF expansion to tranche 2 actors, so that'll cover your members. That comes into effect, I think, from 1 July this year. What are the more onerous elements of those requirements or duties that you're hearing the most concern about from your members? What are they most anxious about in terms of these new obligations that are being put on them as a result of that expansion?
Look, thanks, Senator. I think it's really around, and my colleague Vicky Ciliani may have a view on this as well, but it is perhaps a topic for an entire inquiry itself. But principally, it is really around the obligations that...
We had quite a few already on AML CTF. It's got long legs since 2016 when it was announced,
You're very right, Chair. You're right to point that out. I was more sort of reflecting on the implementation aspects for practitioners. I think there are some challenges. If we sort of zoom out a little bit from the AML discussion, if we think about its issues and challenges around practitioners saying to us anyway, the intersection of codes, all right? So we've got the Tax Agent Services Act Code of Conduct that's legislated. Depending on what function the accountant's performing, they may well have compliance obligations under ASIC and financial services. They'll have their code obligations in relation to being a member of a professional body. And now, of course, the AUSTRAC and AML tranche 2 obligations. So the intersection of code obligations, I think, is an important one for us to navigate. But I would say AUSTRAC have been very accommodating, and we've been working very proactively, that is the profession as a whole, in addressing those concerns. At a very practical level, it's about the systems and the processes, the documentation, the practice management approaches. How do we embed this discipline? And if we think about, we often try to convey this to regulators about thinking about a sole practitioner in regional Australia working 2 days a week. How are they going to comply with this? And making sure we bring those issues to the table. So what we have done is we have provided our members with access to free resources in relation to workbooks and guidance materials to get them onto this sort of travelator, this fast-moving travelator of compliance, and to also to convey to them that, come 1 July, the sky's not going to fall in, but it feels a little like that at the moment. We understand that. And our own lived experience from a group perspective, from an IPA group perspective, is that we have lived experience. Our sister body in the UK, the Institute of Financial Accountants, has been operating with the UK-based regulatory regime on AML supervision for almost 10 years. We are in the UK a supervisory body, so we understand the space, but we also understand the member sentiment of saying why do I have to do this? Why are these obligations being pushed onto me? When we address that from a public policy perspective, members understand it, and our view is we, affectionately refer to as just taking members by the hand and just saying, we'll help you and we'll guide you and provide the resources to them in an open source way. So we're doing our bit to address that from a practical point of view, but it's a very real sentiment around what do I need to do to change my practice management approach, my documentation regime, know my client, how do I demonstrate that, and again, how do I make sure that I'm compliant?
Thanks, Mr. Conway. Mr. Liana, did you?
I was just going to add, the fact that the AUSTRAC guidance was running to like 400 pages.
Is that how long it is?
Yeah, and it was like, well, that's a lot of guidance. So you need guidance for the guidance. So part of our job is doing that, and also
trying to simplify, trying to point out the most salient aspects
as much as you can to comply, and the need even for like software and completely different systems and processes. That is a cost.
Yeah.
That you're going to need them if you're going to actually comply. And a lot of these costs you may not necessarily be able to just pass on to your client.
Yeah.
A lot of our members don't have the sort of clients where you can pass on those costs. So the cost of doing business has gone up, but they do, by and large, the vast majority want to comply. I mean, I know we're talking about the ones that don't. But just the processes that they've got to go through to, it's not just know your client, who are they, where do they live kind of thing. It's knowing everything about that client, the politically exposed people, to the nth degree. And so a lot of members are saying, well, how are we supposed to know that? But they're going to have to know a lot more than they know. So all of that is very much playing on them.
Okay. Thank you.
I guess it's a bit like doctors. There's clinical hygiene, there's also economic hygiene, and sadly we have some very creative operators, international entities and some homegrowns as well, who are seeking to play in the space. So when we use the words AML and CTF, if there are any, good Aussies out there trying to keep up with what's going on in the nation, we're actually talking about a second tranche of reform that's been adopted across the entire world. You said that it's been, I know you've been an AML supervision system provider in the UK since almost 2015, I think it was. Yes. It's 11 years later that it's getting to Australia. It was committed by Mr Morrison, who even dropped into Rome to say, yes, I'm on board with this, on his way to Glasgow, 100%. Didn't happen. There's been incredible resistance. But this is to prevent, let's be clear, in the geopolitical reality, anti-money laundering. I just mentioned Commonwealth Bank, ANZ and National Australia Bank, who are looking at the tune of hundreds of millions of dollars that have been fraudulently acquired by sophisticated money laundering systems that they're the equivalent to some large international entities. And the other part of it is the counter-terrorism finance. We do need to do this work, and we could not stay any longer in the company of Haiti and Madagascar, which are the other two recalcitrants who'd committed and didn't proceed. So, there is change, and this is financial hygiene in the national interest.
Yes, and we have never, ever been against the AML CTF laws and regulations.
Yes.
We understand the position of Australia as a country and whether or not we have fulfilled our obligations. And in fact, I was here all those years ago giving evidence. And we had the same position back then. We're not against it. We 100% support it. Our only sort of real advocacy was around let's try to make it as streamlined and as efficient as possible for those who have to implement it, yes, which you would think would also help in the detection of financial crime. Correct. So anything that we as a body and our members can do to detect financial crime and all that happens to facilitate, we are 100% there. We just want to make sure that our members are in a position to actually be able to implement it, because we have never, ever been opposed to it. We absolutely see the need for it, like every single day, all of us as citizens do.
And it's a sophisticated international market now in terms of products that people can access with a huge market. So I expect costs for Australian businesses to adopt the change are far less than first adopters. So, you know, it is change, absolutely, and all change costs intellectual energy in addition to a financial impost, but it's just a part of doing business. In every industry, we all have to keep up with change. Can I go to just a general question in terms of the First Guardian and Shield matters, the whole ecosystem, research houses, auditors, accountants, trustees have all been implicated in this. Have you investigated whether any of the people who are registered with IPA are involved in those matters?
We have had a look and we follow what's happening in the media obviously quite closely. We're involved in advocacy around managed investment schemes and a whole lot of other things in the financial advice space. We, so far to date, haven't come across any IPA members that are implicated. That doesn't necessarily mean that some may come to light further on down the track. ASIC has been wonderful at now disclosing to us when our members are involved in...
Is that a change of practice?
Yes.
And since when?
I'm not sure exactly since when. At least, I would say at least a year. But I could give you the exact date. But it has definitely been a change, and that has been really, really helpful because then we can take action immediately. But we always monitored in terms of news releases to see, you know, we've all got our sort of our intelligence sources and other ways of sort of finding sort of instances of wrongdoing. Of course, it's helpful if you get advised, and sometimes members disclose what other members are doing and things like that.
Yeah.
So if we do hear, then definitely we can take action. But until then, we're monitoring. We haven't seen anything come up in our CRM system that discloses those entities. We don't have a huge number of members in that space, but we'll just keep monitoring. But so far, at the moment, we haven't come across any members that are involved.
And the same for the Commonwealth Bank, NAB,
yes,
and ANZ matters? You haven't found any members associated with that in any way?
Not so far, no. But we'll keep monitoring.
Right.
And things may come to light. Sometimes members do actually self-report and disclose sometimes. It can be quite surprising, but we'll just keep monitoring. And there's a lot in the media, but we have a dialogue with the regulators, so we'll just keep monitoring.
So I guess there's the efficient way of having a register of these things for trusted entities to be sharing information, which doesn't seem to be formalised in any way. And then there's the grapevine, which can be more of a risk to personal reputation than anything else. And the haphazard nature of that, I think, has been well displayed as the current practice. And it might serve a smaller population and a smaller group and another time, but I would put to you that it's increasingly inefficient and ineffective in a digital world and where a global economy is operating. And we have malign players from overseas who are seeking to disrupt Australia in every possible way at a social level, but also in our financial service sector. So I just put on the record for you, as I have for the other witnesses today, that I think this is a pressing issue that the sector needs to grapple with, and the conversations with ASIC, of course, would be a critical part of that, and of course AUSTRAC and perhaps even APRA. But there's a lot to do there. If I can go to the matter of Mr Ryan O'Shea, there's a number of documents that I'm about to table, and a similar set will be made available to ASIC. I've got more copies here. I might just give them to the Secretariat. But if we can get those to Ms Stilianu now, and I think digitally they might be coming to you too, Mr Conway. While that's being distributed, can I just go to the ASIC statement released on the 24th of October 2025,
through which the company's Auditors Disciplinary Board, CADB, has handed down its decision on company auditor Ryan William O'Shea for failing to carry out or perform adequately and properly his duties as auditor of an entity called United Global Capital, second entity Global Capital Property Fund Limited, GCPF, and UGC Global Alpha Fund Limited, known as Alpha Fund. The scale of this is extraordinary because we're talking about $92 million invested into GCPF and Alpha Fund, and predominantly by self-managed super funds. You know, I'm hearing a steady refrain here about the vulnerability of self-managed super funds and exploitative practitioners who are smelling like honey, like bees to a honeypot, you know, or bears to a honeypot. They're moving in 15 property developments at 93 million, unit trusts with Alpha Fund 6.5, loans to a Mr Hewish for which there were no loan agreements, echoes of their NAB, you know, fraudulent loan dimensions. ASIC indicates that it makes interim stop orders with regard to that. So clearly this is matter that's quite public. But as you would have seen earlier, when I provided documents to CANS, where Mr O'Shea was a member, he has now switched the logo, no longer as of 2023-24 using the Chartered Accountants logo, but if I can draw your attention to the Gold Preschool Association Incorporated document, which should be amongst those ones you have, where the IPA logo is clearly evident in the bottom right-hand corner of the last page. Is Mr O'Shea one of your members?
Sorry, what was that?
Is he one of your members?
Yes, Mr O'Shea is one of our members. He joined in 2023. ASIC advised us of the outcome of the CADB hearing. We commenced action against him. We've given him warnings.
So can I just get the sequence? Before you let him join, were you aware of the CADB matter?
Of this
when
matter?
did ASIC advise you?
It was at the end of October 25.
So post his registration with you?
Yes.
Okay. But the CADB document was October 25 and you knew nothing about him. Did CANS get in touch with you at all?
Not that I'm aware of. He was when he joined IPA, he was shown as a joint member with CANS.
Okay. And what's the processes when somebody wants to be a joint member or transfer between one or the other? Because we have taken evidence on this before and I thought it sounded robust, but clearly something didn't happen.
We do seek proof, like evidential proof, that they're a paid up member of the other body. So we take that on board.
But you don't have proof about whether they're acting ethically or if they're dodgy as all get out?
No, not as such, but the assumption is that if they're still a current member, that they're a fit and proper person.
Okay, yet we do know, and you would know too,
Yes.
that there have been some lengthy considerations by the disciplinary boards of these people and that there is a time lag. Again, it looks to me like there's a big, dark, dangerous space where nobody's able to see what's happening in terms of the movement of these individuals around and amongst the organisations, yours, CPA and CANS.
Yes, and I think one of the things is that a proceeding will start and it could take months, it could take years until it gets to a conclusion. Usually we're notified at the end of the process rather than at the beginning.
I understand that's the practice.
Yeah,
I'm pointing out there's a problem. What's to prevent like-minded entities that are supposedly collectively upholding professional standards of accountants and auditors in this country from communicating at the point of knowledge that an inquiry is on foot?
And I think that's where we need to land. I know that we've had quite a bit of legal advice on this from at least 2 legal firms about what our obligations are and what we are supposed to not disclose and what we can disclose. So we follow those, and we follow that direction, that legal direction, and also the privacy legislation changes that happened in the last couple of years that have really sought to strengthen those privacy situations. So we're very cognizant of that. We have changed our processes to be able to get consent from members to say that they agree to us being able to disclose certain information.
Again, I would say if you're under investigation, you've shifted from one entity to another, there are suspicions about what you're doing, ASIC is inquiring into you, you don't get to say, oh, yes, you can release my name or have a conversation with another entity in that ecosystem. Like it just doesn't wash in terms of the pub test to which we are frequently subject. Like, people knew. People knew about this guy. And he's not operating at a small level. We're talking about just one audit there of $93 million.
The other issue that is often the case is when people use, people like Ryan O'Shea, use multiple entities, multiple names, multiple structures, and we have to be across all of them. I mean,
so is your hygiene, if I could put it that way, in terms of disclosure to you, know your customer, sufficient to meet the challenges of 2025 in Australia?
I would say for the vast majority of members it is. I think for people like Ryan O'Shea, who,
I disagree. I'm going to disagree with you, right? They have served you well, but clearly there is a breakdown.
Yes.
And sadly, when people do the wrong thing, others have to fill in forms and self-identify what's really going on. Otherwise, the whole institute is compromised.
Well, as soon as we find out, and we have ways and means of monitoring what's going on, but I cannot say that we are going to know 100% of everything that goes on by everyone and every entity. As soon as we find out, even if it is, sometimes we get, shall I say, tips from members of the public,
yes,
then we can investigate. Sometimes we get people wanting to, say, whistleblow. We had one recently where someone who was not a member of the IPA wanted to whistleblow. The problem often is that they don't want to hand over too much information for purposes of risking recriminations.
Yeah.
So we can act on what we're given, and we can take it as far as we can take it, which we do.
I understand, and we're getting down in the weeds, but I understand the limitations you're operating within. I'm just saying that it's not working. And it's not working to 2025 level of scrutiny, I believe.
No.
Have you taken any steps to discipline Mr O'Shea and remove him from the membership following the transmissions documented in CAD-B?
Yes, we have. So once we were notified by ASIC, we started our own process. We issue a show cause notice. He was given warnings. We asked for certain information to be given to us. Certain things then transpired. He gave us some information. There were issues that he expressed to us, which I think I'm happy to disclose that, perhaps confidentially. I don't know if I'd want it on the public record. Certain things that he said to us. So he's going through that process at the moment.
So he is currently subject of a disciplinary committee review, is that correct?
Yes, he's been investigated already, and then it's
just... Is complete or ongoing?
It's nearly complete.
Okay.
I do notice also that he's still currently a registered tax agent.
He is indeed a tax agent registered with a TPB according to their website as of yesterday. So
yes, we checked this morning.
I checked yesterday. He was still there.
Yeah, he's still there.
And I kind of think, given what you know about him, what CAD-B have said about him, the guy's still out there turning a buck.
Yes, and the thing is for us...
Or maybe many bucks.
Yeah, and that's correct, Senator Chair. And as you've heard already, the issue also is that, I mean, we could fine him, we could forfeit his membership, we could do our absolute worst, but that is not going to stop him being able to go out, or anyone for that matter, to go out to the public and offer services, because he still holds a statutory registration, which we have no control over.
So did you advise the TPB of the actions you were taking?
No, we haven't, no. Sorry, Andrew, did you want to say something?
Look, I was just going to build on that point, but just briefly, Chair, is that the issue around the capacity for us to intervene, as Vicky's pointed out, in terms of limitations. I think other professional bodies have spoken about the forfeiture, censure and fining and suspension processes, but without the statutory ability to intervene, we simply just don't have those powers. And it's a matter, obviously, for the regulators to put some sort of a stop all or some sort of intervention or injunction to prevent somebody from doing that. We don't have those capacities at law to do that. So I absolutely accept the line that your inquiry in terms of how do we stop practitioners, their own malfeasance, these people who are with malintent from forum shopping and getting through the side door or the back door of another body and inflicting harm. Absolutely agree, and we are absolutely committed to doing whatever is possible to avoid that and to eliminate that. And from our perspective, making sure that they don't inflict any further harm and shortening as tight as possible that process from notification of issue to removing them from the membership. That's absolutely our principle. So I completely agree with the line the approach you're taking and the committee's taking on that, and we'll do whatever we can to support.
Thank you. Could I go to two other documents from October last year? An article in Accountants Daily by Emma Pardis, the 28th of October 2025, and also the CAD-B press release of 24 October. I think you have copies of those in front of you. Just draw your attention to the statement by the CAD-B regarding Mr O'Shea continuously failed across multiple audits to undertake sufficient, then brackets, or any, close brackets, work to determine investments in Global Capital Property Fund Limited were made on commercial terms. He failed to identify that there was appropriate evidence to support the values of the investment and the investments were recoverable and that the investments had been adequately disclosed. This was in circumstances where it was clear from documents that there were potential impairment indicators that had not been investigated. Mr O'Shea was not corroborating the evidence provided by directors who had direct financial interest in the investments, and the risk of management bias was significant. CAD-B also found that the extensive and serious nature of Mr O'Shea's failings justified a finding that he was not a fit and proper person to remain registered as an auditor. Yet he's still listed on the Tax Practitioner Board. He's still able to hang out his shingle and go out and use your logo while you investigate him, and he's still able to operate in the way that I think has been revealed to be profoundly at odds with the expectations of the sector. The company documents have some implications for the directors associated with him. What do you do with that kind of information? To whom do you disclose that?
Well, I would assume, again, it's an assumption, that TPB would be aware of this. I know that the regulators regularly exchange information, so I would expect that the TPB will take action against him. I mean, he's about to be, well, I can't preempt the decision of our Independent Professional Conduct Committee, but our recommendation is that he be forfeited. That's in train at the moment, as we speak, basically. He was afforded, for the sake of procedural fairness and natural justice, he was afforded some extensions of time from as soon as we started our investigative process, but they have now come to a conclusion, and that's the point that we are at. So I can only really speak for the actions taken by the IPA.
Could I just get you to check on notice where Mr O'Shea became a member of the IPA if you don't have the exact date?
or you do?
It's 2023, and I'm pretty sure it's October, but I can give you the exact date.
I'm keen to get to see what the crossover with Cairns is. Is there any part of your membership process that queries the membership of other professional bodies, or is it by self-disclosure?
As to whether they're members of another body? We ask for evidence that they are current members of another body.
So
yes.
but without any attestation of fit and proper.
When they join, even as joint members, we do go through a particular process that tests fitness and propriety. They have to I know it's self-reporting, but they're supposed to disclose if there's any current actions against them, any past actions. Usually we go back at least 5 years, and we ask a series of questions. If they're a member of one of the other two professional accounting bodies, that we take that as, that's pretty weighty evidence of their fitness and propriety, but they are supposed to disclose if there's anything that would go against them being fit and proper people.
And when you find that they don't disclose, will they ever get $100,000 of fine?
I don't know if they'll get $100,000 of fine. That's up to the tribunal. But certainly we would take action. If we find out that someone should have reported something that they didn't, then yes, that in itself is a breach of our bylaws.
What about if they left membership of Cairns, joined IPA and then held out still in the public place that they were a member of Cairns and signing independent reviews? Is that a breach of any of your bylaws?
Yes, because if they tell us that they're a member of another body when they're actually not, we would find out, because that would mean that they can't provide the evidence that they're a current member. In the case of Mr O'Shea, he showed his membership of Cairns. So when he joined IPA, he was a current member of Chartered Accountants Australia and New Zealand at that point in time. But if they hold themselves out to be a member, whether it's of IPA or any other body, and we find out, then we send them a cease and desist notice. And that does happen from time to time with ex-members. Sometimes people who are never members, they just appropriate the logo. So that does happen from time to time. And then we would rely... usually it's members...
Can I put it to you? It needs to be a rather expensive exercise. Do you know, if I thought I was going to be charged $100,000 for using your logo, I might think twice. If it's going to cost me $5,000 and a bit of paperwork, and I'm going to make $100 out of it, like cost of doing business for the unethical person, it doesn't matter, right?
Yes.
So I think we're seeing a lack of incentive to do the right thing, because some people are probably behaving in a way that's unethically to make the money.
Yes, and our disciplinary tribunal is definitely increasing the amount of fines, the amount of the fines, and I would, if I was to speculate as to trends, I would say, and not just speculating on trends, but based on what we've seen, the penalties are getting harsher.
I think it might be, if I can say, about time.
Yes, and I suspect they will continue to get harsher.
And I don't even know at the highest level that's been advocated for today that will be sufficient to really pull in the cowboys. Could I just go to another piece of evidence? Like, so far, all the documents that I've put to you are ones that have been tabled earlier today. I'm tabling 2 additional documents right now. And for the first one, I want to ask, can the IPA, and it's Mr Conway or yourself, please explain the importance of an external examiner who are qualified to examine records of law practices and approved barristers' clerks. Do you know anything about that?
What's the context of that, Chair?
Well, do you know of the process?
Of members who are accredited as external examiners? Yes, our members are accredited under various pieces of legislation and regulations to be, let's call it audit and assurance in different sort of industries or professions, and that's one of them, if that's what that is.
And that profession that we're talking about is the profession of?
The legal profession.
The law?
Yes.
Okay. So that's a pretty significant professional responsibility.
Yes, absolutely.
Can Can I just ask you to look at two documents now? One is the external examiners. It's a document I picked up from the internet. Working with an external examiner. Who could be an external examiner? Appointing an external examiner, annual trust examination, termination. An external examiner is a high status role.
Absolutely.
And it's given to a person accredited with you,
yes.
IPA,
yes.
And they interact with the legal profession to a level where they can examine whom about what.
I would have to take that on notice as to exactly what they examine. Usually it's financial statements and financial records, but in that particular context, I would have to have a look to see exactly what it is that goes beyond that, or if there's anything in particular. I know in terms of trust accounts, that is one where there's a lot of scrutiny of anyone who audits trust accounts, whether it's trust accounts of the legal profession, real estate agents, anyone else who holds trust accounts. It's usually those two. So
accountants, lawyers, and
there's also real estate
agents are very intimately connected. Most people might make one purchase or a couple of purchases of a house over the course of their lifetime, and they interact with all of those people with regard to those transactions. It's a connected group of highly educated, highly valued professionals, fundamental to the proper functioning of the movement of real estate in our financial sector.
Yes, and there are very strict rules around independence. And in fact, the three accounting bodies, we are now in the process of revising the independence guidelines that are part of the Code of Ethics.
Well, let me say I think it's a very good idea, because I have now just put in front of you the list of external examiners, and it's described as external examiners qualified to examine the records of a law practice or approved barrister's clerk where a lot of trust money is held. Millions, dare I say billions of dollars perhaps on a day could be transacted through these accounts. Could I get you to shift through a couple of pages to get to page 3 of page 9?
Yes, I see.
Now, the heading is Victorian Legal Commissioner, Board and Commissioner, External Examiners, updated the 2nd of October 2025. Now, despite what CAD B says about Mr O'Shea, what you know about Mr O'Shea, what CANS knows about Mr O'Shea, what's on the public record about Mr O'Shea, what the TPB knows about Mr O'Shea, Mr O'Shea, through an accounting firm called Audit Able, is still, according to this document, an external examiner qualified to examine the records of a law practice or approved barrister's clerk. Does that give you any cause for concern, Mr Conway?
It does, Chair, and I agree with that sentiment. We don't want practitioners like Mr O'Shea in our profession, and what we are trying to do is identify ways and means for us to get them out of our professional body and our profession as quickly as possible. Does that meet the committee or the community's expectations at the moment? That's obviously for you to advise us in the community, but we're doing our best to get him and practitioners like him, hopefully there aren't any more, out. So it is a concern, and it is an important role. There are a range of other roles that practitioners will have in terms of the ability to provide assurance and review engagements for not-for-profit entities and a whole range of entities. And I think the observation you're making is fair, that it is patently unacceptable for that gap to exist.
So this guy is really good at filling out the forms and finding the gaps. I reckon he must have rode the London Tube for a long time. Mind the gap, mind the gap. This guy is the gap finder. He's better than, a front rower in a test match for Australia getting through the gaps. This guy is unbelievably adept. He is playing the entire system, and his case reveals profoundly broken structures in terms of knowledge sharing and prevention in the national interest. This document asserts that all persons named on this list satisfy the criteria set out in sections 155 to 156 of the Legal Profession Uniform Law Victoria and Rule 65 of the Legal Profession Uniform General Rules. Each have given the consent for the board to publish their contact details, arranged in alphabetical order by location for ease of reference. Here you go. Bring this guy into your law practice. Bring him into your barrister's office. And he is making a mozza, I'd expect, out of shopping himself around and playing for time through every position of inquiry that he's been put to. How many more Mr O'Shea's are there? And
That's an extremely good question,
I have no idea.
And I think it would be a useful exercise for us to have a look at as many, especially with AI these days, as many public registers as possible and do some kind of analysis of all the names. Certainly for example, we could take all of these names and put them in our database, see how many are IPA members, and then have a good look at them in terms of a risk analysis. And with as many other public registers, because there would be other legal services boards, obviously, around Australia.
And that's a very, noble sentiment for you to undertake to do that. And I'm going to ask you to make sure that you also inform the Victorian Legal Services that Mr Abel is not a competent or suitable person to discharge the duties of an external examiner, in your view at this point of time, and advise them of what's going on. But I'd put to you that it's not just a single instance, that there are people who have these skills who for various reasons are operating at the edges of the law and using your insignia, that of chartered accountants. I wouldn't be surprised to see them come to the CPA for the next one.
Yeah.
Right? Big problem. Can I ask you to take on notice? Mr Conway, you want to make a comment?
I was just going to make a point, though, just to reinforce, and I'm sorry if it goes over some old ground, but absolutely take on board that focus in relation to our obligations and notification. As Vicky's pointed out, the process we go through with the public notification, and again, we're trying to make that as quick as possible. But I do point out the limitations in relation, again, to our capacity to intervene and to take any form of sort of statutory approach. There is obviously this intersection between the statutory regulators' obligations and their powers and ours, and who does what in this instance. And I think, that requires some ventilation, clearly, in the public interest. And so we're keen to engage in that. But I just wanted to reinforce that point around the limitations that we have, and we're doing what we can within
I understand where we are and the historical reality, but I've also seen a lot of traffic light determinations about many things in accounting, green, orange, red. To be verified. Could be at the very beginning just an indicator. This is a person who's completely compliant, we have no concerns. There are no indicators. Orange, watch out, right? There are a few little signals. Red, this is the experience, you should be very careful in dealing with this person. At the very least, we need something.
And we do operate a system.
Mr Conway, and then I'll come to you, Mr Liano.
Sorry, Chair. Thank you. I think there are some. I agree with you in terms of the sentiment. There are obviously some practical challenges that give rise to questions about where is the line in relation to, the notification of a complaint that's made against the practitioner versus statutory enforcement action or pending enforcement action. Because, of course, for some practitioners, they may be in nature of some form of complaint or investigation that is then unfounded, yet there is on a public register, to your point, an amber flashing light saying be cautious. Practitioner suffers detriment and loss. How do we navigate that space whilst maintaining a focus on public? So I'm not trying to.
And is it a matter for the public? Perhaps not. Is it a matter for the ecosystem and the integrity of the financial sector? I would put it to you, it is in all of your interest to be sharing this information in a respectful, discreet way that provides the protections that I think Australians deserve. And that's a big policy challenge to be faced. But I hope today has demonstrated there is a very big problem that needs some further investigation. Can I thank you for being here with us today? There will be questions on notice, and if you could answer those by Friday the 10th of April, that would be of great assistance to the committee. Thank you for attending, and we will have you again before this committee next year, and we might try and range the date to be after the 30th or the 31st of March, whichever one it is, so that we can pick up the most recent data, because your brief was a little shorter than the others, sadly, because of the date and the timing. So we'll look for a fuller submission next year. Thank you very much.
Thank you, Chair.
We'll take a break for 2 minutes to allow ASIC to come to the table. We'll try and get out right on full, which means there could be a bit on notice, but yeah, good. Thank you. The committee will recommence, and I now welcome representatives from the Australian Securities and Investment Commission. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. For the Hansard record, will you please state your full names, the capacities in which you appear today?
Yes, I'm Sarah Court, ASIC Deputy Chair. Kate O'Rourke, ASIC Commissioner.
Claire Labouchardie, Senior Executive Leader of the Sustainability, Financial Reporting and Audit Team.
Chris Savundra, Executive Director of ASIC's Enforcement and Compliance Team.
Thank you. Thank you for joining us today. I've already acknowledged the day-long attendance with us of Commissioner O'Rourke and Ms Labouchardie. Thank you very much for joining us this afternoon, Ms Court, Commissioner Court, and Mr Savundra as well. I now invite you to make a short opening statement. Thank you for provision of the hard copy for those in the room and digitally, I think, for those around the country. At the conclusion of your remarks, I'll invite members of the committee to ask questions. Ms Court, thanks.
Thank you. Thank you very much.
Commissioner Court, sorry, I'll give you the due recognition.
Thank you very much for the opportunity to come today. I'm aware that you've had a long day of evidence. You've already been introduced to those who are with me here this afternoon, so I'm just going to make a few brief remarks about ASIC's work in this area. So a key strategic priority for ASIC is strengthening market disclosure and specifically financial reporting, sustainability reporting and audit. And in terms of our enforcement work, financial reporting misconduct and auditor misconduct remain priorities for us, and that's of course because high quality financial reports and audits are critical to informed investor decision making and to market integrity. We have discussed before with the committee ASIC's role in relation to auditors and the fact, well, in fact we've discussed that on many occasions in the past. And as the committee is well aware, there are some constraints that can impede our ability to take action. We regulate individual registered company auditors and we regulate authorised audit companies. We administer the requirements of the Corporations Act as it relates to auditor independence and audit quality, but we do not regulate, as the committee knows, the accounting or consulting professions more broadly. And many large accounting, audit and consulting firms operate as partnerships, and we do not have the power to regulate these. And we also don't regulate the staff within these firms where they're not registered with ASIC. The role of an auditor is, of course, to independently examine a company's financial reports to ensure they comply with the Corporations Act and accounting standards and to determine whether those reports provide a true and fair view of the entity's financial position and performance. We continue to take action, enforcement action, against auditors where we consider there have been breaches of the law, and we share that information with the professional accounting bodies where we can. Just in relation to information sharing, since we were last before the committee around this time last year, we have worked intensively with the professional bodies to improve the regularity and the efficiency of information sharing, and we've now formalised regular information sharing arrangements that replace what were our earlier somewhat ad hoc processes, and that has improved the timeliness of referrals and reduced the risk of regulatory gaps between ourselves and the professional bodies. I think Senator O'Neill, indeed, there was a question you asked just of the last witness about the engagement of the IPA with ASIC and whether there had been changes and when those changes had taken place. And I think the witness didn't have the exact dates there, but what I can tell you is following the attendance here last year, as I say, around this time, we have very significantly increased the interaction with all three of the professional accounting bodies. I think the statistics are that we have shared information with them in the last 12 months on 30 different occasions, and we have in turn received from them information on 24 separate occasions. So that does reflect a very significant uplift, and I'm very grateful for the work Commissioner O'Rourke has been doing along with Ms Bachadier on those issues, and happy to come back to those statistics if you'd like.
Just before you proceed,
yes,
if you can give us an indication of what it was like in the previous year in terms of meetings, 30 occasions since last year.
I think those statistics were about information being shared in writing rather than in meetings. So, yeah, but we might come back to that after the opening statement.
Okay, and the same thing for the 24 occasions, so we'll come back to that. Thank you. Back to you, Ms Court.
I should correct the record, Senator O'Neill, sorry, it's 25 times, not 24, that we've received information from them. And then just quickly turning to our strategic work, our surveillance work and our enforcement work. We have now reviewed financial reports and audits of registrable superannuation entities for the first time. That's a significant new piece of work for us, and in September last year we released a report finding that directors, superannuation trustees and auditors all needed to improve the quality of financial reports and audits, particularly when valuing investments in unlisted funds. And then in October of last year, we released a separate report which found that auditors from firms of all sizes often could not demonstrate compliance with independence and conflict of interest obligations. And we are now selecting audit files for review where we have independence concerns to consider whether there is an impact on audit quality. Another report in October last year, so this is the third of 3 reports we released across September, October last year, into the Oversight of Financial Reporting and Audit, reviewed 254 financial reports from listed and large proprietary companies, and we conducted surveillance of a further 22 companies. The result of that work was that 18 companies made or agreed to make changes to their financial reports. In our 2025-26 audit surveillance program, we will be expanding the number of audit file reviews that we are doing, with files selected both randomly and where there are concerns about auditor independence and conflicts of interest, and we will be monitoring the response to the findings of those reviews. Our surveillance work will now also, of course, include reviews of mandatory sustainability reports. So this is another significant new piece of work for us, and we will be taking a pragmatic and proportionate approach to supervision and enforcement in the early years of that regime, as we have talked about extensively publicly, and we will be supporting industry through guidance and education, recognising the very significant transition the industry is underway with. And finally, Senators, we have also recently strengthened our enforcement actions against company auditors. We've had a range of enforcement outcomes in the last 12 months, and they include imposing conditions on registration, referring matters to the company's auditors disciplinary board, and I understand you've had some discussions about one of those particular matters in the course of the day. Those have resulted in cancellation of registrations. We have also issued infringement notices, and most recently we've upped the ante and taken civil penalty proceedings in the federal court against authorised audit company BDO Audit WA and one of its directors. I was looking at the statistics of the number of matters that we have underway at the moment, Chair. We've got 36 open auditor matters at the moment, 18 of which are in preliminary investigation and 18 of which are in our general investigation list, and 8 of those relate to auditor independence and conflict of interest concerns. So that's a very broad sweeping overview of the work that we're doing across surveillance and enforcement and our engagement with the professional accounting bodies, and very happy to hand over to you. Commissioner O'Rourke has just reminded me we have a prop today that we can provide you with if it is of assistance. Because we've had discussions, Chair, here at the past about what ASIC does do and doesn't do, and it is quite a complex area, we've just prepared a placemat that sets out for the committee's hopeful benefit how we see that, and it might just help with questions this afternoon.
Yeah, thank you very much. I think we have well traversed over the time, but we've got a lot of new members on here as well, some with a lot of experience in this sector and others less so. It is always helpful to have a clear outline of where the limits of your powers exist. I guess what we've been documenting today is that there is no limit to the abuse of knowledge for self-interest, and the question is who's watching, because it cannot continue to be unwatched in the way that it is. So I don't know, it's a bit like cleaning the toilets in the house. If it's not somebody's job, it doesn't get done, right? Somebody's got to do the job.
I haven't heard that analogy before. I will take it.
Right? Not something that everybody wants to do, but it's nonetheless something that has to be done, literally, for hygiene. If I could thank you for that document, and thank you for your clear indication of matters that you're overseeing. Could I ask if you're aware if the company auditors, the CADB, would normally advise external entities about their decision directly, such as the Victorian, I'm just going to look for I don't want to misname them. I've got so many pieces of paper here. Where is it? The External Examiners Board in Victoria, where Mr O'Shea was continuing to be an auditor approved for barristers and solicitors. Is that the sort of thing that CADB would be responsible for cleaning up?
I'm happy to have...
Thank you.
I can't speak for CADB, but my understanding of their practice, Senator, is that they would publish, like they have a publication upon decision. I think we've talked before about how they do not publish upon commencement, but certainly upon decision. But I'm not aware of a practice of sort of active distribution to the equivalent of the Examiners Board or group that you've identified. So if we can find out through the course of the hour if that's different. But
I guess one of the questions is, in terms of a deep dive into somebody and undertaking the course of inquiry, I mentioned the concept of, hygiene in terms of information shared if you're going to join a particular entity. What information is shared with CADB? Would it be a requirement in that inquiry for the person who's being considered fit or unfit to continue with practice to identify all of the entities with which they interact?
Like I said, I'm not aware of that being an element of the CADB process either during the course of their hearing or at the conclusion of it. I understand that they focus their attention on the provisions that they're administering and whether or not there has been a breach that...
And they put out their statement and there's a general assumption, which is that dangerous, that people will be paying sufficient attention to pick up this information.
Yeah, I think we heard evidence earlier today from the various professional bodies about their monitoring of the decisions, whether they be ASIC decisions, CADB decisions or otherwise, TPB, and their distribution. But I'm not sure that the CADB itself has that knowledge about that particular person's other qualifications or memberships and that active step that you've described. Like I said, if we hear otherwise from CADB, we'll let you know, but that's not my understanding of their practice.
Thank you. It just seems to me that there's a whole set of practices now that are coming into place with our banks and with the AML CTF regime, now Tranche 2 being implemented, where there's a requirement for everybody, if I can say at the bottom of the food chain, who's using the service to provide information up, but those who are actually in charge of the monitoring are assumed to be operating ethically, and what is the hygiene test and to whom is such a thing reported? How is information shared when it becomes clear that there's a problem in the ecosystem? And I don't know that we've got any satisfactory sense of the lie of the land out of today. It seems there are many very dark corners and hidden places in which those who wish to exploit our current generous system are able to operate and exploit others who seek their services and perhaps have a misguided belief about how ethical somebody might be that has a shingle with CPA, IPA cans on it, for example.
Yeah,
Commissioner Court.
Yes, sorry, I didn't mean to interrupt you, Chair. I mean, I think the point that you make is a very fair one, and the committee has raised it with us before, so in a slightly different context, but I think the issue is the same that you're drawing to our attention, that being that we've got a range of different regulators and professional bodies involved in this oversight. And I think, Senator, previously the issue has been when ASIC takes action, whether it refers a matter to the CADB or whether we take our own enforcement action, issue an infringement notice, cancel registration and the like, what do we do with that information to make sure that it is as widely understood by all of those different bodies? I think we've got a lot better at that in the last year, as I said, and I think the evidence, as I understand you've heard it today, reflects that. In terms of the CADB decision, we, ASIC, notified the IPA as soon as that decision had been made available. Now, I think it's a question we can take on notice and think about, should we, ASIC, have issued that more broadly beyond our media releases and all the normal things that we do? And I think, as I understand it, there has been evidence today, as Commissioner O'Rourke just said, that a lot of those bodies are watching our media releases, the CADB releases and the like, and we put out extensive information and are as transparent as we can in relation to any of our enforcement-related outcomes. But how far we go and how many different associations we notify. I think it's something we can think about, absolutely. I think the point is a fair one. I'm not really familiar with the piece of paper that you're referring to and what Mr. O'Shea, I think.
Yeah. So I
now
didn't even know
but-
such a thing existed until we sort of started searching.
But I think it's something, again, that we can take on notice if there are these other opportunities for people to move to, the extent to which we can proactively notify those bodies. I guess to some extent I feel a little bit, is it as long as a piece of string? Because
Correct.
we don't know all of these things, but
Correct.
as I say, very happy to understand what the role is and whether or not it is something appropriate.
And whether you do it as a general,
Indeed.
burden of care to put it out, or whether having acquired from the individual a clear indication of every entity with which they're associated, then it becomes those entities at the very first level that get the information as quickly as possible. You went to IPA
Indeed.
straight away, right? So if you knew this was involved, that could happen. My understanding is the document that I tabled is from October of 2025, around the time that CAD-B came out. I'm advised that on the most recent list, Mr. O'Shea is no longer there. Which is a good thing, and it would be most interesting to find out exactly how they were informed, what was the process by which they became aware, and how they activated. So they're questions I notice that we can put to the Victorian external examiners, the Victorian Legal Services.
Well, I hope it's from the ASIC media release, Senator.
I hope so too.
I have had confirmation from the Secretariat of the CADB on their process, and have been informed that they don't take steps to inform other bodies. Their step is to post the decision on their website. But I think what you've heard is a willingness for us to think about it from an ASIC side. So that's just closing that loop on the CADB.
Yeah.
To confirm, I think my earlier evidence is so.
Yeah, I guess the whole question about registers, which register, held by whom, where, how is it maintained, all the hygiene, all those practical questions need to be answered. But I'm just concerned about people with a very high level of knowledge, very adept at finding the gaps, being able to roam freely. We've found one. How many more are out there concerns me. I'd like to ask some more questions, but I'll go to my colleagues for any questions they have. Mr Moncrieff.
Thank you, Chair. I just wanted to go to your role in, or lack thereof, in regulating partnerships. So, I understand that you're focused on other ownership structures, but obviously, audit firms, including the Big Four, play quite a significant role in our financial system. So, I just wanted to comment on whether that ownership structure is inappropriate for you to be regulating. And I understand that the states and territories are currently regulating them usually through the Partnership Act, and whether it's appropriate that we have different jurisdictions with different rules for those partnerships.
I might answer brief at a high level, Mr Moncrieff, and then pass over to Commissioner O'Rourke, who's an expert on this area. The issue that you've raised has been something that's been traversed in this committee, perhaps before your time, certainly through the PwC incidents of a couple of years ago, where the committee explored with us in quite some detail what ASIC's role was or should be in relation to some of the perceived failures in PwC, and has indeed done an inquiry, a detailed inquiry and report on this issue. ASIC's position in relation to the oversight of the big audit partnerships is that we think we're in agreement with the committee that there is a regulatory gap in Australia in relation to the big partnerships who, often have hundreds of partners. They have very significant and important roles, and as things stand at the moment, we are restricted to taking action in a regulatory sense in relation to individuals within those partnerships who are registered company auditors. but no more. Now, we do engage with those firms from time to time, particularly in the wash-up of some of the PwC issues, but I think it's fair to say our role is more one of moral suasion and setting out our expectations and concerns as opposed to having any significant regulatory hook. There are some minor exceptions to that, but as I say, we're on the record publicly as of the view that we think there is a gap there.
Yeah, no, thank you. Thank you. As well as
Miss Lawrence is online, so it'll be helpful for her
Oh,
if
of
I
course.
actually know
Okay,
you.
thank you. Hello, Miss Lawrence, and Miss Jarrett as well, I can see. As I think that is that question of the gap that Deputy Chair Court has referred to is around those firms, but it's a little bit agnostic as to whether they were companies or partnerships. Like, I think our concern is that it's at the firm level that so much of the governance and the issues that can flow through to conduct issues or audit quality issues that we've seen that gap. That being the key issue, rather than the fact that it's particularly that they're partnerships, not companies, that absence attaches to. So you're right that it's a state-based thing. We've got constitutional limitations here. So on one level, that's a little bit beyond us collectively to solve. But I think for us that gap that would be filled would be attaching to the regulatory capacity you'd have to get around that constitutional capacity, but I think that in the Treasury consultation paper, that was some of those issues were canvassed around how that might be. But I'm not sure we think that the partnership structure itself has its own problems.
So you don't think it has its own problems as in terms of regulating it, or in terms of its structure itself?
The latter, in the sense that we would be keen to progress the idea of regulation of the firms, even if they remained partnerships. That's the gap that we'd like to fill, rather than it both being attached and then them having to be converted to a company structure, for example. So it's the absence of the regulation rather than its form that is of particular concern. There were issues canvassed around the historical reason for partnership and the adjacencies in law firms and others. So there's sort of history there, and you'd say that on some corporate governance issues there's some challenges associated with regulating a partnership rather than a company. So it's not like they're identical, but the bigger issue for us is that question of just us having no connection to the firm.
And when you're engaging on those individuals who are on conduct issues or whatever it is you're looking at, do you engage with the state-based regulators as well? Is it like fair trading or whatever, or you just only directly deal with?
Because our regulatory hook attaches to the people, and they have specific requirements under the Corporations Act that we're administering, the fact that they might separately have breaches of partnership arrangements or laws, we don't focus on that. That's not our particular area of concern. So, that's really goes to the relationships between them and their partners. That's not Corporations Act.
Yeah. Okay. Thank you. Thank you, Chair.
Very much. Senator Sharma.
Thank you. Good afternoon. Nice to see you all. Have you got a position on, we were discussing earlier today, the ability of professional standards bodies to actually monitor and discipline their members, the accounting firms obviously, and there's some obvious limitations because they've got a contractual relationship only with their members. They're not empowered with regulatory authorities. We have heard in the course of the day how I think it's CA New Zealand has some sort of quasi-regulatory roles provided by statute. There's the body in the United States created out of Sarbanes-Oxley, PCAOB, I think it's called. Has ASIC sort of expressed a view on this in the past, in the context of previous inquiries, about whether something similar would be warranted in Australia, whether it's not warranted? I'd just be curious for your House view on that.
Thank you. I think it has been raised in earlier hearings, that question of how the different parts fit together. So should there be just just a statutory set of responsibilities, or if there is going to be professional standards that supplement it, should it be one professional standards bodies, or if there's multiple, should people be required to at least belong to one of them, because of course someone could belong to none of them and then they don't have any that apply to them. So that issue I think we have canvassed in the past with Senator Pocock particularly. So we don't have a view that we should convert it to a single system, or that that either a single one between the three professional accounting bodies, nor that they be collapsed in with the statutory provisions as well. What we have done is sought to make what we have got in terms of multiple layers work as effectively as possible. So I think that's the point our Deputy Chair has made, but also recognise that even in the existing one, which has layers, there are gaps, and that's what we've just been discussing in relation to what about the firms. Their members, I understand from Kansas evidence this morning, some of their members are firms, but predominantly all of us are regulating people, and there's a gap there if the firms aren't also regulated.
It just struck me as well. I mean, the ceiling on fines that they will impose is quite different between the three bodies. The fines they impose in practice is quite different, and they seem to be getting different legal advice, if you like, about what quantum of fine would constitute something that's punitive and potentially unlawful or potentially vulnerable in court versus not. And we heard, if you heard this Cairns today, it was in the order of $10,000 to $20,000, I thought, for an egregious breach, but some of the other bodies said 50 to 100, and that seems like quite a wide variation.
Maybe that's why Cairns have got more members, Senator Sharma.
I think that's unfair, Senator O'Neill. But perhaps, I mean, it sort of suggests that there's a potential kind of regulatory arbitrage play here. I wouldn't suggest practitioners are doing it, but it just does concern me a little. I think
that's right. I heard those differences as well through the course of the morning and the afternoon, but I think, as I said earlier, as beyond that, there's the capacity of someone to belong to none of them.
Yes.
Or two of them, and so, I think there is... it's not a comprehensive system in that someone has always got a professional standard that applies to them as well as a statutory standard.
That was all I had for now. Chair, in the interest of the time, because I know you might have some...
I think Ms Lawrence has some questions now. Ms Lawrence, you have the call.
Lovely, thank you. My apologies, I'm not there in person today. Look, I've just got a few questions around insurance, and some may well be best put to perhaps the professional bodies we've heard from today, and we can perhaps look at that, putting them on notice if you think so. But my question to you is, firstly, are you aware that professional accounting bodies may have commercial arrangements that are involving professional indemnity insurance and a referral incentive that are linked to their members?
Good afternoon, Ms Lawrence. I'm not sure we're able to answer that, I'm afraid. We're not aware, at least not sitting here today. Happy to see if we can get any relevant information for you, but nothing immediate comes to mind.
Okay, because when I'm just sort of looking at the peak bodies, and I just jump on like the IPA's website. They've got a very helpful ADA chatbot where I can apply and secure professional indemnity insurance, but also if I want to refer clients to insurance risk products, IPA Insure offers a referral partner option, a frictionless process for you and your clients, plus an additional revenue stream for your practice. So I guess I'm interested to understand where you've got a professional body that is there to set standards, and whether, in ASIC's view, might give rise to conflict of interest where those same members are potentially providing a particular revenue stream, and whether there's sufficient disclosure settings around ensuring consumers are fully informed about the product they're purchasing and whatnot, if there's an incentive model as well. So just trying to unpack the extent to which ASIC has a role to oversight and regulate insurance in the context of professional indemnity in this case, but protecting consumers ultimately, but also ensuring that standard-setting bodies have got a separation of any conflict of interest with revenue.
No, look, Ms Lawrence, is a very interesting point, not one I recall being raised with us previously, and unfortunately Commissioner Kirkland's not with us today, who's our insurance expert. So I'd be grateful if we could take that on notice and get some advice internally as to whether that's an issue, firstly, that we have any awareness of, and secondly, if we do, what our views are on it.
Thank you. And I guess if there are any minimum standards.
Ms Lawrence, there's a further response from Ms O'Rourke.
Forgive me for interrupting you. I just was going to say, and I think it would depend a little bit on what types of insurance those additional sales were in relation to. I think if it was, so we will need to do a little bit more digging, because I don't think we have much oversight of professional indemnity insurance, but if it was extending into, for example, general insurance or some other kind, then it may be. So, yeah, we'll see what we can find out.
Back to you.
Thank you. And in that as well, and I'm happy to perhaps put some of these in writing, but I'm just interested there's a minimum standard that's expected for insurance cover, because if I take my mind back to like the HI in the early 2000s, a lot of that stemmed from, setting the bar quite low, and so customers weren't then fully covered for the type of risk exposure, plus the incentives and referral programs, and I mean the litany of issues of culminating conflict. But it seems like there's, some issues that look like they're being mirrored today, and I'm not suggesting that there's any problem. I just want to make sure that there doesn't lead to any issues and oversight of that to protect consumers, and as I say, having that separation. So I'm happy to pop a few more questions in writing if that helps, but very keen to understand what ASIC's role is and what it sees as its regulatory responsibility there.
Thank you, Ms Lawrence. We'd be very grateful if you put those in writing to us so we can give them due consideration.
Thank you. That was my main line. I had obviously a lot of follow-on questions depending on the response, but if it has to go on notice, I will refer. I will definitely do that, Chair. So I will hand back to you.
Thank you very much, Ms Lawrence. And Ms Jarrett, you now have the call.
My apologies, commissioners and others, for not being there today. I have a few questions that'll probably jump around a little bit, so I do apologise up front. My first one relates to just your general observations. We talked about emerging trends that you might be seeing in terms of your investigations, but just generally, I think you engage obviously a lot within the community. And like, what are you seeing? Like, what are the things we really should be keeping an eye out for? You mentioned conflicts of interest. Are there specific areas of conflicts of interest, for instance? But what else?
Thank you, Ms Jarrett. And I'm assuming that you're talking about within our auditor surveillance work?
Auditor, yes, of course. Yeah, sorry.
No, that's all right. It could be a very broad answer, that's all, if you let me speak more broadly.
Within your remit, Commissioner.
I'll try to restrain myself. Are you happy to take that, Commissioner?
Yeah, no,
O'Rourke?
thank you. Thank you, and I'll start and then offer the opportunity for Ms Labuschagne or Mr Savandra to add, because there is both surveillance and enforcement. I think elements to your question, you asked about investigations, but the wider issues as well. So you're right that our recent reports have, in the sense of conflicts of interest and independence, were areas of particular focus for us. We've also spent time thinking about the new requirements, or the requirements that are now applying for registrable superannuation entities, so the extension of financial reporting in order to audit the audited financial reports for those entities. That's an important, very important part of our system with the size of superannuation funds. I think we talked about the size of the SMSF sector earlier today, but with the funds themselves being 3 or 4 times that, the importance of the financial information of that being reliable and consistent and independently verified is so important. Other areas, the third area is the extension of the requirements to have sustainability reporting, and for they're not yet applicable, but there will be assurance requirements that apply to the sustainability report. So there are three big areas. More generally, we are in discussions.
Are you seeing anything specific in that? You're not seeing stuff in that, like concerns in that space yet, are you? Or you are?
It's a little bit early. So the sustainability reporting requirements, the first batch that they attach to Group 1 companies who have a financial year from 1 January 2025 to December 31, 2025. So with those reports are coming in, but actually the requirement for those reports to be assured or fully audited has a lag. So, no, it is too early in relation to those. More generally, though, some of the issues that we are hearing in engagement include some that have been canvassed today, which include AI, use of AI in audit or in companies that auditors have been auditing the accounts for, and some of the other issues we've already canvassed, some of the more specific ones, in information sharing and some of the things that our Deputy Chair talked about in the practical sense, making our regulatory system work better. But I might just see, do you want to keep it? Yeah, sorry, there's one a little bit more.
I was just going to say, Ms Jarrett, in terms of the enforcement matters that we have had outcomes from recently, so we've had a number of court enforceable undertakings, infringement notices, cancellations of registration, and the kind of things that those outcomes relate to are things like an auditor not meeting their rotation requirements on multiple occasions, failures relating to systems of quality management for the audit firm, failures of the assurance services provide, a cancellation for holding a prohibited relationship with multiple clients. So a lot of them still fall under that sort of those broad headings of either independence or not appropriately managing conflicts, but they can evolve or emerge in a range of different forms of misconduct.
Yeah, and do you think because these issues are not new, right? They have been around for quite a while. Is your gut sense that we are seeing less of that, or is it just this? Like, do we have to really live with a certain amount of? I hate to use this word, badness, because there's always one rotten apple in the bag, right? Like, is there a standard a way that we should be thinking about this?
I think perhaps the fairest way to answer that is that we are always, when we do our surveillance work, and others can correct me, but we always find or often find, examples of non-compliance. And I think I've heard Commissioner O'Rourke give evidence previously that the degree of non-compliance, of course, can be on a spectrum. So if you're talking about how many years before you rotate auditors, well, if it's 6 years, I think that's a technical failure, but it's pretty close to the 5. If it was 15 years, that's a far more potentially serious failing. And so I think we look both in a technical sense, and when there are technical breaches, the approach that we would usually take, and again I can be corrected, but is to engage and liaise with the audit partner, put them on notice as to our concerns and to some extent enable remediation, but where those failures are, in our view, more significant, and in particular where we are of the view that the audit failure has resulted in impacts on consumers or investors, then we'll take a much more intensive enforcement response. So I hope that answers you to some degree.
I think it's a fair way to assess it, actually, saying that there is a spectrum. And do you think we're sort of moving from, just say we were more in the extreme, are we seeing a shift towards something less than that at the moment, or is it just generally still more work to do?
My own view, having been a regulator for a long time, is that there will always be more work to do, and unfortunately we can never, in any area of ASIC's work, suggests that our job here is done. And indeed, if we are ever to give that message, I think it almost gives a green light. So, my own view is that these things, they do come in waves to some degree, but I think it's important that ASIC is doing and seen to be doing its surveillance and enforcement work in this very important area to a significant degree at all times. One of the things, just briefly, we haven't talked about very much, and then I'll finalise the answer, is we have really elevated, Ms Jarrett, our attention to failures to lodge financial reports. And I think this is a relatively new area of focus for us, and we have seen some quite widespread non-compliance in terms of the lodgement of financial reports that is concerning us, and we are using that information almost as part of a sort of red flag detection to potentially more significant issues. So that's something that I suspect as our work there continues, we might be able to talk to the committee about some more in due course, but it's slightly different to that which we're talking about, but related, I think.
Yeah, and just one additional observation is that even if issues have been well known or pressures are known, that the circumstances in which they might play out can change both in complexity and significance in the economy. So an example I'm thinking about is the importance of independent valuation of particularly intangible or unlisted assets. So that's something that's been always difficult. Like, we recognise it's a challenge for auditors, but it's become increasingly important as the size and number of private credit funds grow, and they're also, even for our superannuation funds separately, investing in things that are intangible or have unlisted, getting that valuation process right. It's just one of the key issues that came through our RSE report that we referred to earlier. So you may say, look, that's something that people have over time got better at. That might be so, but gee, if it's got harder to do and more important, then to the point our Deputy Chair made, our attention remaining on that issue and us really emphasising that it matters if we're seeing non-compliance with those provisions, I think it is important.
Thank you. If I could just jump back to something else you said earlier. You were talking about this is the information sharing between yourselves and the professional bodies, and you said 30 different occasions where you've shared information and 25 where you've received it. Did you say in writing? So that's in writing?
Yes.
Yeah,
So
okay.
yes,
Okay, because the reason I'm asking is, and part of my potential ignorance here is, I understand that there has to be an exchange of information in writing. You need the paper trails, and you need to know the facts, and it's easy to get it down. But is there a reason why? Like, can you pick up the phone and talk to them? And you do?
Yes.
Yeah. Okay. I'm just asking because we've heard some evidence that sharing of information is really difficult, and when information is shared, you can only do so much with that information, etc. So I was just really trying to get a sense of, well, how easy is it to actually do your job?
So Ms Jarrett, thanks for the question. So certainly we can share information over the phone or in writing, but to the extent that the information is confidential, and there's a presumption that information that we obtain as part of our regulatory and enforcement work is to be confidential, and we are to maintain that confidentiality. We are empowered to release it to the professional and accounting bodies, but it's under strict statutory requirements, so it can be released to them, and they're under an obligation that they can't disclose it to any other person, including the accounting professional or auditor about who the information relates. So they're inhibited in their use of that information because they can't disclose it. So that's the main reason why we generally maintain or release information by way of writing, is because of those strict statutory requirements around the maintenance of confidentiality.
Can I just ask a question there, though? They can't release that information, But is there any restriction on them acting internally on that information?
There isn't anything preventing them acting internally. The issue, though, is...
they could put a red flag on an individual to watch.
Absolutely.
That wouldn't be a problem.
And I think our position is that they can then go and ask for the relevant information from the member or the auditor to provide relevant information to the accounting body. So...
is it your understanding there's any restriction on CANS, IPA or CPA in sharing any information with you that's at odds with the contractual obligations that they each emphasised very forcefully to us today?
I think it's only the contractual obligations, and I can't recall which body it was, but they amended their contractual rules recently, and since amending it, they've made 3 proactive disclosures now to ASIC, where previously there either had been none or very few until there was a public outcome. So I think it's only the contractual restrictions. I think intertwined with that...
They could be amended, as we've seen, with one of the entities. They could be amended by the membership itself to enable better protections and the flow of information to ASIC in a confidential way, but as an early warning signal. There's technically no real impediment to that type of redress or framing of the contract going forward.
No, I don't think so. And I think there have previously been concerns expressed around privacy, but I think, again, that could be addressed and cured through appropriate variation of the contractual terms.
Thank you. Back to you, Ms Jarrett.
Thank you very much. This is a bit of a broad question because we've had a lot of information shared with us today, and we've got different professional bodies, different some with their own investigation groups, their own disciplinary bodies. There are challenges. We've had people talk about the challenges at the intersection of the statutory, what we've just been talking about, the statutory requirements and practice requirements. We've heard people slipping through the cracks and working out ways to get through the gaps. Mr O'Shea's name's been mentioned numerous times. Is there a better process? Like as somebody who's sits very external to all of this, is there a better process where we can be protecting consumers by better holding to account the professional integrity of those who are to do what they're there to do in a professional capacity?
You're right, Ms Jarrett, that is a very broad question.
It's a very broad question, but it just strikes me today that there's just all these things happening, and sometimes we have to take a step back and look at a system and go, where to?
And maybe the appropriate response is that is an issue for the Parliament to think about if it is of the view that there are gaps. I think from our perspective, Ms Jarrett, we need to look at the way that we are doing our role within that complex system and make sure that to the extent we're able to, we are thinking about those potential gaps and taking action to make sure that they're filled wherever we can. And I think that takes me back to the earlier evidence that I gave about the work that we've done to improve the information sharing and the regularity of that interchange with the professional accounting bodies. And we've heard another example of perhaps, another area where we can further share that information today. So I think we need to be coming at this in terms of ASIC's work, always looking at it or thinking about it through that consumer lens, and how do we make sure that where there are particular individuals that come to our attention that we're of the view the public needs to be protected from, as an example, that we do what we can there to make sure that that's the outcome. And I mean, there are a range of ways we can do that. I was just thinking back to the example of, that the committee's talked about quite a bit today about Mr O'Shea, and just, you know, one of the things that ASIC did in relation to Mr O'Shea was because we had concerns about whether he was appropriately conducting the audits that we sought, and before the CADB process came to its conclusion, that we sought an undertaking that he would not engage in that kind of work pending the outcome of the CADB decision, because we took that view that the public should be protected sort of to that degree. So there are various things that we're able to do in terms of protecting the public, and we're always being challenged by this and other committees as to how we do that the most effectively and the most quickly, and that we are always looking and thinking about that through an investor or consumer lens, and how to maintain market integrity. And obviously the issues we're talking about today go to the heart of that. So look, that's a fairly wide-ranging, non-specific answer to your question, but I think it's one that I can assure you that we are always thinking about through that lens.
Yeah, and I think that sort of your answer almost goes to part of the point that I'm trying to get at. There are so many different players in here, and you have to approach it from your requirements and your legislative requirements. We've got the professional bodies who look at it and go from their requirements, and I look at it and I go, we have a system with all these players. It's like, we've got a pothole in the road. I might not be the person who knows who fixes it, but I certainly know what might need to be done, because I've seen enough people fall and hurt themselves in a pothole, right? Like, it's just, I think there are players that within this process that, there may well be a better way to build our system or improve our system. And I do agree, it is definitely a role of government and policy there. But yeah, I think there's a lot of gaps and a lot of players here that might be able to be simplified in some way.
All I can do is assure you, Ms Jarrett, that as long as the system remains as it is, we will be working hard to make sure that we hear the views of the committee and work closely with all the other players in that system to make sure that information is received and disseminated appropriately as much as we can.
Wonderful.
Thank you.
Thanks, Ms Jarrett. Can I just note that you, in your submission, informed the committee oversight hearing in March that you had historically, some professional accounting bodies had been providing notification on an ad hoc basis. I think we've had reconfirmation of that today. I think there was a point in the submission you stated that you engaged with CA, and CPA to formalise the notification process. Has that happened? Has there been any formalisation of CAN's, CPA, IPA and ASIC?
Yeah, Chair, yes. The answer is yes. I think it was in around June of 2025, and I'll have to work through each of the professional bodies, but we exchanged correspondence around how we could exchange and share information better. We looked at how we were providing information to those bodies and looked at ways that we could streamline and improve the process.
Okay, I'm glad that that's been formalised. Can I go to you, Commissioner O'Rourke? Sitting here through the course of the day, I'm asking that question with a sense that the formalisation of the process hasn't delivered the outcome that we might hope yet. What is your view after having listened to the evidence today in terms of public perception of this new understanding between ASIC and the three auditing regulators?
Yeah, thank you.
Quasi-regulators.
Professional bodies. I was listening out to hear if any of them were going to refer to that correspondence that Mr Savundra has referred to and didn't. So that was of some surprise. We have...
What could explain that? Because my fear is, this is the secret squirrel stuff that we do, which is completely at odds with what the messaging that we need to be in the community is. Mr O'Shea and others like you, there isn't anywhere to hide. We're talking to one another. We're formalising this. So I've come to the end of the day hearing that thinking, that is not what I heard today.
I think while that's right, neither did I hear any of them refer to that exchange of correspondence. We haven't been able in the course of the hour to find out the statistics about the information shared in the year up to March 2025. Okay. I think you asked that at the beginning.
Yeah, so on notice.
So we've got good numbers for this year, but what was the one before? I'm confident it was lower.
Yes.
So both as to what we had given to the professional accounting bodies, but also what we'd heard as well. So I think in practice we have seen increased information flowing both ways, and we will quantify that for you on notice.
Great.
So that's good. That's good.
And maybe a public announcement about that might be pretty important too, as a signal to, those who would exploit the spaces.
Yeah, thank you. That's a good invitation, because we have, I've spoken about in previous occasions, talked about also improving the number of ways in which we try and communicate, whether they be findings of surveillances or outcomes from enforcement. So thinking about that as an additional issue to bring to the wider audit and community's attention is worth thinking about. So thank you.
Thank you. Can I go to a slightly different but associated matter? You... in the same submission, you stated that all registered company auditors are required to notify ASIC in their annual statement if they've been subject to disciplinary action by any professional accounting body. I'm assuming that is after the matter has been resolved. Is that the case? Or do they report while the matter is active?
Thank you.
Ms Labouchard.
Yeah, thank you, Chair, for the question. So the obligation on auditors is, as part of their annual statement to us each year, to comment on whether they've been the subject of any disciplinary actions by one of the...
So action, not inquiry?
Action, so it's after the fact.
So is there any reason why ASIC is... unable to be trusted with information about inquiry?
And sorry, I've just received information. It's pending or actual.
Okay, so if it's begun, if there have been any inquiries, they're supposed to let you know.
Well, pending or actual. Separate to that, as part of the information sharing with the professional accounting bodies, as Mr Savundra referred to, we did write to them asking for them to provide to us not just information about a concluded proceeding, but also confidential information that's come to light as part of their undertaking. So even if they haven't yet concluded a particular proceeding, and we've been doing the same as well. So sharing information with the professional accounting bodies, information before we conclude an action, so confidentially in nature. And so the 30 that we referred to and the 25 includes information not just about concluded proceedings, but also confidential information that we have shared with one another.
Okay. And there's no sort of trigger point at which you go, we have enough information, we can share it now? Or like, is it an early warning system where we say we have had, a certain person has come to our attention or a certain company has come to our attention, they're associated with your entity, we're letting you know that they're in our sights? Like, what's the trigger? What's the threshold?
So for us to share information with them, it is an assessment that's made on a case-by-case basis.
Okay.
We need to balance sharing with them against jeopardising our enforcement activities as well.
Okay. All right. So there might be occasions on which it is unwise to do so. I guess the question from the Australian public is, how early do they need to know? And how can they find out? So that's a different question. Are you aware of anybody who's failed to meet that requirement? Any of the company auditors who, are you aware any of them failed to notify?
Do you mean that annual statement that Ms Labouchard? Do you
want to take that one on notice?
Yes, please.
Thank you very much. Yeah. If I can just go to the NAB ANZ Commonwealth
matter, which we had a bit of a discussion before. It's a matter of public knowledge now that there have been referrals of accountants and lawyers to police. Are you aware if any of those identified so far are subject to your oversight?
No, not at this stage, Senator O'Neill.
Okay.
We're very aware of the issues, of course, to which you're referring to, and we are engaging with a range of other entities, as you would expect us to, but certainly those issues are at a relatively early stage of investigation, as I understand it, by both the New South Wales and Victorian Police. So there will be elements of certainly of relevance to ASIC, but it's at an early stage at the moment.
Today we've talked so much about people who are actually within the system, who have been able to hide in dark places. I ask you to take on notice consideration of when people are actually sanctioned and move outside the system, then go on to operate without any registration appropriate to their skill set for malign actors. They've had a role as auditors. I guess the question, who are the frauditors who are overseeing the auditors who are abusing their skills for, corrupt groups, terrorist organisations, money laundering entities, drug and arms businesses that are operating internationally? What and to whom falls the responsibility to locate and sanction them? And where's the list of risky people under surveillance? How does that architecture work is my next question. I don't think we're going to have time to prosecute that today, but can you give it some consideration?
We can, and I have one answer for you, and I'm not sure if it's on the right track, Senator O'Neill, but so as we've talked about, so we deal with the registered company auditors, the professional bodies deal with a range of auditors, but I don't think we should lose sight of the fact that if an accountant is engaged in criminal conduct, then the standard laws apply. We don't have to deal with them under auditing requirements. And indeed, before I came in here, I did ask, out of interest, do we have charges that have been laid against CPAs and accountants? And we do. We have a number of matters. We have a matter just this week or two ago where a certified practising accountant, registered tax practitioner and SMSF auditor has been charged with multiple dishonesty offences in the Brisbane Magistrates Court, as an example, and there are many others. So the fact of being an accountant doesn't mean that the standard criminal laws and all the other laws don't apply to you and doesn't give you a clean bill of health. So those that are involved in financial sector misconduct, whether it be accountancy, auditing or others, it's interesting, they can often get tied up in a number of the other serious misconduct where they're not actually operating potentially as an accountant or an auditor, but they are trusted by people
and skilled and providing their knowledge.
And they know their way around the system. And we have, as I say, I have here a list of 6 recent matters where accountants have been facing charges.
Finally, Shield First Guardian, are there any registered company auditors that you know of who are in your purview with regard to those matters?
We'll have to take that on notice, Senator. Not that I know of the top of my head, but I think it would be prudent to double-check. There's a lot of people, as you know, involved in that range of matters.
And if you could, in your more formalised interactions with the IPA, CPA and CANS, which are now a matter of public record, check with them about any accountants that are still operating within their structures and their systems who might not be fully known to them yet, but are known to you and other players in the space with regard to Shield and First Guardian, lest they continue unobserved.
Okay. We can take that. Thank you, Senator.
There is Another question. One of the significant issues in the finance world at the moment is the apparent growth in fraud of the issuing of loans. There's a report in the media that Austrac has asked 10 of the largest banks in Australia to share loan data to try and get a sense of how big the fraud problem is. Is there anything that ASIC is doing or could do with the banks on this too? And I'm interested to know how the information in the ASIC registry, for example, is accessible and able to be used for that purpose.
I think, Senator, that might be wise to also take on notice the information in relation to ASIC's registries. And as I alluded to in my earlier answer, we're very aware of what Austrac is doing in relation to those matters, and we're liaising with both Austrac and APRA, and we'll keep a close watching eye for what work ASIC, if any, should be doing in relation to as that investigation unfolds.
Yeah, and any information that can be shared to protect the public from any further insult or injury. And I'm advised that as of February 2026, the external examiner still had Mr O'Shea listed, so it didn't happen quite as quickly as we might have hoped. Can I thank you very much for your attendance today? There are a number of questions that you've taken on notice, and we may have a few follow-up ones as well. Can I ask you, if possible, to provide those to the Secretariat by Friday the 10th of April? Can I thank not just yourselves, but all witnesses who appeared today. Thank you also to Hansard Broadcasting and our fabulous Secretariat and my colleagues, Mr Moncrief, Mr Buchholz, Senator Sharma, Senator Paul Scar, Ms Jarrett and Ms Tanya Lawrence for their attendance today. Thank you. Thank you. That concludes the committee hearing. The committee stands adjourned.